I'm sorry? Okay, do we have my list here? I didn't bring the... That's what I'm looking for. Perfect. There we go. Yeah, very good. Sure. Tabling of documents pursuant to subsection 79.22 of the Parliament of Canada Act. It is my duty to present to the House a report from the Parliamentary Budget Officer entitled Fiscal Sustainability 2020. Tabling of documents, the Honourable President of the Treasury Board.
Merci, Monsieur.
Thank you, Mr. Speaker. I'm pleased to announce that I have a message from the Governor-General.
Okay. Son Excellence.
Her Excellency, the Governor-General, transmits to the House of Commons the main estimates for the necessary funds to finance federal public administration for the 2020-2021 fiscal year, and pursuant to Standing Order 54 from 1957, recommends this budget to the House of Commons. Signed by the Governor-General.
Excellency, the Governor-General, Commons the main estimates of sums required to defray expenses of the federal public administration for the fiscal year ending March 31st, 2021, and in accordance with Section 54 of the Constitution Act 18, recommends those estimates to the House of Commons, signed by the Governor-General. L'Honorable.
The Honourable tabling of documents, the Honourable President of the Treasury Board. Mr. Speaker, I have the honour to table in both official languages, pursuant to Standing Order 32.2, the report on federal tax expenditures for 2020.
Introduction of government bills. Oh, excuse. Introduction of government bills. Déclaration de ministre.
Statements by ministers.
Rapport de délégation interparlementaire.
Reports from interparliamentary delegations.
From committees. The Honourable Member for Humber River Black Creek.
Thank you very much, Mr. Speaker, and it's a tremendous honour this morning on behalf of all of the members of the International Trade Committee. We met this morning and we have the honour now to present in both official languages the first report of the Standing Committee on International Trade in relation to Bill C-4, an act to implement the agreement between Canada, the United States of America, and the United Mexican States. The committee has studied the bill and has decided to report the bill back to the House without amendment. It has been an honour for all of us, and I say this on behalf, I believe, of all of us as parliamentarians, to work on a bill that is going to create thousands of jobs and provide lots of opportunity for growth in our country, and to ensure that we continue to work in a very positive way with the United States and Mexico as we move forward. And I want to thank the committee members, all of the staff that worked with us. We had over 102 witnesses. The clerks did a great job. And to our Deputy Prime Minister, Ms. Freeland, of course, who did a tremendous amount of work along with our Prime Minister and all of the other witnesses. So it is a great honour that I present this report to you, Mr. Speaker.
I don't see too many complaints, so we'll let that slide. I just want to remind the honourable members not to refer to each other by their names, but by their riding or their position. It's not a problem. I was looking for a point of order. I didn't see one. I thought I'll bring it up anyways. Introduction of private members' bills. Ms. Sidhu, Brampton South, seconded by Mr. McKinnon. Coquitlam Port Coquitlam moves for leave to introduce bill entitled An Act to Establish a National Framework for Diabetes. This motion is deemed adopted. The honourable member for Brampton South.
Mr. Speaker, I'm honored to rise in the House today to introduce my bill, An Act to Establish a National Framework for Diabetes. Today, 11 million Canadians have diabetes or prediabetes. Brampton has the highest rate of diabetes. In the birthplace of insulin, how can we not take stronger action to improving the lives of nearly 1/3 of Canadians? Presently, 20 Canadians are diagnosed with diabetes every hour of every day. The national framework seeks to improve access to treatment and prevention of diabetes through education consultation with federal and provincial governments, Indigenous groups, through clinical practice guidelines, and most importantly, a united approach to ensure better health outcomes for Canadians. Mr. Speaker, through my bill, I'm confident that one day, soon, we will extinguish that torch outside Banting House. Together, we will find the way to defeat diabetes. I want to thank the member from Coquitlam, Port Coquitlam, for seconding the motion to introduce my bill. I encourage all members in the House to join in supporting to improve the lives of millions of Canadians across Canada. Thank you, Mr. Speaker.
Mrs. Sidhu, Brampton South, seconded by Mr. McKinnon, Coquitlam Port Coquitlam, moves that the bill be now read a first time and be printed. The motion is deemed adopted.
Première lecture de ce projet de loi.
First reading of this bill.
When shall the bill be read a second time? At the next sitting of the House. Private members' bills. The Mr. Soroya, seconded by Mr. Viss, moves that for leaves to introduce a bill entitled An Act to Amend the Criminal Code, Possession of Unlawful Unimported Firearms. This motion is deemed adopted. The honourable member for Markham Unionville.
Thank you, Mr. Speaker. Mr. Speaker, people from across the GTA and in my riding are scared. Every day, the media report new shootings more horrible than the last, and this weekend was no different. In 2018, shootings reached an all-time high. In 2019, the record was broken again. We know that organized crime is behind most of the shootings, and the innocent people are caught up in the violence. According to Toronto Chief of Police, smuggled guns are the weapon of choice for these criminals. When I spoke with the law enforcement, they said they were frustrated. Police pick up dangerous offenders, and they are back on the street the next day on bail. When convicted, serious criminals are getting a slap on the wrist. There are no reason to have smuggled guns. Mr. Speaker, today I am proposing a bill that would have the punishment fit the crime for this dangerous offense. Thank you, Mr. Speaker.
Mr. Soroya, seconded by Mr. Viss, moves that the bill be now read a first time and printed. This motion is deemed adopted.
Première lecture de ce projet de loi.
First reading of this bill.
When shall this bill be read a second time? At the next sitting of the House. And where are we here? First reading of Senate public bills. Motions. The Honourable Opposition House Leader.
Mr. Speaker, I think if you seek it, you may find consent for the following motion, that notwithstanding and the standing orders or usual practices of the House, Bill C-4, an act to implement the agreement between Canada, the United States of America, and the United Mexican States, reported back earlier today, be permitted to be considered by the House tomorrow at report stage. Thank you.
Does the honourable member have the unanimous consent of the House to move the motion? Agreed? Agreed. No? Okay, we don't have unanimous consent. Presenting petitions. Order. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. It's an honor to rise today to present a petition from many Canadians, thousands of Canadians, concerned that after 6 years since the Truth and Reconciliation Commission, we have not fulfilled the 94 calls for action. The petitioners call on the House of Commons to immediately undertake to encourage provinces to reform their jury selection systems and other judicial reforms and enact its own reforms, particularly calling to the calls for action numbers 25 to 42 to ensure justice for Indigenous peoples. Thank you, Mr. Speaker.
Presenting petitions, the honourable member for Sherwood Park, Fort Saskatchewan.
Well, thank you, Mr. Speaker. It's a pleasure for me to table Bill a petition in support of Bill S-204. That is a private member. It's a bill in the Senate that would make it a criminal offense for someone to go abroad to receive an organ for which there hasn't been consent. It seeks to deal with the very serious issue of forced organ harvesting and trafficking. Thank you.
Presenting petitions. Présentation de pétitions.
Presenting petitions.
Nanaimo Ladysmith.
Thank you, Mr. Speaker. It's an honor to put forward this petition today from many of my constituents in Nanaimo Ladysmith. This is a petition that was signed up at the body shop at Woodgrove Mall, and it calls upon the House of Commons to ban the sale or manufacture of animal-tested cosmetics and their ingredients in Canada moving forward. And this is to get us up to the European Union standards. I have a second petition here today. This petition has been signed by residents up and down Vancouver Island, and it calls on the House of Commons to establish a permanent ban on crude oil tankers on the west coast of Canada to protect BC fisheries, tourism, coastal communities, and natural ecosystems forever. Thank you.
Presenting petitions. Présentation de pétitions. Questions on the order paper. The Honourable Parliamentary Secretary to the President of the Queen's Privy Council, I guess. Please,
yes,
go ahead.
Thank you, Mr. Speaker. I would ask that all questions be allowed to stand at this time, please.
Very good. Now, I would like to take a few minutes to inform members of an error on the order paper. Two private members' bills, which are substantially the same, are currently listed under private members' business. Items outside the order precedence, specifically Bill C-221 on the Employment Insurance Act, standing in the name of the member for Elmwood Transcona, was introduced in red a first time on Thursday, February 20th, 2020. And Bill C-217, standing in the name of the member for Salaberry-sur-Roi, was introduced and read a first time on Monday, February 24th, 2020. Conformément.
Pursuant to Standing Order 86-4, the Speaker can refuse notice if he determines that two items are so similar as to be substantially the same. In this case, only the first bill should have been placed on the notice paper. As a result, Bill C-217 is currently before the House in error. I therefore direct that the order for second reading of Bill C-217 be discharged and the bill dropped from the order paper. I apologize for any inconvenience this may have caused members. I thank all honourable members for their attention.
I'm also ready to rule on question of privilege raised on February 18th, 2020 by the member for Timmins James Bay concerning the government's response to written question Q163. In his intervention, the member alleged that the Minister of Justice and Attorney General of Canada deliberately misled the House in a response to written question about the cost incurred in legal proceedings related to Canadian Human Rights Tribunal cases. In short, the member argued that there is a discrepancy between the costs specified in the government's response and the amount provided to members of the public who obtain the information through access to information request. In his opinion, The government is in contempt of the House for having deliberately misled it by providing incomplete or inaccurate information in its answer to written question Q163. In response, the Parliamentary Secretary to the Government House Leader asserted that the government uses a consistent formula for calculating litigation costs when responding to written questions. While the methodology used for this compilation of the amounts obtained by other people is unknown, he added that this discrepancy in the information by no means suggests that the calculation by the government were done in bad faith or to deliberately mislead the House, and that this matter should not be considered a legitimate question of privilege, since it consisted more in a debate as to the facts. In other words, his view is that the members disagree on how the final number was arrived at, but that such disagreements are not unusual in debating an issue from different perspectives. I thank the members for their intervention. Essentially, the member for Timmins James Bay contends that the response was deliberately misleading because, as he mentioned in his remarks, it does not align with the information obtained by an academic and a journalist through other means, while the Parliamentary Secretary suggests that the methodologies employed by other sources may have differed to the one employed by the government. En fin de compte, il semble...
Ultimately, this seems to be a dispute as to the facts, which, as Speaker, it is not my role to assess. Our precedents on this subject are clear, and, as stated in House of Commons Procedure and Practice, 3rd edition, at page 529, and I quote, "There are no provisions in the rules for the Speaker to review government responses to questions." End of quote.
In the case before us, contrary to the precedents cited by the member for Timmins James Bay, we do not have a situation where the same individual has presented two different sets of facts to the House, nor is there any evidence to suggest that there was an attempt to deliberately mislead the House. For these reasons, the Chair cannot find that there is a prima facie question of privilege in this case. It may be that the member for Timmins James Bay is not satisfied with the response he received. There is, however, an array of options available for him to pursue this issue, whether it be resubmitting a written question worded differently or by asking questions to the minister directly during oral questions or a committee meeting. The Parliamentary Secretary, in his intervention on February 25, 2020, also suggested that members could approach a minister or a parliamentary secretary directly to seek clarifications when they feel that the information is incomplete or appears to be inconsistent with other sources of information. He contended that more often than not, these inconsistencies may simply be a mistake, an omission, or a misunderstanding instead of a deliberate attempt to mislead the House. La présidence doit toutefois avouer.
The Chair must admit that perhaps better communication between members who seek the information and the government who provides that information could be a solution to improve how the information is shared in this process without escalating any dissatisfaction to a question of privilege. However, the Chair wants to reassure the House that whenever members feel that their privileges have been breached, it is their right to bring the matter to the attention of the Speaker in this way.
Conclusion: as speakers before me, I've expressed several times that I would like to reiterate the importance of the accuracy of information from the government on which the members rely to perform their parliamentary duties. I thank all members for their attentions. Orders of the day.
Government orders, government bills. Resuming debate at second reading of Bill C7, an act to amend the Criminal Code, medical assistance and dying.
Resuming debate, the honourable member for Sherwood Park, Fort Saskatchewan, has 13 minutes and 30 seconds remaining in his time.
Thank you, Mr. Speaker. We're debating a bill today which strips away safeguards from the existing regime for euthanasia and assisted suicide. Debate started yesterday, and I want to continue in the line that I was talking about yesterday. I spoke about some of the philosophical problems underlining the government's desire to remove safeguards. But those philosophical ideas are clearly best understood in the realities of life under legal euthanasia and assisted suicide, in the experience of people and families who have been affected by it, and in the concerns of people who will be further impacted by the proposed expansion of the practice and removal of safeguards. Now, the fact is that the expectation at the time of the Carter decision was for a legal regime that would apply narrowly, and yet we have seen the alarmingly rapid process of expansion at the level of policy and practice continuing with this legislation. Given that this bill comes ahead of a scheduled statutory review, it looks like the pace of expansion, of removal of safeguards and enlarging eligibility will continue apace even after this. Rates of identified euthanasia and assisted suicide have gone up dramatically every year since legalization, from about 1,000 in 2016 to over 5 times that in 2019. Those rate increases show no sign of abating. And more horror stories are coming out about how the current regime has already changed the dynamics of our healthcare system. Mr. Speaker, my grandmother was a Holocaust survivor, so I know about the long-standing traumatic effects that stay with many survivors the rest of their lives. One instance of euthanasia at the Louis Breyer Nursing Home in Vancouver, a Jewish facility which has Holocaust survivors among their clientele, was particularly traumatic for residents and staff. Dr. Ellen Wiebe met with Barry Hyman and his family in the spring of 2018 and determined that he met all the criteria. She later went to the nursing home and closed the door without informing or consulting with nursing home staff. Hyman was killed by Dr. Wiebe in the evening of June 29th, without any consultation with his primary caregivers at the nursing home. Perhaps Dr. Wiebe had good intentions, but someone sneaking into a nursing home and then asking us to trust their own notes as evidence of consent, this raises serious concerns. Dr. Kesselman, CEO of the Louis Breyer Nursing Home, agrees. Imagine the implications for our staff and our residents and their families, he said. We have a lot of Holocaust survivors. To have a doctor sneak in and kill someone without telling anyone, they're going to feel like they're at risk when you learn someone was sneaking in and killing someone. Now, clearly, Dr. Wiebe in this case was pushing the envelope. I doubt most doctors would behave in such a fashion. But we do see from analyses that have taken place in other countries that a small number of activist pro-euthanasia physicians are overrepresented in cases with problems. A majority of doctors are trying to do the right thing, but a lot of death can flow from the choice of a small number of envelope pushers. In a paper studying cases of euthanasia in Holland between 2012 and 2016, bioethicists David Miller and Scott Kim from the National Institute of Health in the U.S. noted significant problems in the application of these laws for vulnerable people if the screws aren't tightened properly. During that period, Miller and Kim found 33 cases in which doctors had broken at least one rule while killing someone, though apparently none of these justified prosecution. Miller and Kim specifically identified the overrepresentation of certain activist doctors in cases which raised red flags. Now, I spoke in this House in 2016 about another case in Canada, where a physician declared a depressed person eligible for euthanasia even before examining that person because the patient, quote, could easily get bed sores and then die of infection. A person's death was, prior to examination, declared reasonably foreseeable because the person could theoretically die from an as-yet uncontracted bed sore infection. It is striking that we have these cases to look at all in Canada, given the massive data collection gaps. There is no requirement for advanced legal review to determine if criteria are being met. There are no national standards on tracking data. In fact, in many cases, when a patient dies as a result of euthanasia, their death certificate will not even indicate that as the cause of death. People who have had bad experiences cannot tell their stories in most cases. The data that the government refers to is severely constrained by these realities. We tried during debate on the last euthanasia bill to push for mechanisms for better data collection and reporting to ensure evaluation and protection was possible. But at the time, unfortunately, the government didn't listen. Now, those who have had negative experience and have lived are understandably reluctant to speak out, but I do want to share one story with permission of someone close to me who had a negative interaction with the system after this regime began. So this is Taylor's story. Taylor Hyatt is a 20-something former member of my staff. She has cerebral palsy. She is vibrant, accomplished, and full of life. She went to the hospital a couple years ago with cold symptoms. She was told that she would probably need some oxygen, and she was asked if she wanted that. She replied, yes, of course. But then the doctors pressed her on the point. Are you sure? Are you sure? Taylor was asked, are you sure if she wanted oxygen? She just had pneumonia. When we look at the government's proposal to further expand euthanasia and assisted suicide, expand eligibility criteria, and remove the small number of safeguards that exist, then we need to ask the same question. Are you sure? As these cases illustrate, we have particular reason to be concerned about cases in which people receive euthanasia or assisted suicide immediately or alone. If multiple family members and healthcare staff can see over a period of time that a person is clear in their desire to have their life ended, then there is less risk of vulnerability or abuse. Imagine a case, though, in which you visit your mother at hospital on a Monday, and you thought, seems like she's having a good day. She makes no mention of wanting to die. She's experiencing some pain, but the nurse says she has promising ideas about how to manage that pain. The nurse tells you, I think we need to adjust the levels of a few things, and that should settle the pain down. We'll work on that as soon as the doctor has a chance to see her. And on Monday, you leave feeling reassured. Then you are informed on Wednesday that your mother is dead. You are told that she met with the doctor, was in extreme pain, and expressed a desire to die, so she was killed right away. You didn't get a chance to say goodbye. You don't know if the doctor got it right or wrong. Maybe your mother really wanted to die, but maybe she was just experiencing a temporary low point from which she would have recovered. You will never know the details or the situation because of the absence of witnesses and of legal review. That means there's very little evidence left behind. If your mother really wanted to die, she could, but would it be so unreasonable for the doctor to have given it a few days, for you to have been able to talk to her about her wishes? This particular case is exactly where we should focus our concerns as we look at this legislation. The current legal system requires at least 2 independent witnesses who are not paid personnel, and there is a 10-day reflection period. Now, I would underline, as members have said and as the government has generally failed to acknowledge, that there is already a mechanism by which this 10-day reflection period can be waived. But this mechanism, this 10-day period, sets out a rule of general practice that is open to variation, and it establishes the general and important principle that a person should not have their life taken as a result of a fleeting sense of hopelessness or because their medication levels are off for a period. It makes no sense, as the government is proposing to do, to reduce the number of witnesses and remove the reflection period when there are already provisions for waiving it, for managing that effectively in different kinds of situations. Other members may have had these same experiences. I can tell you I had a close friend dealing with depression a few years ago, and his state of mind would fluctuate dramatically from day to day. On certain days, he couldn't imagine going on. On other days, he would feel, in his words, like himself again. Recognizing these realities of fluctuations and development in people's experience, it is horrifying to me that someone could opt for and receive euthanasia or assisted suicide within a few hours without independent witnesses or any reflection period. So the government must remove the sections of this bill which reduce witnesses and eliminate that reflection period. Now, the government has included a section in this bill dealing with so-called advance consent. The mechanism is that I, as a patient meeting the criteria, might ask to die on June 1st, even if I had lost capacity. My consent right now would suffice for the taking of my life on June the 1st. However, the legislation contains no requirement that I be asked how I feel on June the 1st. Suppose that I am facing a loss of capacity and I am afraid of the implications of that loss of capacity, not knowing what it would be like to mentally regress in the way that doctors have predicted that I will. Suppose that in light of this fear, I sign on to advance consent. But then on June the 1st, while I have indeed lost substantial capacity, I actually have a much higher quality of life than I expected to have. Should the advance consent that I have provided, in ignorance of my future circumstances, overrule my feelings in that moment? Now, this isn't just idle speculation. Let me read from an article in the Washington Post about a Dutch case involving an advance directive. Quote, the patient, referred to in official documents only as 2016-85, had made an advance directive requesting euthanasia in case of dementia. But the directive was ambiguously worded and she was no longer able to clarify her wishes by the time she was placed in a nursing home, though her husband did request euthanasia for her. Despite the lack of a clear expression from the patient, a physician concluded her suffering was unbearable and incurable, though there was no terminal physical illness, and prepared a lethal injection. To ensure the patient's compliance, the doctor gave her coffee spiked with a sedative, and when the woman still recoiled from the needle, asked family members to hold her down. After 15 minutes were spent by the doctor trying to find a vein, the lethal injection flowed. Now, the government has tried in this legislation to avoid this most extreme case by saying that advance consent only applies to a particular date and that the procedure should not proceed if the patient is clearly refusing euthanasia. But unfortunately, the space for abuse is still massive. In the case just given, suppose that the patient was given stronger sedatives so that they were completely unaware of what was happening and therefore offered no resistance. That would be allowed under the framework established by this legislation because it does not require that patients be informed or consulted at the time of their death. If they have provided advance consent, that is considered sufficient. In virtually every case, the requirement for contemporaneous consent is important in our law and is a necessary part of autonomy. If I am to be truly free, then I must be free from the directives of my past self. My past self should not irrevocably be able to bind my future actions. But even so, it may be possible, still allowing advance consent, but to have some mechanism through an amendment to ensure that a patient, even with limited capacity, is informed and consulted at the time where their life is taken. And I would encourage the government to consider that. The government should be open to considering these problems and these fixes, taking out sections of the bill which dangerously remove safeguards and strengthen the section on advance consent to ensure that a patient is informed and consulted contemporaneously. Now, finally, on the point of safeguards, let's go back and reflect on what the purposes of safeguards are. Now, some members will feel that meaningful safeguards are not necessary because they will say we should trust medical professionals and patients to get it right. The Parliamentary Secretary has used general data about trends in this area to suggest that there aren't problems with abuse. But let's be very clear that the reason we have safeguards is not to deal with the general case, but it is precisely to deal with the exceptional cases. Even if there are not problems in the vast majority of cases, we try to introduce reasonable verification mechanisms because those verification mechanisms will catch instances of abuse and cases where vulnerable people might be pushed towards a death they do not want. The reason we need law enforcement is not because most people are lawbreakers, but because some people are lawbreakers. The reason that we have fire departments and expansive rules and protocols around fire prevention is not because most houses are on fire, but it's because some houses could get on fire. I hope that we will see through this debate that the safeguards in the current legal regime really are a minimum, and that we can provide reasonable safeguards like a short, waivable reflection period and a requirement for independent witnesses, which, like sprinkler systems in this room and security guards watching over us, insulate us against the possibility of something going very, very wrong. For the sake of the vulnerable, let's not fire the security and rip the sprinklers out of our system just to make an ideological point. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
So I thank the member opposite for his contributions to this debate, and I want to point out 4 matters and lower the tone a little bit because I think we need to be talking about facts as opposed to emotional arguments. The first point in terms of clarification, there are 4, is that depressed individuals are not subject to this regime. We've included specifically a carve-out for mental illness as a sole condition. So clarification number 1. Second point is that the data collection that the member seeks is being beefed up by this very bill. So point well taken, point being responded to. The third point is that hyperbole has entered into this debate about people being, quote, killed right away. The notion of having a written consent witnessed by an independent witness and then the eligibility being verified by 2 independent practitioners and that occurring in a matter of minutes or a matter of hours is categorically false. That is not the way the system currently operates. And the fourth point is that it is an absolute red herring to raise a case based in Holland where you have advanced directives for ailments such as dementia. we don't have dementia within the penumbra of ailments that can be subject to this regime. And secondly, we are not proposing advanced directives, we're proposing advanced consent. Now let me ask the member a question. He's raised, in some instances, concerns about what he perceives to be patients that are suffering or doctors that are acting aggressively. What I would say to him is that those are important cases. And if he has cases, have those cases been brought to the attention of either disciplinary bodies that regulate physicians or to law enforcement, because those should be enforced. In fact, what we have is evidence to the contrary, that doctors are not practicing this overly aggressively. In fact, there's a small pool of doctors. That's the point that was made.
The honourable member for Sherwood Park, Port Saskatchewan.
Thank you, Mr. Speaker. You know, the members should know that the last piece of legislation included a good faith exception, that a doctor who didn't follow all of the rules but still acted in quote-unquote good faith would escape prosecution. So there have been cases where these are referred to disciplinary bodies, but a limited capacity to actually prosecute people who are in the case described going into a nursing home, taking someone's life without any consultation with the surrounding staff. These are cases that raise significant concern. The member says we should lower the tone and avoid hyperbole, and then criticizes me for bringing up specific cases in Canada and in other countries which have similar legal regimes. And the government should look at these cases and consider them before moving forward. It is right to bring up the Dutch case, and I acknowledge the differences in the proposed regime here in Canada from the Dutch regime. But I pointed out very specifically that there is no requirement in the existing legislation for the person to be asked in the moment. I would beg the government, introduce that additional requirement for some contemporaneous consultation with the patients. What, after all, do they have to lose? And there very much is the possibility of someone being killed right away under this legislation. And if the parliamentary secretary is so opposed to that characterization of the legislation, then why not leave in some waiting period? If he says, because of all the administrative requirements, inevitably there will be some delay, then leave the waiting period, the consideration period.
Order. Order. Questions and comments. Questions and commentaires. L'honorable député de...
The honourable member for Thérèse de Blainville. Thank you, Mr. Speaker. I listened to what the member had to say, and it raises some questions. Well, I have some questions for him. I get the feeling that what he was saying was not related to the bill before us. I'm a nurse in a former profession, former life. I'd like to hear things that we can relate to more. And he gives the impression that healthcare workers are perhaps less well-intentioned than they actually are. I'd like to tell you what I've heard from doctors and nurses, and what I heard in that speech was pretty esoteric. I hope that you were on the front lines to criticize this. This bill has been improved upon by two people, two individuals who went to court to challenge this bill to expand the access for people who... am I out of time? I'm sorry, Mr. Speaker.
Park, Port Saskatchewan.
Well, thank you, Mr. Speaker. Simply put, I think the record will show that the member's characterization of my remarks is not at all accurate. But let me just re-emphasize a point that I made, which is that the very purpose of safeguards are to deal with the exceptional case. I agree that the vast majority of healthcare practitioners are not only well-intentioned, but also are not trying to push the envelope in any way. But the data suggests, the data that I cited suggests that in other jurisdictions we've seen how a relatively large number of problematic cases can emerge from the actions of perhaps also well-intentioned but definitely envelope-pushing physicians who are going beyond the intention of the legislature in terms of the structure of this bill. Now, the parliamentary secretary had some points that I wanted to get back to very quickly. It's true that this legislation excludes depression as a sole condition, but it does not exclude people who are suffering from depression from accessing it. And in a previous parliament, the member for St. Albert Edmonton had tried to introduce an amendment whereby if someone was suffering from depression as well as other conditions, they would at least be a psychiatric assessment.
Order. Sorry, I do prefer not to have to interrupt honourable members when they're in the midst of their speech, but there are many members that are wishing to participate in this time for questions and comments. I'm stopping the clock here right now, so we're not going to take any more time away from you. Some things that would help if members would sort of direct their attentions to the chair in the midst of questions and comments. It gives me a chance to signal kind of where we are in terms of timing. And we will generally gauge the time for, although there's nothing codified in terms of the limit for the time that you should take to pose your question or respond, that we'll usually gauge by the number of people who are rising. So if you kind of see that there's a lot of people standing up in questions and comments, you would sort of keep your comments a little more short, and we'll do our best to regulate that so that we can get more members participating. And just a final reminder that questions and comments are for that purpose. I appreciate that members are trying to also get time in debate, and we'll try to honor that as best we can, but it is not a time for speeches. It's more for posing a question or a reflection on what the member has just said in his or her speech. Questions and comments. The honourable member for South Okanagan, West Kootenay.
Thank you, Mr. Speaker, and I'd like to thank my colleague for his speech. And I think I need some clarification. He's finished off his speech with talking about final consent. The way the bill stands now, the bill that's in force now requires final consent at the time that people are assessed beforehand, and then have to give final consent when that order is proceeded with. And this has forced patients to make cruel choices. One cruel choice, and that is, once you are assessed as being eligible for medical assistance in dying, you have to decide, should I do this now while I have that competence and can make an answer, or do I set a date in the future to allow myself and my family to do all the things that you want to do, and then risk the chance that you are not competent, that you cannot answer, and the procedure would not go ahead. And I have had a friend having to make that cruel decision. And so I'm just wondering if you could clarify his statement about, let's fix advance consent by requiring advance consent.
Member for Sherwood Park, Port Saskatchewan.
Thank you, Mr. Speaker. I thank the member for his question. I have 2 points. First of all, I think it's important to say in general in the context of advanced consent that a person does not know precisely what their experience will be. You may get a prognosis. You may think, I'm going to feel a certain way about things at that point in time. But I think it's important to underline that the reason we generally don't have advanced consent is because people don't always know what their experience of that thing is going to be. Nonetheless, I want to be very clear. What I would propose as a middle way between having no advanced consent and the advanced consent regime proposed in this legislation is to allow somebody to give advanced consent, but to still require, even at the point at which they may have lost capacity, some contemporaneous consultation with the person, so that they, even at a point of reduced capacity, they be told what's going on and they be given the opportunity to, generally speaking, assent or not. Even at the point at which they have lost capacity, it's still fair to them to give them some information about what's happening and be able to express their objection if they're able to in the context of limited capacity.
Questions and comments. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. To my friend from Sherwood Park, Fort Saskatchewan, it would appear to me that the very concept of medical assistance in dying is the concept to which he objects, and certainly the courts have ruled that it's a violation of our charter rights as Canadians not to have access to medical assistance in dying. I know it's a very difficult topic and fraught, but I would ask the member quite directly, not to a hypothetical, but would he not agree that Audrey Parker of Nova Scotia, who knew she was terminally ill and who chose to end her life earlier because she was denied an advance directive, does the member not agree that these sets of amendments to the criminal code are fair and within the context of what the courts are directing us to do?
Well, member for Sherwood Park, Port Saskatchewan.
Well, thank you very much, Mr. Speaker. I know there have been various court decisions dealing with this broader topic, but I'm not aware of court decisions dealing specifically with the issue of advance consent. Clearly, the case of Ms. Audrey Parker should evoke a thoughtful response from us. I'm not aware of all the medical details of the case, and I think many people have opinions about the case who also may not be aware of all the details or the context or the information she received. So I just don't feel comfortable giving an answer in the House of Commons about what should or should not happen in a particular individual's case. I think we can, as members of Parliament, try to work together to find consensus, to have our cake and eat it too, to use the expression. We can have, if it's the will of the majority, some mechanism of advance consent, but still require contemporaneous consent at the point at which somebody's life is taken. And I think that's very important, because we would not want a situation where somebody has their life taken while they are unaware it's being taken or don't want that to happen. I will just tease the member a little bit by pointing out that there was a Court of Appeal decision in Alberta opposing the carbon tax, and I hope she would share my enthusiasm for court decisions in that case as well. Some dialogue with the courts is maybe reasonable.
Resuming debate, the Honourable Minister of Health.
Mr. Speaker, and I'm very pleased to rise in the House today to address C7 and speak to our proposed changes to Canada's medical assistance in dying legislation.
The proposed measures are, as you know, in response to the Truchon decision by the Quebec Superior Court, which held that it was unconstitutional to deny access to medical assistance in dying to people who meet all the other eligibility criteria, but who were not near the end of their lives.
To this ruling, the Government of Canada has had the opportunity to consider some additional measures for where there is strong support. That is why we are proposing changes that will help clarify and add precision to Canada's medical assistance in dying legislation. Over the past few months, I've had the honour of listening to many Canadians, and it was important for me as Minister of Health to hear firsthand what they had to say. My colleagues and I hosted a series of roundtables and heard from more than 125 experts, academics, ethicists, doctors, nurse practitioners, members of the disability community, Indigenous groups, and key stakeholders. I also engaged my provincial and territorial colleagues, and my officials worked closely with their counterparts across the country. In January, I was in Calgary, and I spoke to Cynthia Clark, who saw her husband through the process of medically assisted death last summer. Her perspectives, as well as those of so many others with first-hand experience, were invaluable. I also listened to practitioners who have been providing medical assistance in death in a very thoughtful, compassionate way over the last 4 years, and they had a lot to say about what was working well, but also what was not working well. We heard many personal stories, like Cynthia's, that helped shape the changes that we are proposing today. In addition, the feedback received from our online consultation was astounding. In 2 weeks, we had more than 300,000 responses. Est-il clair?
And it is clear that a number of changes could be made to improve access, respect choices, and protect vulnerable people. I believe that with this bill, we have struck a balanced approach that better reflects the best interests of all Canadians.
Mr. Speaker, protecting the safety of vulnerable people while respecting the autonomy of Canadians remains our central objective. And that is why the bill proposes a two-track approach to safeguards, based on whether or not a person's death is reasonably foreseeable. Reasonable foreseeability of natural death would no longer be a requirement for determining whether a person can access medical assistance in dying. It would, however, be used to guide practitioners in determining which safeguards to apply. And this is consistent with what we heard at the roundtable meetings. Providers involved in assessing the eligibility of applicants for a medically assisted death told us they have a good understanding of the concept and are comfortable applying it. Under the amended law, they would use reasonable foreseeability of natural death to determine not eligibility, but rather which safeguards would apply. For those whose death is reasonably foreseeable, we would ease some of the pre-existing safeguards. Under the current system, there is a requirement for a 10-day reflection period. We are proposing to eliminate this reflection period. For those who are at the end of their life, the decision to request medical assistance in dying is well considered, and this additional period only serves to prolong suffering unnecessarily. The current system also requires that 2 independent witnesses confirm that the person who has signed a request for medical assistance in dying is who they claim to be, and that no fraud has occurred, such as someone forging a signature. During our consultations, we heard that this requirement was a significant barrier for many people at the end of their life. we propose requiring only one witness and allowing this witness to be a paid personal or health care provider. These individuals naturally would be excluded from acting as a witness if they are a beneficiary of the person's will or if they would receive a financial or material benefit from the person's death. Anyone involved in assessing or providing medical assistance in dying would continue to be ineligible to serve as a witness. And for those whose death is not reasonably foreseeable, we would create a new, more robust set of safeguards. We think it is important, even while improving access, to ensure that people who are suffering but who are not dying are given full and careful consideration as they assess whether or not to pursue an assisted death. Strengthened safeguards would also serve to protect vulnerable individuals. For example, the bill proposes a minimum period of 90 days for assessing a MAID request in the case of a non-imminent death. This period would allow for exploration, discussion, and consideration of options to alleviate suffering by the person seeking medical assistance in dying and with the practitioner. The bill would also require that the person requesting MAID be provided with information on available counseling, mental health supports, disability supports, and palliative care as part of the informed consent process. We know that the majority of practitioners are already ensuring that their patients are aware of all of the supports and options that are available to them. This provision underscores the importance of the doctor-patient relationship. It allows for a practitioner and a patient to decide whether medical assistance in dying is the right step and provides sufficient time for the patient to discuss and consider other treatment options, crucial for patients who are weighing this kind of decision. This, Mr. Speaker, supports fully informed decision-making and individual autonomy. Mr. Speaker, under the current legislation, those who become incapacitated lose their eligibility for medical assistance in dying because a person must give their consent immediately before the procedure. This means that some individuals deemed eligible for medical assistance in dying have chosen to end their lives earlier than they wanted out of fear of losing the opportunity to receive the service. That is why we're proposing to include a waiver of final consent for persons whose death is reasonably foreseeable and who have been assessed and approved to receive medical assistance in dying. Individuals at the end of their life who risk losing their decision-making capacity before their chosen date would have an avenue to receive MAID without worrying that loss of their decision-making capacity before their chosen date would disqualify them. Support for this amendment is strong amongst stakeholders, Canadians, and health practitioners. Canada has had 4 years to reflect on the current MAID legislation passed in June 2016, and there are many complex issues that require further study. In December of 2016, the Government of Canada asked the Council of Canadian Academies to conduct independent review on 3 specific types of requests for medical assistance in dying that are currently outside of the scope of the law: requests by mature minors, advance requests, and requests where a mental disorder is the sole underlying medical condition. The Council of Canadian Academies convened a multidisciplinary panel of 43 experts to review an extensive body of evidence, including Canadian and international academic and policy research.
We tabled those reports in Parliament in December of 2018. They provide a comprehensive and well-thought-out review of these very difficult topics. Mr. Speaker, I would encourage all members to read those reports as we pursue our discussions on the proposed changes to the Act and the parliamentary review, which will be launched later this year.
There is agreement amongst experts that allowing advance requests for people with illness, such as Alzheimer's disease, well before they would otherwise be deemed eligible is very complex and will require careful consideration and consultation before it could be included in legislation. During the roundtables, I heard directly from healthcare providers who expressed discomfort because they have seen patients who, as their condition progresses, might not have the same desire for medical assistance in dying as when they were first diagnosed. The Council of Canadian Academies expert panel report on advance requests came to the same conclusion. At the same time, we know that many Canadians have expressed an interest in advance requests so that they could have the comfort of knowing that they could avoid extreme suffering at some future date. For all these reasons, we believe this issue is deserving of deeper examination through the parliamentary review. That will be our opportunity to tackle questions that are profound and difficult to answer, even for practitioners who have been providing this service over the past 4 years. Mr. Speaker, the proposed changes to the medical assistance in dying legislation would exclude persons if mental illness is their sole underlying medical condition.
That does not mean that people with mental illness would not be eligible. It means that mental illness cannot be their sole underlying medical condition. This is another complex area that warrants further discussion.
Federal legislation came into force in 2016. Health Canada has released 4 federal interim reports that provide more information on how the legislation is being implemented across the country. In November 2018, we implemented regulations that resulted in the creation of a permanent monitoring regime, which sets out obligations for reporting on medical assistance in dying cases by doctors, nurse practitioners, and pharmacists. The first monitoring report under these regulations is expected to be released in spring of 2020. Since MAID legislation was enacted in 2016, more than 13,000 Canadians have chosen this option of a medically assisted death. This is not unexpected. We have seen a gradual increase over the numbers over the last 3 years. The number of medical assistance deaths in Canada, slightly under 2% of all deaths, is in line with international regimes. Increasing use of MAID is largely because of enhanced awareness of it as a legal option and greater acceptance by Canadians. The federal government recognizes that public reporting is critical to ensuring transparency and public trust in the legislation. And that is why we're also proposing changes to expand data collection to help provide a more complete picture of medical assistance in dying in Canada. Under the current legislation, only practitioners who receive a written request for MAID and pharmacists who dispense a MAID substance are required to provide information. But it has become clear that capturing information based solely on written requests for MAID received by physicians and nurse practitioners has resulted in an incomplete picture on who's requesting MAID across the country and why. The amended legislation would authorize new regulations to be developed in partnership with provinces and territories to allow for the collection of data on all assessments for MAID. And this would include those undertaken by other health professionals in the care team. It also clearly aligns with the original intent of the legislation to collect information on all requests and cases of MAID in Canada. Mr. Speaker, I think we can agree that Canadians with life-limiting illnesses deserve the best quality of life possible as they approach the end of their lives. Palliative and end-of-life care provides patients with relief from pain and distress associated with the challenges of living with a life-threatening illness. Supporting home care and palliative care is a key priority in our ongoing efforts to improve our healthcare system. Through Budget 2017, we made historic new investments in healthcare to improve access to mental health and addiction services, as well as home and community care, which included palliative care. And to further support access to palliative care across the country, the government worked closely with provinces and territories and stakeholders to develop the framework on palliative care in Canada, which we tabled in Parliament in 2018. And we have released an action plan to support each of the priority areas identified in the framework. Mr. Speaker, I want to assure you that the proposed bill responds to concerns identified by practitioners and experts through the roundtable discussions.
I will continue to work in close cooperation with provinces and territories, as well as with key partners, to support the implementation of the amendments proposed to this legislation if they are adopted by Parliament.
Working with provinces and territories, health system partners, and regulatory bodies to support best practices and information sharing on clinical guidance and other aspects of implementation, which includes training and retrospective reviews. I have a great deal of respect for the practitioners who've been providing this service over the last 4 years with immense diligence and a huge amount of compassion. Their experiences have helped us craft legislation that much better meets the needs of Canadians. This law is constructed in a way that supports autonomy, but with flexibility that allows for a practitioner and a patient to work more closely together. Medical assistance in dying is a complex and deeply personal issue. In tabling these changes, our government has considered carefully the need for personal autonomy and the protection of vulnerable peoples. There is strong public support for change, and Mr. Speaker, I believe that we have found an approach that reflects the best interest of all Canadians. I urge all members of this House to support the proposed changes. Thank you.
Questions and comments? Question commentaire. The honourable member for Cloverdale, Langley City.
Canadians who are deciding whether they wish to receive medical assistance in dying are often experiencing prolonged suffering. The problem is prolonged suffering is due to lack of palliative care. We were promised $3 billion to go to palliative care. Our dear member, Mark Warawa, spent 9 days in hospital before he even saw a palliative care doctor. I'm wondering how in God's green earth we think that this is the better way by loosening these guidelines to ensure the best quality of life for Canadians.
Minister of Health.
Well, thank you, Mr. Speaker. And as the member opposite knows, we've made historic investments through provinces and territories to improve a range of healthcare services, including palliative care. As I mentioned in my speech, it's been an honor to be part of a government that understands that having a strong framework, actions that we can agree to take together to improve palliative care at the end of life is clearly very important to all of us, as especially we have an aging population that will require more and more of those services. But it is also equally important to recognize that Canadians have very loudly said, and courts have agreed, that they deserve to have autonomy at the end of their lives, and that includes choice to use medical assistance in dying. Thank you.
Questions and comments. The honourable member for Montcalm. Thank you, Mr. Speaker. One comment first. With respect to palliative care, it's really important, but I would remind people that the Conservatives were the first ones to approve health transfers, and if there had been enough transfers at 25 cents to the dollar, there would have been enough palliative care. So with respect to the Baudouin ruling and the condition of the state of health of Mr. Truchon, well, these people were entirely excluded from having a choice. When we talk about free choice, you have to have options. How come the minister, if she says that there are practitioners who are able to see that there are people who have Alzheimer's who are in first favor of MAID, and then they're able to see that they may have changed their minds. If they're able to see that they changed their minds, how come they're not eligible like Ms. Truchon or Gladue would have been? The Honourable Minister of Health. I'd like to thank my colleague for his question.
I agree with him that it takes a long time to recover from a decade of a lack of investment in healthcare across this country under the former Conservative government. So we are doing our best, Mr. Speaker, to make up for lost time. I will say that in the case of conditions such as Alzheimer's, where people anticipate how they might feel if they have a condition, it is much harder to do those assessments. We heard this actually from practitioners who work very closely with patients in all kinds of different situations, and who said that when a person anticipates how they might feel when they are suffering from a particular condition, it can often be dramatically wrong. When a person actually arrives there, they do not have the same kinds of feelings that they might think they have when they, for example, have a traumatic injury. And so for this case, Mr. Speaker, we believe that advance requests require further study so that we understand the implications from a patient perspective and a practitioner perspective.
Questions and comments? The Honourable Member for Timmins, James Bay.
Speaker, I'd like to thank the Honourable Minister for her work on the corona virus crisis. She's been very clear on a number of issues. I am concerned when I hear this debate, though, because our Parliament voted when I was working on the palliative care motion, and we had everyone support the issue of palliative care. And I met with groups across this country about end of life. And what we heard again and again and again about dignity in dying and the rights of people was that they needed those rights to access palliative care. That was what we heard in every group that I ever met with. And yet the only movement that we've seen from the government, it was mandated by the Supreme Court. I understand that. I understand we had to put this legislation in place. But I'm concerned that the Parliament of Canada voted on a national palliative care strategy to work with the provinces and the territories to put in place the opportunity so that people could truly die with dignity with their families in a much more healing and holistic manner. And yet we've seen a lot of talk about that, but only as an addendum to this conversation about assisted dying, but we've seen no resources or commitment on palliative care.
Minister of Health.
Well, thank you, Mr. Speaker. And I will remind the member that through Budget 2017, in fact, Canada made historic new investments in healthcare, which included $11 billion over 10 years to improve access to mental health and addiction services, as well as home and community care, including palliative care. And in August of 2019, Health Canada released an action plan that defines federal activities and the next steps linked to the framework on palliative care in Canada. There are a number of actions that we need to take collaboratively with provinces and territories. We'll continue to work with everybody, including the provinces and territories, to ensure that we can improve the quality and availability of palliative care for all Canadians. Thank you.
Questions and comments. Kese Kamanta, the honourable member for Dufferin-Caledon.
The Minister for her speech. She mentioned that there are safeguards in place for people that suffer from only mental health issues or the mentally ill. What are those specific protections that are put in place? Because from my review, there's no requirement for an assessment by a psychiatrist for someone who might be experiencing something such as severe depression.
Minister.
Thank you, Mr. Speaker. The proposed legislation excludes people whose sole condition is an underlying mental illness, and that is because we still don't know enough about how the desire to receive the service of medical assistance in dying might interact with a particular mental illness. I will say that this in no way negates the suffering that people who are struggling with mental illness feel. I personally have worked with people who have severe mental illness and fully understand that that suffering can be very immense. But we also know that as part of the expression of a variety of different mental illnesses, the desire to end one's life is one of those components. And for that reason, we believe this is deserving of extra review through the parliamentary reviews scheduled in June. Thank you.
Questions and comments. Honourable member for Saanich Gulf Islands.
Mr. Speaker, and I thank the Honourable Minister. This is a topic that's come up quite often in the round of questions to the Honourable Minister. But I do note that the legislation before us includes, where appropriate, ensuring that the patient has been informed of other means of alleviating suffering, including mental health services, counselling services, palliative care. And I wish to ask the Minister again for some real specifics. We clearly are nowhere near having adequacy in any of these areas. So it's fine for the legislation to say the patients may be advised of access to these things, but access is inadequate.
Honourable Minister.
Well, thank you, Mr. Speaker. I thank the member for her question as well, because I agree, as the Minister of Health, that's part of my job, is to improve access to health care across Canada, and certainly wouldn't be my mandate letter to improve that if, in fact, we thought that everything was perfect. But we do know that the work is underway with the provinces and territories. I mentioned the $10 billion investment that happened a couple of years ago. Obviously, in my mandate, things like access to primary care, improving supports for addictions and treatment in communities, these are the kinds of things that the Prime Minister has asked me to do. In the meantime, we know that Canadians also want to have autonomy at the time of their death. And so this is an important balance that we have to strike. We have to make sure that we're continuing to work in ensuring that Canadians have equal access to services all across the country. The legislation says that people need to be made aware of services in their community and available to them, so that, in fact, they are fully aware that the choice they're making is truly one that reflects their own particular circumstance.
Time for one just last short question. The honourable member for Humber River Black Creek.
Minister, I certainly applaud the intent and where we're going with this changes to the legislation. But I think the concern has to be, at the end of the day, we pass a lot of money down to the provinces, and we expect them to do certain things with that. Ensuring palliative care and all of the other services, of course, are available is important. Is there a FedProv group together that is going to ensure that a fair amount of the funding that we continue to transfer down gets to the very areas that we want, which is ensuring that people have access to palliative care and other resources?
Well, Minister.
Thank you, Mr. Speaker, and I thank the member for her question. Absolutely, there is a federal, provincial, territorial working group that works very closely together to try and determine how we create an equal access to services across Canada, how we make sure that the investments we're making are resulting in differences in the access to care for people independent of where they live, and that we work together to uphold the Canada Health Act. And this is something, as you know, that the Prime Minister takes very seriously, as do I. And so, as I've recently tabled my findings under the Canada Health Act, we'll be pursuing with provinces and territories their obligation to make sure that they're providing services that are afforded to all of us through the history of healthcare in this country. Thank you.
Before resuming debate, I would like to give my compliments for the honourable members for their participation during the questions and comments period. It was excellent. Resuming debate.
The honourable member for Dufferin-Caledon.
Thank you very much, Mr. Speaker, and I'm happy to stand today to add my voice to this debate. I think it's a particularly important debate. It's an important subject, and I think there are a lot of issues that need to be discussed. I'm going to confine my comments to issues that I find with the bill, things I'm concerned about, and my genuine belief that the government will take a very collaborative approach to this legislation, because if we have a collaborative approach to this legislation, Canadians can then have the trust and faith that we have developed legislation that will actually address the needs and protect the concerns. Speaking of the concerns, I have a number. I'm going to start off by talking about what I consider to be a significant lack of consultation. This legislation is due to come up for review in June. It's the 5-year mandated review of the legislation. My understanding as well is that the government has applied for a 4-month extension with respect to the implementation of this legislation that the Quebec court struck down. So if we have this 4-month extension and we have a mandated review of the legislation scheduled in June, my first question is this: what is the rush? Why have we rushed to introduce legislation prior to having that mandatory review, which of course would be extensive and broad and far more in-depth than any consultation that has been done with respect to this current piece of legislation? My understanding as well is that there was only about a 2-week public consultation or input that was available for this legislation, which, in my opinion, is woefully deficient given the gravity of this, the topic that we're discussing today. So this is my first real concern. What's the hurry? What's the rush? The court has given us more time to do this, and I believe we should be taking the time to go through a mandatory review, consult with Canadians, and then decide on the path forward. That's my number one concern. I apologize. I also want to put out that I'll be sharing my time with the member for Langley-Aldergrove. Thank you for the page for bringing that to my attention. She's doing an excellent job. So one of the first things the next thing I want to talk about is palliative care. And the minister has made comments in the House today espousing the great investments that are being made by their government in healthcare, but not really talking about any specific investments with respect to palliative care. And I think that's a critical thing to look at when we discuss this legislation. And I want to remind the minister that legislation that was passed, an act providing for the development of a framework for palliative care in Canada that was passed in the previous Parliament in 2017, it clearly states this: whereas the final report stated that in the preamble, whereas the final report stated that a request for physician-assisted death cannot be truly voluntary if the option of proper palliative care is not available to alleviate the person's suffering. So this is something that was passed by this Parliament. So when we look at expanding the scope of medically assisted death without also expanding the scope of the availability of palliative care, I think we're doing an incredible disservice to Canadians, because the availability of palliative care in this country is poor at best. I'm going to speak about this personally just for a moment. Both my parents suffered from terminal cancer. My mother was not able to get into a palliative care facility because there was no palliative care facility available for her, and so she passed away in the hospital. My father also was not able to get into palliative care, but fortunately, his illness was longer than my mother's, or unfortunately, depending how you look on it, and we were able to bring in private home care that was able to, ease his suffering and make sure that he was being taken care of. But also, there was no way that he was going to be able to get into palliative care within the scope of his illness. And this is something that is affecting Canadians from coast to coast to coast. And it's something that the minister has rushed to introduce this bill. Why would the minister not have introduced corollary legislation or legislation in tandem, or announce the increases in funding for palliative care? When we talk about my own riding of Dufferin-Caledon, we have a fantastic hospice for palliative care. It is called Bethel Hospice. They only have approximately 15 beds. That is the palliative care options in my riding of Dufferin-Caledon. Approximately 200,000 people, 15 palliative care beds. You can imagine there's a significant number of people who are not able to get into palliative care. And therefore, the option of medically assisted death becomes far more attractive for someone who's not able to enter into a palliative care facility. And I would repeat that that is clearly a violation of legislation that was passed by this House. When people do not have the option for proper palliative care, their consent for medically assisted death is significantly in question. So I'm extraordinarily concerned by the lack of any plan by this government to deal with investments in palliative care. And the minister has suggested that there are significant safeguards in place for people who suffer from a mental illness or are mentally any type of a mental illness. So I'm not sure what those safeguards are. She suggests that just having that condition would exclude someone from obtaining medically assisted death. But what is the definition of that? How are we defining that that is, or proving that that is the only issue? There's no requirement for someone to go to a psychiatrist in order to prove or to assess that they're not suffering from a severe bout of depression. I can say that in my own life, I have gone through extraordinary stages and phases of depression where I actually did not want to live anymore. And no, I was not seeing a psychiatrist at the time. And would I have then been able to avail myself of these services in a period of particular darkness? And we know that mental health is an issue that is rampant throughout this country. So again, I go back to my first point, which was, why are we rushing to do this? Why have we not taken the time to go through the 5-year review and to find ways to make sure we're safeguarding all Canadians and providing with the option for medically assisted death if they want it, but also ensuring that people who are choosing this, maybe because of a lack of palliative care, maybe because of some underlying mental health issues, that they are going to be protected. So these are some of the major concerns that I have with respect to this piece of legislation. When we go back and talk about consultation, I know that 2 weeks for online submissions with respect to concerns by Canadians. This is not anywhere near sufficient amount of consultation. And it was mostly, as my understanding is, online submissions. And, this is not a way to get the pulse of Canadians with respect to a very significant issue that's going on in this country. And I will continue to ask why there wasn't longer or broader consultation. I know this matter will be studied at committee, but having been a member of Parliament now for going on 5.5 years, I understand the extreme limitations that go on at committee. We will often bring a panel of 6 witnesses. Those 6 witnesses will each get their 10-minute statement, and then members of Parliament might get a 6-minute intervention to try and raise an issue. So if you're going to suggest that a committee study will be far broader in scope or somewhat more encompassing than the mandatory statutory 5-year review, I'm going to respectfully disagree with that submission. I think that committees do great work, absolutely, but they also suffer from an extreme pressure of legislation and time. So to suggest that a 1 week or a 2 week or 3 meetings at committee is going to sufficiently have time to analyze and debate and discuss this legislation, I do not think that is the correct answer. We should be putting this legislation off until we have the mandatory 5-year review in June, which can allow us to have a far more expansive discussion with respect to all of the issues that are being discussed in the legislation. Thank you, Mr. Speaker. These are my comments and concerns with respect to the legislation. I certainly hope that the government will listen to these concerns, act collaboratively, act cooperatively, not try and just drive this legislation through without listening to the legitimate concerns that are being raised by members of the opposition. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. I want to pick up on the member's points in regards to the issue of palliative care, and it is something, you know, during the debates in the last session, there was a great deal of emotion that was expressed on the floor, and I really valued and appreciated the contributions by members, and I think that members from all sides of the House were really trying to get that better understanding and just the importance of what it is, the subject matter that we were debating. And the member is quite right in the sense of when you think of palliative care, that whether it's the national government, the different provincial governments who ultimately administer health care, we do need to do a much better job on palliative care. And I'm wondering if my friend from across the way can just provide some additional thoughts. And I would ask him to look specifically in areas of the country where palliative care is nowhere near where it should be or could be compared to other areas of the country. And I'm thinking maybe whether it's rural versus urban, even the variations between urban centres.
For Dufferin-Caledon.
Well, I appreciate the point being raised. Yes, access to palliative care across this country is a huge issue. And in fact, we're making the situation worse with the government deciding to take away funding from palliative care centres that do not offer medically assisted death as part of the suite of services that they offer. So we're losing palliative care beds across the country as a result of that decision. And I'm actually hopeful that the member hearing this and hearing this being raised by members of the opposition, they will take that back and actually look at reversing that, because the last thing we need in this country is less palliative care beds. And I would really encourage this member to speak to his leader and speak to his cabinet and get them working on this national palliative care strategy and invest money so that we have equal access to palliative care across the country.
The Honourable Member from Montcalm. Thank you, Mr. Speaker. I would like to tell my Conservative colleague this. He would like a psychiatrist to be the one to assess the mental health of the person who is suffering or dying. Family practitioners prescribe medication, and they are also in a position to treat depression. So a patient is given a diagnosis, and he's told there's no cure. His or her doctor is offered palliative care. However, if the patient says, I want MAID right away, well, their doctor is going to give them antidepressants. There are ways to prepare a person that happen well before. And also, this legislation excludes mental health as an underlying condition. So what is the concern exactly for my Conservative colleague? Everyone thinks that easing suffering in palliative care, regardless of whether it's in a palliative unit or not, is common practice. That is good medical practice. It happens. Pain is eased. And no one at end of life who is receiving good care is in a position where they have to ask for MAID. But if a person asks for that, then that is up to them. So that choice has to exist. That person has to have options.
Dufferin-Caledon.
Well, Mr. Speaker, I'm not disputing that people should have options. That's certainly the whole point of the legislation. I'm not arguing against that. What I am suggesting is that there are not sufficient safeguards in place from my perspective. And while the member might say that going to see your family doctor to talk about depression is an excellent way to be treated for depression, I can tell him from my experience it is absolutely not a good option. My family doctor and most family doctors are completely incapable of treating someone for depression. They might be able to prescribe a medication, yes, but guess what? The answer to all depression is not medication. So my concern, and we're here to raise concerns, my concern is that this is not properly addressed in this legislation because I don't believe there are proper safeguards in place, and I think that's something that we should be discussing here during debate, also at committee, and certainly in the 5-year review that's going to take place in June.
Resuming debate, the honourable member for Langley Aldergrove.
Thank you, Mr. Speaker. I'm pleased to join the debate on Bill C-7, an act to amend the Criminal Code of Canada, and specifically Section 241 of the Criminal Code. That is the provision of the Criminal Code that makes it illegal to counsel a person to commit suicide or to aid someone to do so. In the absence of more recent amendments, in the previous Parliament, there's Bill C-14, which was legislation from the previous Parliament in response to a Supreme Court of Canada decision, the Carter decision. In that case, the court found that the plaintiff's charter rights had been infringed by a strict interpretation of Section 241. Now, interestingly, that bill C-41 from the previous Parliament stated as one of its objectives in preamble paragraph 6 that, and I quote, permitting access to medical assistance in dying for competent adults whose deaths are reasonably foreseeable strikes the most appropriate balance between the autonomy of persons who seek medical assistance in dying on the one hand and the interests of vulnerable persons on the other. Now, the relevant provisions of the Criminal Code included that language. It states that qualifications were made, including that with respect to the person, their natural death has become reasonably foreseeable, taking into account all their medical circumstances. All of this is about to change because of the Truchon decision. Now, Mr. Speaker, I'm speaking on Bill C-7, a bill that would eliminate the reasonable death foreseeability safeguard and expand MAID, medical assistance in dying, to a larger number of people. And I'm encouraged to do so because of the many letters and correspondence that I've received from people in my constituency. I've received some letters in support of expanding MAID, but the vast majority of the letters that I have received encourage me to speak against expanding the availability of medical assistance in dying. Correspondence that I'm receiving from constituents repeat two basic themes. First, the reasonable foreseeability of death safeguard should be maintained as an effective defense of societal interests and Canadian values. And secondly, that more should be done to expand palliative care services. To quote one person, let Canada be a society that is known for its modern and advanced palliative care services and not as a country that has ever-expanding use of medical assistance in dying. Alleviate the suffering, do not eliminate the sufferer. I'm going to just read quotes from two people who bothered to write me a letter. The first is from Dr. Den Hollander. He states, if Canada must allow MAID in some form, and I wish it didn't, it is incumbent upon us to ensure that it is rare. Eligibility requirements should be tightened, not loosened. More safeguards are necessary, not fewer. Enforcement must be scrupulous, not relaxed. Without these protections, vulnerable people will be pressured by family members, friends, and medical practitioners to avail themselves of medical assistance in dying. I also want to quote from a letter that I received from Ramona. She works in healthcare, including palliative care, and she quotes a person to whose care she attended who died in the Langley hospice facility. And here's a quote. I want to live well while I'm dying. Now, Ramona goes on to comment, surely this is what healthcare was created for, to support people while they are alive, not to speed up their death. So this is the tenor of the input that I'm receiving from my constituents. What's behind Bill C-7, of course, is the Supreme Court decision of Truchon. The plaintiffs in that case argued that their constitutional rights had been infringed by the now amended Section 241 of the Criminal Code. They argued that the Carter decision, on which Bill C-41 was based, did not require that a person's end of life be reasonably foreseeable, and that is a true statement. That is not what the Carter decision had required. And secondly, they argued that the legislated end of life requirements violated the right to equality under Section 7 of the Charter and the right to life, liberty, and security of the person under Section 7 of the Charter. Now, the federal government, acting through the Attorney General's office, did the right thing at that time. They defended their law. That is what the Attorney General should do. Bill C-41 was a well-considered opinion of the previous Parliament. It was the law. The Attorney General must defend the law. But remarkably, the Quebec Superior Court refused to accept the arguments advanced by the Attorney General. This is what the Quebec Superior Court said. The court cannot accept the first two objectives advanced by the Attorney General regarding the affirmation of the inherent and equal value of every person's life and the importance of preventing suicide. So in the opinion of the justice writing that decision, those two principles were not what was the underlying philosophy of Bill C-41, but it was all C-14 rather. What it was all about was protecting vulnerable persons from being induced in moments of weakness to end their lives. Remarkably, the Attorney General of Canada did not appeal that decision. That's what they should have done. Any self-respecting Attorney General would appeal a decision that attacked the laws of Parliament. This Attorney General elected not to do that. And now we are in this position where we are under pressure to amend the law when we should instead be following the directive of Bill C-41, and that is to have a comprehensive review of the whole legislation. That is what we should be doing. What is the rush? The rush is caused by the Attorney General's failure to appeal this decision. It should have been tested through the court system up to the Supreme Court of Canada. Now, with the reasonable foreseeability of death safeguard down, this is what we have left. An applicant for MAID qualifies if he or she has a serious and incurable illness, disease, or disability. That person is in an advanced state of decline, number two. And number three, their physical or psychological suffering is intolerable to them. Completely subjective test. The reasonable foreseeability of death criteria is now gone. Now, let's just test this against a couple of hypothetical situations. Imagine that a person has Parkinson's or MS, or somebody who is in a terrible accident and is paraplegic. Under this new regime, if it becomes the law, people who are not dying, but who meet all the other criteria, however subjective they may be, will qualify for state-sanctioned suicide. Just to repeat what one of my constituents has said, let Canada be a society that is known for its modern and advanced palliative care services, and not as a country that has ever-expanding use of medical assistance in dying. Thank you.
Questions and comments. Question commentaire. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, it's more so on a point of order, and my apologies to the member for interrupting his question and answers. But, Mr. Speaker, there have been discussions amongst the parties, and if you seek it, I am hopeful that you will find unanimous consent for the following motion. That notwithstanding and standing order or usual practices of the House, Bill C-4, an act to implement the agreement between Canada, the United States of America, and the United Mexican States, reported back earlier today, be permitted to be considered by the House tomorrow at report stage.
Does the Honourable Parliamentary Secretary have the unanimous consent to propose this motion? Yes? No. There is no consent. And we'll now then go back to questions and comments. Questions and comments. Question and commentaire. This is on the last speech by the Honourable Member for Langley Aldergrove. Question and commentaire. I think I saw. That's the Honourable Parliamentary Secretary to Government House Leader.
Yes, Mr. Speaker, in addressing the bill, the member opposite made reference to the fact that he was quite disappointed that the federal government did not appeal the decision from the Supreme Court of Quebec, or the Superior Court. And I'm wondering if he feels that, if government looks at a decision that's made by a court ruling or a superior court, that it is a viable option for the Government of Canada, for the Attorney General, to say, well, look, as opposed to appealing, it makes sense, and it's better that we actually forego going to the Supreme Court and go in favor of making the changes that are being requested. And that is why we see the legislation that we have before us. And would he not see that as a viable option that government should consider in certain situations such as this?
Honourable Member for Langley Aldergrove.
I thank the member for his question. Bill C-14 was the well-considered response of the previous Parliament to a Supreme Court of Canada decision, the Carter decision. Bill C-14 became the law, was incorporated into the Criminal Code of Canada. I'm of the opinion, Mr. Speaker, that the Attorney General should defend the laws of the country. It was the law was only 3 years old. It was a well-considered decision of this Parliament. The Attorney General should defend the laws of Parliament. Thank you.
Question and commentaire. Questions and comments. Honourable Member for Victoria.
Mr. Speaker, my question for the member across the way is really around whether the Conservatives support Audrey's amendment and helping those families facing end of life, avoid the kind of cruel suffering and the difficult choices that people are often facing when they are looking at imminent end of life situations and potentially not being able to give consent farther down the road.
Honourable Member for Langley Aldergrove.
Question. I believe that people should have choice, but choice should be a real choice. Palliative care, I believe, is the right way to go. I'm just going to quote again somebody who wrote to me, let Canada be known as the country of advanced palliative care, not as the country of ever-expanding provision of MAID. I understand that people suffer. I understand that people may not be able to give concurrent consent. However, this country can certainly invest more money in advanced palliative care, and that will relieve suffering to a very large degree. And we should work on alleviate the suffering, not eliminating the sufferer. Thank you.
Questions and comments. Question and commentaire. The Honourable Member for Sherwood Park, Fort Saskatchewan.
Well, thank you very much, Mr. Speaker. I thank my colleague for his excellent speech. There are many different provisions in this legislation. One of them that I thought was interesting was that for the case of someone whose death is not reasonably foreseeable, the government is saying that one of the two physicians involved in the consultations has to have some expertise in the ailment. It's interesting because this didn't appear in any of the other cases. It seems to me reasonable to have this safeguard, not just for the case where death is not reasonably foreseeable, but in all cases, that to say at least one of the physicians consulting should actually have some particular expertise about the ailment. Physicians deal with a wide variety of different kinds of things, so to say that the person who knows particularly well the disease should be involved in the consultation. To me, that seems very reasonable, and I wonder what the member thinks of that, and I hope the government might be willing to apply this safeguard not just in one of the two streams, but really across the board.
The honourable member for Langley Aldergrove.
Thank the member for the question. Of course, it stands to reason that I would support anything that would improve and enhance informed consent. So indeed, the doctor giving the advice to the suffering patient should indeed be an expert in the field. And I would also support any argument that would put in that additional safeguard for both streams, both those patients who are whose death is reasonably foreseeable, as well as those whose death is not reasonably foreseeable. It stands to reason I would support that, and I would hope that the government would support that. Thank you.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Employment and Skills Development.
For Beaches, East York. Mr. Speaker, it is an honour to stand up in the House of Commons and participate in the second reading debate for Bill C7, an act to amend the Criminal Code to Canada's medical assistance in dying legislation. Thank you for this opportunity. In developing these amendments, Canadians were widely consulted in January 2020. During these consultations, approximately 300,000 Canadians completed an online questionnaire. In addition, the Minister of Justice and Attorney General, the Minister of Health, and the Minister of Employment, Workforce Development and Disability Inclusion met with stakeholders in Halifax, Montreal, Toronto, Vancouver, Calgary, Winnipeg, Ottawa, and Quebec City to discuss proposed revisions to Canada's medical assistance in dying framework. These experts and stakeholders included doctors, nurses, legal experts, national Indigenous organizations, and representatives of the disability community. Mr. Speaker, the high level of participation in both the questionnaire and the in-person sessions is a reflection of the importance of this issue to Canadians. Moreover, the results of the consultations were critically important in shaping the government's approach to medically assisted dying as it evolves to reflect the needs of Canadians. Mr. Speaker, this bill would amend the Criminal Code to allow medical assistance in dying for people who wish to relieve their suffering through a medically assisted death, whether their natural death is reasonably foreseeable or not. This bill would remove the reasonable foreseeability of natural death from the list of eligibility criteria. It will also expressly exclude people seeking medical assistance in dying solely because of mental illness. The bill proposes a two-track approach based on whether or not a person's natural death is reasonably foreseeable. Existing safeguards remain and are eased for those whose death is reasonably foreseeable. In addition, new and modified safeguards would be applied to eligible persons whose death is not reasonably foreseeable. Now, Mr. Speaker, in the spirit of nothing without us, I would like to mention the government remains focused on addressing the concerns of the disability community around vulnerability and choice. Mr. Speaker, the proposed changes to the legislation support greater autonomy and freedom of choice for eligible persons who wish to relieve their suffering by pursuing a medically assisted death. At the same time, full consideration has been given to the protection of vulnerable persons and to respecting the equality, rights, and dignity of persons with disabilities. In short, Mr. Speaker, this bill maintains and strengthens safeguards to support fully informed decision-making while also respecting individual autonomy. In terms of advance consent, many participants were comfortable with implementing advance requests for those who have been assessed and approved for medically assisted dying. but are concerned about losing capacity before it is provided. This bill would allow people who risk losing decision-making capacity to make arrangements with their practitioner to receive medically assisted dying on their chosen date, even if they lose decision-making capacity before that date. The bill would also make advance consent invalid if the person demonstrates refusal or resistance to the administration of medically assisted dying. The bill goes on to clarify that reflexes and other types of involuntary movements, such as response to touch or the insertion of a needle, would not constitute refusal or resistance. In addition, the bill would allow eligible persons who choose to self-administer to provide advance consent for a physician to administer a substance to cause their death if self-administration fails and causes them to lose capacity. This type of advance consent would be available for all eligible persons, regardless of their prognosis. Mr. Speaker, I would like to take a moment now to speak to the progress the government has made with respect to the rights of persons with disabilities in Canada. In fact, last year, the government enacted the Accessible Canada Act, which aims to create a barrier-free Canada through the proactive identification, removal, and prevention of barriers to accessibility wherever Canadians interact with areas under federal jurisdiction. The Act is one of the most significant advances in disability rights since the Charter in 1982 and is designed to inspire a cultural transformation towards disability inclusion and accessibility in Canada. The Act created Accessibility Standards Canada, a new organization that will create and revise accessibility standards and support and promote innovative accessibility research. The CEO and board of directors were appointed and operations began last summer. That act also established National Accessibility Week, a week dedicated to accessibility in late May and early June each year. National Accessibility Week is an opportunity to promote inclusion and accessibility in communities and workplaces, and to celebrate the contributions of Canadians with disabilities. It is also a time to recognize the efforts of individuals, communities, and workplaces who are actively removing barriers to give Canadians of all abilities a better chance to succeed. The Act applies to federally regulated organizations for now, but we know the culture shift will have a trickle-down effect, and awareness and action on disability inclusion will increase across the country. Mr. Speaker, our government is taking real action to address the rights of persons with disabilities. The careful writing of C7 is a testament to that. Representatives of disability organizations and leading disability scholars participated in consultations across the country. Their input informed the reforms proposed in this bill. We recognize that disability inclusion requires more than legislation, and that is why we are continuing to work with the disability community and other stakeholders to address stigma and bias. It is important to bring about a culture change to ensure that the important contributions made to Canada by persons with disabilities are recognized and valued on the same basis as those of other Canadians. Going forward, we will continue to focus on improving the social and economic inclusion of persons with disabilities. Mr. Speaker, we will continue to work hard to ensure that every person is treated with the dignity and respect they deserve, especially when it comes to deep and personal issues like ending one's life. It is imperative that the voices of all Canadians, including Canadians with disabilities, continue to be heard on the issue of medical assistance in dying. Thank you.
Questions and comments. Kese Kamanta, the Honourable Member for Cloverdale, Langley City.
Mr. Speaker, my esteemed colleague mentioned the extensive two-week online public consultation that happened. And the questionnaire, I felt, was extremely leading. So I held a town hall in my riding. We had almost more than 100 participants. And we went through the online survey question by question. And it was clear that regular Canadians were being asked to make decisions on highly nuanced questions that were much more appropriate for healthcare professionals with clinical knowledge to answer. And many chose actually to not fill in the multiple choice options because of the biased slant of the questions. They chose instead to fill in the comment section to ensure their true answer was recorded without the ability for bias. So my question is this. When will we have access to the 300,000 responses, and most especially the written comments?
Honourable Parliamentary Secretary to the Minister of Employment.
And I thank the honourable member for the excellent question and the concerns that have been raised in this House. And again, we know that this issue is an incredibly complex issue. We know that it is an incredibly personal issue. And our priority was to listen to Canadians, and which is why we conducted, again, extensive consultations with doctors, nurses, the disability community, vulnerable populations across the country. We received obviously over 300,000 responses to our survey that again asked Canadians their opinion on MAID. And this legislation here that's before us, of course it's a reflection of the Quebec Superior Court decision in Truchon, but we firmly believe that it is also a reflection of Canadian voices from coast to coast to coast through those extensive consultations. In terms of accessing the survey results, I'm happy to provide that information for you. I don't have that information now, but I can provide that information to the honourable member outside of the House.
Questions and comments? The honourable member for South Okanagan, West Kootenay.
Well, thank you, Mr. Speaker, and I'd like to thank my colleague for his speech. And one thing the NDP is concerned about with this legislation is when people have unendurable suffering, yet under this they face a 90-day period of assessment. And we were just wondering, where did that number came from? Who gave them that advice? It would seem that in this situation, people would very much appreciate, people seeking this treatment would appreciate a more rapid response.
The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. And again, I thank the honourable colleague here for the excellent question. If you actually read the preamble to Bill C7, you see the legislation's explicit desire to balance several interests and values. The autonomy of the person seeking a dignified death, the protection of vulnerable persons, and the important public health issue that suicide represents. And I believe that this bill, Bill C7, achieves that balance by, again, relaxing safeguards for Canadians that are at end of life, but also strengthening safeguards and, just as important, strengthening supports for Canadians who have a grievous and irremediable medical condition and who are in an advanced state of irreversible decline, but not necessarily at the end of life. Thank you.
Questions and comments? The honourable member for Red Deer Lacombe.
Well, thank you very much, Mr. Speaker. My question for my colleague is this. Given the fact that the government, of which he's a member of the government caucus, has chosen to accept the decision of a Quebec court rather than appealing it to the Supreme Court of Canada, I would guess that the rationale would be based on a sense of urgency to deal with this issue. I'm wondering if I can count on my honourable friend across the way to make the same point in his caucus meeting about the decision in Alberta that the carbon tax is out of jurisdiction and that the government will accept the Alberta court's decision as much as they're willing to accept the Quebec court's decision on this matter.
The Honourable Parliamentary Secretary to the Minister of Employment.
Well, thank you, Mr. Speaker. And again, I thank the honourable colleague for the question. I'm not sure how the actual question is cogent to this incredibly personal and complex and emotional discussion that we're having in the House. But what I can say is that our government remains committed to protecting vulnerable individuals and protecting the equality, the value, and self-worth of all Canadians. Thank you.
Resuming debate, the honourable member for Beaches, East York.
Thank you, Mr. Speaker. We have a unique opportunity to fix our assisted dying laws and to protect the individual rights of all Canadians to make such a fundamental and deeply personal choice for themselves. Now, I opposed the assisted dying laws in the last Parliament because they were too restrictive. They were not in keeping with the Supreme Court's decision in Carter, and because I believe them to be unconstitutional. And here we are, Mr. Speaker. A Quebec court found the law to be unconstitutional. We agreed rightly to abide by that decision, and we have another chance to get it right. Now, as we look forward to what getting it right looks like, we should also look behind us at the Supreme Court's decision in Carter. Now, those in this House have talked about striking a balance between the fundamental freedoms of individuals to choose for themselves and the autonomy of the individual to make such a deeply personal choice, as against protecting vulnerable persons. But of course, for anyone who reads the Supreme Court's decision in Carter, they will know that the Supreme Court struck that balance with a number of safeguards that looked like this. To be eligible for assisted dying, one need to be suffering intolerably and in an enduring way. There needed to be a grievous and irremediable condition, an incurable illness. And the individual in question needed to be competent and to clearly consent. Now, the government in the last Parliament, incorrectly in my view, added an additional criterion for eligibility, that one's death needed to be reasonably foreseeable. That is unnecessarily and unduly restrictive. And I'll get to a court case in particular that explains this in greater detail. But there are two core injustices that the new law proposes to fix. First, this question of removing the reasonably foreseeable requirement as a matter of eligibility, and also to address the case of Audrey Parker, because we had another fundamental injustice where an individual who was eligible for MAID was taking their life earlier than they otherwise would have, lost time in their life that they otherwise wanted to spend with their family and loved ones, because they were worried about losing competence and being unable to give consent near the very end, despite the fact that it is exactly what they wanted. Now, the Council of Canadian Academies identified 3 levels of advanced requests where an individual is already eligible for MAID, that's the Audrey Parker case, where an individual has been diagnosed but is not yet eligible but is on the path clearly towards eligibility, and where someone has not yet been diagnosed and so is further from eligibility for MAID. And clearly in this case we've identified a solution to one of those categories, but we ought to, I think, solve advanced requests more broadly going forward. Now, is the law perfect? No. It's, I think, worthy of our support, Madam Speaker, at second reading, but there are a number of concerns worth highlighting. First, while a reasonably foreseeable death is no longer a criterion of eligibility, there are additional hurdles for individuals to pass if one's death is not within the near future. One of 2 practitioners assessing eligibility must have expertise in the condition. Now, that sounds very reasonable in theory. My only question for committee members as they look to this is to ensure that that is not an impossible barrier in practice, for particularly for those in rural communities where such expertise may not exist at all times. Now, there's also a minimum, and I would say somewhat arbitrary, period of 90 days for the assessment of the request. It looks like a backdoor cooling period, Madam Speaker. It would make far more sense for us to have, I would say, no time limit in the assessment period to be done in the ordinary course, or at least a much shorter time period, because we are talking about people who are suffering incredibly, who are competent to make the decision for themselves. Does it cure the case for Audrey Parker? I think largely, but I do worry if the MAID procedure must be scheduled already. What does that mean? That if Audrey Parker was in a situation to say, I'm not exactly sure what the time period will be, I know it's not now, but I know it will be soon, is she to have scheduled a particular date which would make her eligible for the advance request? Or are we going to put someone in a situation where they are scheduling something earlier than they otherwise would? Now, mental health. This is a real challenge because there's an additional criterion that we're building into this legislation. It says, for the purposes of MAID eligibility, a mental illness is not a serious and incurable illness, disease, or disability. And again, it sounds reasonable on its face in many ways, because we can immediately imagine a situation where mental illness, of course, impinges upon our ability to give consent, impinges upon our ability to conduct ourselves as a competent person. But that isn't always the case. And because I am aware of some opposition from conservative benches, and because I'm also aware of the conservative just the number of conservative MPs that come from Alberta, I wanted to quote from a case from the Alberta Court of Appeal from 2016. This was a woman identified as EF, a 58-year-old woman with a severe conversion disorder, a psychogenic movement disorder. And the court wrote, "She suffers from involuntary muscle spasms that radiate from her face through the sides and top of her head and into her shoulders, causing her severe and constant pain and migraines. Her eyelid muscles have spasmed shut. Her digestive system is ineffective. She has trouble sleeping and is non-ambulatory." The Alberta Court of Appeal states, "While her condition is diagnosed as a psychiatric one, her capacity and her cognitive ability to make informed decisions, including providing consent to terminating her life, are unimpaired." Here is a woman who was eligible, was able to take advantage of MAID because we did not yet have an unconstitutional law in place to prevent her from accessing the regime. The Alberta Court of Appeal determined that absolutely this woman was competent and was able to consent for herself. They noted further that she had consulted with her husband and adult children who were all in support. And I worry that if we look at restricting mental illness completely, even if it does not impinge upon one's consent, even if it does not impinge upon one's ability to conduct oneself as a competent person, what are we telling that individual? That they are unable to make a fundamental and deeply personal choice for themselves, that they have fewer rights than I do, than we do. And that can't possibly be right in this society. And I'll note that this is a recurring problem for the Justice Department, that when they argued the case of EF and they lost at the Alberta Court of Appeal, they argued that the Carter criteria meant that terminal illness was required. The court said no. They argued that illness has at its root, they argued that illness for a psychiatric condition should be deemed ineligible. And again, they lost at the Alberta Court of Appeal. So if we're to respect the Carter decision, and if we are to respect the precedent in case law since the Carter decision, I don't think that we ought to have such a categorical exclusion in our law. Carter, the Supreme Court noted, "It is a crime in Canada to assist another person in ending her own life. As a result, people who are grievously and irremediably ill cannot seek a physician's assistance in dying and may be condemned to a life of severe and intolerable suffering. A person facing this prospect has two options. She can take her own life prematurely, often by violent or dangerous means, or she can suffer until she dies from natural causes. The choice is cruel." The cruelty, and this is the Alberta Court of Appeal, stating the cruelty in the situation is there, regardless of whether the illness causing the suffering may be classified as terminal, and certainly continues to be there, regardless of whether the suffering has as its primary focus a psychiatric disorder. As a final note on this subject, Madam Speaker, I would just note this law, if it is carried forward without an amendment, it will treat mental illness as lesser than physical illness, a stigma we have worked hard to combat in other settings. I've said previously, I do think we have to tackle advance direct requests more seriously than we have in this legislation. I know, of course, there's an ability to have this broader conversation later this year as we revisit this conversation. I certainly think if one is diagnosed with a condition and they can clearly see where it is heading, of course I want to, as a matter of my fundamental freedoms, be able to determine my future. And I would even say we ought to, in directing our own futures, be able to provide advance requests more broadly and more easily, even if we have not been diagnosed. And I recognize that the Council of Canadian Academies identified we need certainty, though. And how do we provide certainty? I think through sunset clauses, where if we haven't revisited and re-upped our commitment to our advance requests within a certain period of time, then it would fall away. But that would certainly allow for certainty to take hold. And I will just close, Madam Speaker, by saying this. I mean, there are other things that we could look to in the law, including mature minors, because minors, of course, have the ability to make life-changing decisions in medical contexts in other settings outside of MAID. But in the end, this law needs to ensure that anyone eligible for MAID pursuant to the Carter criteria continues to be eligible for MAID through this law. It is a matter of fundamental freedoms, a matter of dignity in the end, Madam Speaker.
Questions and comments? The Honourable Member for Cloverdale Langley City.
Thank you, Madam Speaker. The Liberal government has sent a clear message to the provinces that euthanasia access is a priority over palliative care. as we can see from the fact that the Liberals are letting a Quebec lower court judge steer the way forward for the rest of Canada. We can also see on the opposite side of the country that Fraser Health in British Columbia leads the charge by revoking funding for hospice care beds that were confiscating private charitable donations for the implementation of MAID access. Why is this government not fighting to ensure quality palliative care access before euthanasia?
Beaches, East York.
So I trust the member heard me when I quoted not only the Supreme Court, which was the Quebec court was just reiterating the Supreme Court's criteria, by the way, and I also quoted the Alberta Court of Appeal, which was, again, reiterating the Supreme Court's criteria. I would also note that this false dichotomy between palliative care and death with dignity is so completely false that, of course, a government ought to be focused on providing all of the options at the end of one's life to ensure that there is dignity. But in the end, the government has no right to take away my fundamental individual choice.
Questions and comments. The Honourable Member for Timmins, James Bay.
Yes. Thank you, Madam Speaker. I listened with great interest to my honourable colleague, who I have a great deal of respect for. I would raise the questions that he'd raised on the issue of the advance directive. And I say that because I think when we think in advance, everyone I've ever known who's talked about, well, how I want to go and how I want to be, and I mean, my friend who was going to sit in the snow and listen to Bob Dylan and drink a bottle of whiskey on his last day. It's a great way to go, but we don't end up getting those options. But when we are faced with death, and I saw this with my own sister and her horrific suffering and her husband just before that, and they were very young, the will to live is so incredibly strong. And people don't realize how much they want to live and how much they want to stay. So when we make advance directives, and I know this is not so much the purview of this bill, but I want to ask my honourable colleague about the reasonable limits of that, so that we're not signing off and saying, in future, if it happens, this is how I want it to be, because when it happens, we are in a very, very different place and in a different world than we ever imagined we would be.
Beaches, East York.
Thanks to the member for the question. This is by far the most complicated area. There are some easy cases, like the Audrey Parker case, where someone is already eligible for MAID, and of course they understand their condition, and it's very clear an advance request ought to be in place. It's harder, but still, I think, fairly straightforward, where someone is diagnosed with a disease and there's a short-term trajectory where they can see that they're going to deteriorate significantly. It is much harder where one is not diagnosed at all. I'm 35. Would I put an advance request in right now? Well, how could that be intelligible? How could we make sense of that? And I think there are two things to say to that. One, I mentioned sunset clauses. So I think if we are requiring certainty, it would have to have an individual revisit their advance request and uphold and again support their advance request. And there's got to be a window of time where it would then fall away and not be legally valid. And the other thing to note, though, is that the Supreme Court's criteria is also pretty key here, where I can't just say an advance request for anything and I'm eligible to die, that I still have to be in a condition that is an incurable illness and where there's a grievous and intolerable and enduring suffering, which I think are incredibly important safeguards to keep in mind.
The Honourable Member for Dufferin-Caledon.
Thank you, Madam Speaker. And I appreciate the member's comments on this and many other matters. I do want to raise an issue with him suggesting the false dichotomy between palliative care and this legislation. In fact, this House in the previous Parliament passed legislation in the preamble which very clearly said, whereas the final report stated that a request for physician-assisted death cannot truly be voluntary if the option of proper palliative care is not available to a person suffering. So this is a critical issue, and access to palliative care is critically short in this country. So there is no false dichotomy. Why is this member's government not actually putting together a pan-Canadian strategy on palliative care and investing the money necessary so that we have that?
Member for Beaches East York, very briefly.
So the member should know that we've invested billions of dollars through bilateral agreements with provinces, and we've set a priority of home care, including palliative care. The member should know that health care, fundamentally, the delivery of palliative care, is within provincial jurisdiction. The member should also know, though, in the end, regardless of whether or not there is palliative care there or not, this is a question of whether does an individual have a right to make such a deeply personal choice for themselves or not? Do you believe in liberty or not?
Resuming debate, the honourable member for Louis Saint Laurent. Thank you very much, Madam Speaker. I'm very happy to participate in this debate today, which obviously is out of the normal framework of a debate here at Parliament that we often face. And in my personal life as a parliamentarian, this is the third time as a member. As I sat at the National Assembly of Quebec, and I had the privilege to sit there for 7 years, and here at the House since 2015, thanks to the support of my constituents. So this is the third time as a parliamentarian I have been asked to vote and debate the issue of medical assistance in dying.
To the National Assembly in 2008, and as a member of the National Assembly, I participate in the first debate that we had in Quebec, and the first time in the Canadian legislature we had to address that issue in 2010 and something. So I participate in that debate in Quebec, and I also was a participant in the debate that we had 4 years ago, when for the first time we had to address it in the House of Commons. So, in my parliamentarian life, this is the third time that I had to participate and to vote in this very touchy, personal, and non-partisan issue. C'est pourquoi, Madame la Présidente,
and that is why, Madam Speaker, I would like to remind people of a few cardinal rules that should guide us as parliamentarians in this debate that should not be partisan, and particularly we should must be remained respectful. Madam Speaker, we should show respect for a free vote in this issue. In my opinion, there is no good or bad position. There's no position that I'm entirely comfortable with, whether you're for or against. There's no partisan line on this. There's just an opinion that you have and that we're going to share and analyze. Therefore, you have to have a very open mind. You have to respect that there are colleagues from our party that don't share the opinions of others, and that's okay. And, Madam Speaker, there's nothing at all bad in this. We have a position that some aren't comfortable with, but I'm pleased to share my time, by the way, with my honourable colleague for Port Moody Coquitlam. Thank you, Madam Speaker. I'd like to thank my colleague. So, we have to show respect for debate, respect of people's personal opinions. We have to show respect that in this debate there's no partisanship or good or bad position. There's positions you agree with and those that you don't. And we have to respect that. There's also a substance here you have to bear in mind. In our opinion, there are some gaps in this legislation. First, we have to make sure that doctors who have to take action in respect to MAID have freedom of choice and conscience. If a doctor has a difficult time acting in this, they have to be able to state this and not have to move forward with MAID. All those who I spoke with, and I did speak with many people because I've participated in this debate for quite some time, they've told me that doctors may be open to some things at some times, but others not. And they should never be obliged to act if their conscience doesn't allow them to. There's something else we have to bear in mind. Medical assistance in dying, given its very essence, is the very last stage in someone's life and in the healthcare process. We must always remember that palliative care is there to ensure that people who are sick can have a life that is full of dignity despite the tragedy that they're facing. So we have to bear in mind that doctors should be able to act according to their conscience, and we also have to remember palliative care. Another key point we have to respect in this debate, that there's no rush.
That the first time that the Quebec government addressed this issue, it took 6 full years. 3 different governments, 3 different premiers. There was a huge debate about that, a strong debate, a wise debate, and each and every position has been clearly established by those people who participate in that debate. No rush, Madam Speaker. Take your time. We're talking about, for some people, assisted suicide. It's a very touchy issue. The worst case scenario is to rush it. In Quebec, we spend 6 full years. We shall follow this example. Obviously, it will not take 6 years this time. But the first footstep made took 6 full years. Donc, Madame la Présidente, respect.
Therefore, we have to respect the fact that we shouldn't rush things too much. So why are we here with this bill, C7? Because when the bill was voted on and adopted at the House of Commons in 2016, obviously there were some components, and I was part of the committee, that were challenged by citizens and that the court had to decide on. And this happened. Madam Speaker, I'd just like to note something. I didn't know this before I did the necessary research, and it's interesting to note that the current Minister of Justice, who I have great respect for, as a legal professor at McGill, who voted against the bill that was tabled in 2016, and now as Minister of Justice, he's proposing a response to a court ruling from Quebec that, bear in mind that on October 11th said that the Supreme Court shot down the component with respect to reasonably foreseeable death. So this element has been incorporated in this bill. Madam Speaker, you also have to understand that this bill addresses some things, but also ignores others. The first component that is fundamental with this bill is that they're eliminating the 10-day waiting period. And that means that one of the components that we added with the federal legislation to give a cooling period between the person's decision and the actual activity, well, the court felt that this was not good, and the minister said that they would move forward with that. And bear in mind that the C-14 that was adopted 4 years ago did intend to review this a few months later. As of June 2020, they did plan to review the legislation, and it might have been preferable to appeal the case and allow the Supreme Court to pronounce itself on this issue. We should have exhausted all the legal avenues so that the highest jurists of our country could have looked at this. And we decided to take note of what the Quebec court said and then to take action. That's their right. But we think that since we're in a very delicate topic and this subject really is a very fundamental one, and there's also high-level legal issues here at stake, it would have been preferable to appeal this case, and we should have ensured that all the legal ramifications were analyzed by the highest court of the country, namely the Supreme Court. Therefore, we also have to understand that there are things in this bill, some that are put forward and others that aren't. They decided not to look at mental illness, and that's a good thing because it's a very delicate issue. There's a fine line. When does mental illness not become irreversible, and when does it not? And so it's a very fine line there. It's hard to define. As I said earlier, the worst thing we could do is to rush. Perhaps at another time we could look at this. Perhaps we could debate this later, but for right now, we have to do one thing at a time. So my time's running out, but I just want to bring it to your attention that in this very sensitive and fragile debate, the worst thing we could do is to rush into this and to attack people on their viewpoints, but we have to respect everyone's personal choice and take the time, Madam Speaker, to do things properly on such a delicate and important issue. Thank you.
Questions and comments?
The Honourable Member from O'Callaghan. Thank you, Madam Speaker. And I appreciate my Conservative colleagues' remarks. Yes, in fact, we do have to keep the public good in mind. But I didn't really understand his position. He said we need to take the right amount of time. And he knows that that's also a delicate issue in itself, because while we take the time to do things properly, there are people who are suffering. There are people who do not have a choice, who want to be able to exercise their free will regarding their state. And the state we represent here is not giving them with choices and options to ease their suffering. So I would like to know what his position is on options for people like Ms. Gladu and Mr. Truchon in terms of access to medical assistance in dying. The honourable member. Thank you, Madam Speaker. The point is this, and I think it's important to remind this. My colleague also sat in the Legislative Assembly, and I worked with him 4 years ago. And it's true that we need to proceed because there are people suffering. But he knows that in Quebec, we've done things well and properly. Why? Because we took 6 years to do that. And yes, there were people suffering over the course of those 6 years. There were people who wanted access. However, we decided to do things properly. Now, we were elected in 2015, and we had a fairly tight timeline because we had been ordered to do this by the Supreme Court. Now, we still tried to take the time. It's true that there are people who are suffering, but there were people who were suffering over the 6 years that we took in Quebec. And I don't think anyone will argue that we didn't do the job well over those 6 years when we had to consider this very sensitive issue.
The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. Knowing my friend is, as a former provincial representative, understands and appreciates the important role that provincial governments actually play in the administration of healthcare and providing services. And one of those very critical services is, in fact, palliative care. We hear a great deal of debate on that particular issue. The federal government does play a role also in ensuring that there is a quality palliative care as much as possible throughout the country. And I'm wondering if my colleague could provide his thoughts in regards to how it is Ottawa needs to work with the other jurisdictions to ensure that we have the best palliative care being made available possible.
The honourable member for Louisa-Laurent.
For my colleague from Winnipeg North, obviously, and I said that in my speech, that yes, it is very important to put emphasis on palliative care. And we're talking really for the life of those people. It's not an easy task, but the responsibility of any government is to be sure that those who suffer have access to that palliative care. Obviously, this is a provincial jurisdiction. This is where the province should do something on. Yes, but on the other hand, it would have been better if in the bill it would have make emphasis on the palliative care, as we did 4 years ago. It was very important for us in our committee to address this issue, and we hope that the government will take care of palliative care.
Questions et commentaires, questions and comments.
The honourable member for Montcalm. Thank you, Madam Speaker. Quebec worked very well on this, but Quebec covered the area of its own jurisdiction. And it also included that at the end of life, you could make a request for medically assisted dying. However, that was part of a continuum of care. Now we're talking about the criminal law, and 2 courts now have said that us, the lawmakers, have to deal with medical assistance in dying for those who aren't at the end of life. So I would like to know from my colleague if he feels that for people like Ms. Gladu and Mr. Truchon, this bill responds to their needs, and if he agrees with the 2 rulings, the honourable member, very quickly. Yes. I think I said this earlier on. Maybe he didn't hear me. The reality is this. We have to take the right amount of time. When we have a ruling that's handed down from a court, and there are going to be others, I think it's the responsibility of the government to take this to the highest court in order to be sure that all the points have been assessed and covered by the very highest courts in this land, in other words, the Supreme Court. But in terms of what he said, yes.
Resuming debate, the honourable member for Port Moody, Coquitlam.
Thank you, Madam Speaker. Bill C-7 is an act to amend the Criminal Code on medical assistance in dying, and is one that I believe was written with the intention of providing compassion to those who are suffering to an unfathomable, unbearable degree of pain by allowing a lawful, expedited termination of their suffering and grant access to dignified death. The intention is kind, and I see an urgency from the government to extend this expression of compassion to those who are suffering beyond comprehension. But, Madam Speaker, from the perspective of a visionary and a lawmaker who cares for the long-term wellness and prosperity of our country, I would like to invite all members of the House to pause and bring into our dialogue the long-term effect of this bill and the impact of this bill on the guiding principles of lawmaking going forward. I do not stand to speak on this bill with the moral authority of one who has reached a point of suffering as those who may be applying for MAID. I don't think most members of the House here have the personal experience to speak on that level as well. But I do stand here to speak on this issue because there's been a force in my life that carried me through some very dark nights of the soul when adversity, pain, and repeated cycles of injustice were poignant enough to wear down my will from fighting, from trying, and sometimes cause me to question the value of my existence. I've seen this force raise addicts, cancer patients, and those experiencing deep depression from deep pits of psychological paralysis and darkness. This force transcends the distinctions of race, gender, socioeconomic background, etc. It is almost as vital as life itself. It is a force that is central to the existence of the human race, and that force is called hope. While hope is easier for access to some than others, for others it may be almost impossible because their painful experiences choking the light from their vision. As caring individuals, communities, and a nation that prides itself in compassion, it is our duty to turn every stone to help others find hope when they can no longer access it themselves. Hope is a journey that demands an unrelenting search until it is found. We see it with Terry Fox. He is a national symbol of hope because despite his painful struggle with cancer, he made the sacrifice he made with his cross-country campaign for cancer research because he was in search of hope and giving that hope to others. His triumph over adversity story, though his life was tragically truncated at such a young age, still continues to champion Canadians today. As Canadians respond by revering him as a national hero because we value hope, and we've seen the power of hope that compelled Terry to pass the finish line of his last breath. We see hope whenever we see Team Canada send their Paralympians to the Olympics. Many of them have overcome deep physical, emotional, and mental suffering. Their focus, discipline, and excellence have helped them to overcome their challenges. Our nation is built on a foundation that values the sustenance of life and the right to prosper. We invest millions of dollars every year on first responders, medical services, infrastructure, and laws to protect the survival, sustenance, and prosperity of the people. But expediting the administration of death is counterintuitive to the inner reach for hope in the human condition. Our very Constitution is founded on the principles of the value of human life, the prosperity of each human being, and each one's access to an opportunity to flourish. While deep with the intentions of compassion and the appropriation of dignity, intervening with easier access to MAID opens a door to a very complicated path of further suffering, even for those who live on. I'd like to bring to the attention of the House the story of a man named Alan Nichols from my province of British Columbia. As reported by CTV this past September, his family has stressed that Alan struggled with depression and should not have qualified for assisted death. Alan's brother Gary told CTV that he didn't have a life-threatening disease. He was capable of getting around. He was capable of doing almost anything that he had to do to survive. Like many Canadians, Alan's life was altered dramatically when his father passed away, especially since his father had been so involved in his life. His father's death made him particularly vulnerable, and he stopped taking antidepressants and became more angry and isolated, not going into public, not seeing anyone, not eating properly, as Gary described it. Alan's family knows that he rid his home of furniture apart from a bed and a chair, and that he would refuse medication and food because of his depression. Another disturbing aspect to Alan's story is that despite his family's attempts to be involved in his life and an advocate for his life, they report that the hospital staff would not share information with them and shut them out from hearing the key facts. There's more to this story, and I'll just leave it there because this is accessible. But the point that I would like to illustrate here is that this is a very complicated issue, and it's one that touches on the chord of something that is so deep and necessary to our existence and to our country, and that is hope. And because of the irreversibility of death, there is little intervention that can be done afterwards when hope is terminated, because there is no breath to receive the assistance of hope thereafter. So rather than be in a rush to legislate this bill, I believe we should focus on tackling things like the epidemic of suicide among the First Nations communities, among the youth, or giving Canadians better access to mental health care, so that Canadians will have greater access to hope when faced with situations of suffering as those who are suffering so much that they would consider made. Until there are enough measures to show the flourishing of hope and human prosperity to counter a potential culture of death from capturing our nation, if we are to be too swift and lenient in our decisions surrounding issues of death. It pains me to watch others to suffer, but it also pains me to think that as lawmakers, our focus is on expediting access to death rather than expediting access to hope. Madam Speaker, my statement in the House today is to inspire all members of the House to not only consider the dignity of the suffering who are seeking their release through death, but the dignity of existence and human prosperity for the long term. Removing the mandatory 10-day waiting period reduces protections for vulnerable members of society. The government's original legislation, Bill C-14, went through extensive consultation. It is scheduled for parliamentary review this summer, and I would ask the Liberal government to respect the process and allot the review to proceed rather than rush this very sensitive and complex issue into legislation. Let's give this time, because death is irreversible. And Madam Speaker, I've decided to look at this bill through a filter of hope and preserving the culture of hope as being a force that guides the laws we make not only today, but for decades and centuries to come. Therefore, I stand today in the name of hope and invite my colleagues across all aisles to examine this bill through the lenses of hope and preserving hope in our country. Thank you.
Questions and comments? The honourable member for Humber River Black Creek.
Thank you very much, Madam Speaker. And I want to say to my colleague, applaud her courage and recognize that every word that she spoke today is probably the same words that I think all of us as parliamentarians have spoken about, because hope is eternal. Hope is what gives us all the energy to do all the battles that we have to do in our own lives and in our families' lives. And we must never eliminate that hope that people want to have for various ways in their lives. When we dealt with this bill previously, it also was an amazingly complicated, as my honourable colleague mentioned, It was probably one of the most difficult issues in my 20-some years as a parliamentarian that I had to deal with. But by listening to people, like my colleague and to others, you try to find the way that reflects the feelings of so many people. In investing more money, in making sure that there are programs that offer hope, whether we're talking about mental health or palliative care or so many other different avenues, is trying to ensure that everybody has hope, that they don't want to give it up, and that we have given them every opportunity possible to access that help. I'd be interested to know from my colleague if she feels that there is still a tremendous lack of those services in the areas that she represents.
Or Port Moody Coquitlam.
Thank you. I appreciate your compassionate remarks. I'm very emotional right now because obviously it's a very important issue, I think, for everyone. And in some way or another, we're all impacted by it. I believe that having spent time in the front lines, whether it's in my area where I represent or anywhere else in Canada, there is a lack of access to counseling and mental health care that, as I mentioned in my speech, would give tools to Canadians to work through their struggles and their adversity and their pains to again, access more hope before moving in the direction of medical assistance in dying. And I understand fully the implications of compassion that this legislation, piece of legislation is wanting to present. But because of the irreversibility of death, I feel that time is needed and that all those other areas, it is, I think, preventatively and for the long-term future of our country, that those must be dealt with greater care and time.
The commentaire, questions, the Honourable Member for Timmins James Bay.
Speaker, I want to thank my honourable colleague for a beautiful speech. We don't hear the word hope very often in this place, and it's something that's very important. I would like to say 2 points. One is that death is hard. Death is very hard, but it doesn't mean it's not without hope. When my sister died, it was brutal, it was unfair, but it was life, and we brought her up in the old Celtic way with the singing and the celebration, because that's what we do. And there is hope in that. And hope has to be about compassion. Hope has to be about doing what's right. But I'd like to ask my honourable colleague, because she said it just in passing, about the lack of action on the horrific suicide crisis we're facing. That year in, year out, we are losing hundreds of young people. I lose young people in my region all the time. And it never seems to be a priority. And when I hear the Prime Minister talking about losing patients, I think of the patients that's been lost in children as young as 9 and 10 and 11 who don't even believe this country cares about them enough that their lives are worth living. I'd like to ask my honourable colleague what she sees we could do to address the horrific hopelessness that's in so many young people that are giving up now.
Brief answer from the member from Port Moody Coquitlam.
I so appreciate the comment that the member made just now. I think there isn't further, first of all, there needs to be more dialogue and long-term solutions that are thought out, but we need action. We can't just have good intentions. We need to put it into action. So I look forward to opportunities to working with anyone across the aisles on trying to bring more action in helping to take care of our youth in relation to suicide or mental health issues. Thank you.
Please do débat, resuming debate. The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. I rise today to address a very important piece of legislation, and in looking at it and thinking in terms of what it is that I might say, I couldn't help but reflect in terms of the previous debates that we had in the process in the development of Bill C-14, which kind of led us to the point where we are today. And, you know, if members really want to get a good sense of just how thorough that debate was and the discussions for those that were not here back then. I would really recommend that you take a look at some of the comments, whether it was in the standing committees, the many lead-up discussions that had taken place to that, the many different presentations that were made, and even the pre-study that was actually conducted. I really enjoyed listening to the debates back then because, like the member that had just spoken, we heard a lot of personal stories. And when people ask me, one of the things that I enjoy about being inside the chamber is the different types of debates that we actually receive. And for those that are observing the debate today, these are the types that I personally really do learn from and appreciate the stories that come before the House, because quite often, Madam Speaker, this is the type of debate, like we are all concerned about protecting the vulnerable individuals in our society. At the same time, I think it is important that as legislators that we have a role to support the eligible person to be able to seek medical assistance in dying. And it is a very difficult issue. I think that a good number of us felt in the passing of C-14 that we had something really that was going to advance us and move us forward. Even during the height of that discussion, there was a feeling that, in a number of years, we should, in fact, review it, take a look in terms of what has transpired in the previous years, and we are quickly getting to that point. But last September, there was a Superior Court in Quebec that made a determination. And as some members across the way in the Conservative Party say, well, maybe we should have appealed that particular decision. I respect that opinion, Madam Speaker. I don't necessarily believe that would have been the best direction of the government. The direction that we have chosen is to make some changes to the current legislation in hopes, Madam Speaker, that we will better serve Canadians by doing that change now. Now, having said that, once we get into those summer months, there's going to be a great deal of discussion because it was mandated. I would like to extend, like when I think of the C-14 debate, and I'm going to provide some of my own personal thoughts on the whole issue of palliative care, but what I would really like to see us talk a great deal more about is the issue of mental illness. And that is something that I am hoping that when we do that comprehensive review, that we will incorporate that along with palliative care, Madam Speaker. These are two areas, and I'm sure that I am not unique, that all 338 members would concur. When you think of healthcare in Canada, there is a couple of issues that come time and time at our doors, and that is the issue of mental health care services and palliative care services. And this is something in which, I used to be the healthcare critic back in I guess it would have been 15 years ago in the province of Manitoba. And we didn't have the same sort of dialogue that we hear in the last number of years on those two critically important issues. I think it was British Columbia many years ago that actually elevated the issue of mental illness and made it a separate ministry. So you had a minister of health and a minister of mental health illnesses, Madam Speaker. I believe it was BC that actually had taken that very strong, tangible action. The point of me saying that is that more and more provinces are aware of the issue and the importance of mental illness. The government of Canada has substantially, and we could go into literally hundreds of millions of dollars over the last number of years and continuing to invest in mental illness across the country, along with palliative care. So I think that we are on a very strong footing when we look in terms of where we are today. And you need to reflect on what brought us here, the many different consultations, literally thousands of people that were engaged, the many hours of debate and dialogue that had taken place. Again, you could probably get into the thousands. I don't know for fact on that point, Madam Speaker, but I'm sure that if you take a look at it between the committees that met prior to Bill C-14, during second reading of C-14, the amount of consultation with Canadians in all regions of the country, and the responses that we received via all sorts of mediums, that you're talking about literally hundreds of thousands of Canadians in virtually all regions of our country have been able to weigh in on this issue. Advance it to just January of this year. Again, we've had consultations, roundtables that have taken us in the different regions of Canada. I believe there was the survey, and that's been referenced already today on several occasions, and where there was approximately 300,000 Canadians that got engaged in that particular questionnaire survey at the beginning of the year. And I don't know if we have all of the results that have gone public to date, Madam Speaker, but I trust those individuals that helped formulate the legislation that we're debating today have done their homework in terms of that consultations and incorporating in all of the ideas. As I know, the Department of Justice and the Departments of Health are following this debate, listening to what members have to say, Madam Speaker. And to those individuals, what I want to, from a personal perspective, to be able to emphasize, based on the experiences that I have garnered over the years, Madam Speaker, is that there's really, for me, two concerns that I want to express. One with regards to the issue of healthcare services, and the other one dealing with the legislation itself. Let me expand on both points. When I think of healthcare services, and if you were to ask Canadians as a whole what makes them feel good about being Canadian, you will often hear, and I suspect it's probably number one, is our healthcare services. And when I think of the healthcare services, I made reference to the medical, mental health illness and palliative care. I have had the personal experience of being able to witness firsthand the evolution or the changing of palliative care. When I had my grandmother and in the St. Boniface Hospital, and many of our hospitals in the country have palliative care sections in them. Many of them will have the paneling of seniors in particular. Seniors that can't get the type of quality care that is necessary in the personal care home facilities or supports in their communities in homes, so they end up being in hospitals and they would actually be paneled. And often many of those will go into that palliative care section because there is no palliative care units that are really designated as palliative care healthcare facilities. So they end up in those hospital situations. My grandmother was one of them. And it was terminally with cancer. And in that situation, Madam Speaker, we watched as the weeks went by, and obviously family members come and so forth, and it was very difficult on the family. We had a very special relationship, as we all do with our grandparents. Many of us wondering why it is that she had to be in a hospital facility, where you get, even though it was kind of sectioned off from the emergency and the other aspects of hospitals, but there was still, you're going into a hospital, and it is a different type of a situation. Not necessarily the most comfortable. Now,
ultimately, my grandmother passed. And then a number of years later, Madam Speaker, I had the experience, the personal experience, of being there for my father in his days prior to his passing, and where he had to go from home into a hospital. And we were very fortunate that we were able to get him into the Riverview Health Center. And in that center, that feeling that you get the type of care and in the large windows, a beautiful atmosphere, the type of care is very, very different. And when I reflect on that, and I was there at the moment of my father's passing, and we had the discussions, a number of days prior, where he was in fear of what was going to happen because he witnessed what had taken place with his mother, my grandma, at the St. Boniface Hospital. And he didn't have that choice, but we talked about that, having that choice. And I think, knowing my father, that he would have been very happy with the way in which ultimately he had passed. And I really attribute, the treatment, that world-class treatment at that particular facility. And I kind of wished that my grandmother would have had the same sort of atmosphere. It's not to take away for the super fantastic work that those healthcare providers and others did at the St. Boniface Hospital, Madam Speaker, but it was a totally different atmosphere. And that's why when I listened during the C-14 debate that we had, we heard many stories of the one that we just heard from the member opposite. And they're very touching, and they are compelling. And it makes you want to say, well, what can we do here in Ottawa to ensure that we have the quality of healthcare services, the best that we can possibly provide. And it's one of the reasons why I'm very passionate on the issue of that national framework. That it doesn't have to be, a system where you have this in British Columbia as a system, this in Atlantic Canada or in the province of Quebec or some provinces that don't have the same economic means or the same sort of treasury to provide the type of service that we should be. And this is where the national government does have a role to play. So when I listen to comments inside the House in regards to what it is or where it is that we might want to go from here, or concerns, very serious concerns about the current legislation, I would really suggest that we reflect in terms of what it is that we're going to be able to potentially do in the coming months. When we have the opportunity, because unlike, at least in the Manitoba legislature, I would argue that our standing committees can be exceptionally effective. It is truly amazing in terms of just the type of authority and the ability and just the participation that we can witness if, in fact, we're prepared to park our partisan hats at the door and try to do what's best for Canadians on this issue. And if we can take a look at what had taken place in regards to C-14, there's absolutely no doubt in my mind that we can do that. If members listen to the previous speaker, you get a sense of what was taking place when we had the debates in here on C-14. I would encourage, whether it's the Health Standing Committee or whatever it is that we come up with collectively, and there is going to be representation from all the parties, why not maybe even take into consideration of the possibility of taking it outside of Ottawa, Maybe look at the different regions. See what some of these other provinces are doing. Maybe even tour some of the palliative care facilities, Madam Speaker. Because there is a great variance. We need to look, if I reflect on the province of Manitoba, we should take a look at what's happening in Winkler, Manitoba, Flin Flon, what's taking place in the city of Winnipeg. Take a look at the difference between the Riverview Healthcare Center versus what takes place in the Seven Oaks Hospital. Where and what role can we play as a national government to ensure that we are maximizing the benefits of providing the type of palliative care that Canadians expect and deserve, given the limitations that we actually have? And it's only the national government that can do that, Madam Speaker. And I would suggest to you that it is going to be in a very important role. We just had what many would say we tabled the annual, the Standing Committee on Trade earlier tabled the CUSMA deal, the trade agreement between Canada, United States, and Mexico earlier today, and many of the members were taking some pictures of that particular committee, feeling very positive in terms of what it is that they've been able to accomplish. My challenge to that health committee, if that's going to be the standing committee, is to take that role very seriously in terms of the potential life-changing report that you can have for Canadians. I truly believe that the will be there to support what it is that committee is hoping to be able to accomplish. And I believe it's just as significant, maybe even more important, than the report that we had tabled today from the Trade Committee, which was supported, from what I understand, earlier today, unanimously by all members of this House. Because if you listen to the speeches even thus far, I don't think that there's anyone that would dispute what I have said, Madam Speaker, in regards to it. Now, I wanted also, but you've told me I only have 2 minutes, Madam Speaker, which is really hard to believe. I wanted to, the same principles that when I talked about palliative care, we need to take a look, that standing committee, I really encourage in the strongest way I can to take a look at the mental illness issue. That is such a critically important issue. Ottawa needs to play a stronger national leadership role on that. So hopefully that'll happen, Madam Speaker. But because of time, I'm only going to highlight maybe just a few very brief points, Madam Speaker. The proposed amendments would allow for a waiver of final consent for persons whose natural death is reasonably foreseeable, in the sense that who have been assessed and approved to receive medical assistance in dying, who have made arrangements with their practitioners for a waiver of final consent in certain situations because they were at risk of losing decision-making capacity for their chosen date to receive MAID. I also want to highlight the government is very much aware of the concerns about increased risks where MAID is provided to persons who are not dying in the short term. The bill therefore proposes additional safeguards that would apply where a person's natural death is not reasonably foreseeable. These new safeguards aim to ensure that sufficient time and expertise are devoted to exploring requests for MAID from persons whose natural death is not reasonably foreseeable, and that such people are made aware of the seriously and consider available means of relieving their suffering. Madam Speaker, I did want, because I make reference, and this is a really important part to me, maybe I'll do it in a question and answer. Thank you, Madam Speaker.
Questions et commentaires, questions and comments. The honourable member for, oh my God, I'll get there. Flamborough Glenbrook.
Thank you very much, Madam Speaker. I appreciate the opportunity to be able to address my colleague across the way. I don't often take the chance, but I'm going to take the chance right now and say that I'm speaking for much of my colleagues here on this side of the House in regards to the strategy that the government is taking on this important issue of medical assistance in dying. And that is that in 2015, and just to remind those who are watching that that's five full years ago, the last election, they made a commitment that they would invest $3 billion in palliative care to make sure that palliative care across the country was as available as medical assistance in dying. To date, they have not fulfilled that commitment. And that's the problem that we have with modifying the medical assistance in dying, is that the people who would like to have palliative and hospice care to be able to feel loved all the way through to the end of their life with the assistance of some medicines that would relieve their pain don't have the capability of experiencing that, and they should have equal rights as well as those people who want medical assistance in dying. Why haven't they delivered on their promise, and why won't they commit to that today?
Here, here.
The Honourable Parliamentary Secretary.
Well, a couple quick points on that matter, Madam Speaker. First, I wouldn't necessarily concede to the member in terms of the commitment that he's referenced. I do know that there has been record amounts of, historical amounts of money, cash transferred over to the provinces to deal with health care. And we're talking historical numbers of dollars that have actually flowed to the provinces. Now, I can also indicate that a significant percentage or a significant amount has actually been allocated for palliative care. The actual dollar figure I really couldn't say, but let me, on the second point, pick up on the first point and try to alleviate the concerns that the member has. And that is, when I talked about the importance of the committee going forward into the summertime, that I think a part of that discussion and that study should be taking into consideration what sort of financial role Ottawa could be playing in order to support. As I say, we want to make sure that there's a sense of equity amongst the different provinces. So I think a part of that study that we are going to be having in the coming months, Madam Speaker, needs to take into consideration the whole issue of the costs of palliative care too.
Questions and comments, questions et commentaires. The Honourable Member for South Okanagan West Kootenay.
Yeah, thank you, Madam Speaker, and I'd like to thank the member for Winnipeg North for his speech. The NDP is, in general, fairly happy with this new legislation because it fixes some of the real problems the original legislation had that we debated and passed in the last Parliament in reaction to the Supreme Court ruling. And the Liberal government at that time ignored some very important parts of that Supreme Court ruling and just forged ahead with its own version of what they thought was best. And here we are, 4 years later, redoing everything. And I wondered if the member could comment on that. Shouldn't we have done it right the first time and not put all these people who are suffering so much through that additional duress for these past years?
Parliamentary Secretary.
Yes, thank you, Madam Speaker. As the member knows, that whole debate process and the ultimate passage of C-14 in its state back then received, I believe, unanimous support from the House. And there's no doubt that during that whole dialogue, there were some differing opinions. And the government at the time genuinely felt that that was the best way to proceed. Some wanted the government to go a little bit further. And it's one of the reasons why, even back then, we recognized that this was the type of issue, given the very nature of the legislation, that we would want to come back. So even if the Superior Court in Quebec had not made the ruling that it did back in September of last year, Madam Speaker, this House would have been reviewing the process. The decision by the Superior Court of Quebec allows us to be able to speed up on something ruling, a very important issue, and that's why the government has chosen to bring forward this bill. But I do believe that even once this legislation passes, and it might change to a certain degree, we'll wait and see what happens once it gets into committee, even at the conclusion of this particular bill, we're still going to be seeing this future study, which is a good thing.
Questions and comments, questions and commentaires. The Honourable Member for Montcalm. L'honorable député de Montcalm.
The Honourable Member for Montcalm. Thank you, Madam Speaker. The Parliamentary Secretary made a very interesting speech. We have to keep our focus on what is our jurisdiction and the objective of the court ruling. We have to transform the criminal code, even though I share his concerns with respect to proper palliative care. We have to have access to it. But palliative care is not in the criminal code, and it's not federal jurisdiction. Does he not agree that one of the solutions to increase palliative care and access to this care so that people who need it and who wouldn't be relieved by palliative care should have access to made, but the solution would be first and foremost to accept requests of all provinces and the Premier of Quebec to increase health transfers to 5.2%.
Yes. Well, Madam Speaker, I do believe that it is important that the Government of Canada, no matter what its political partisanship is into the future, should always provide financial support for healthcare across Canada. But a part of that also includes recognizing that the national government has a role to play to ensure that we have the Canada Health Act being implemented, that we look at areas of healthcare like mental health, like palliative care, and there's, I think, an expectation of Canadians that the national government is doing that. I'm glad to say that we have today a government that is working with the different provinces in order to try to support where it can at ensuring that we deliver good quality healthcare services from coast to coast to coast.
Questions and comments. The Honourable Member for Battle River Crowfoot.
Thank you very much, Madam Speaker, and I appreciate the comments that my honourable colleague has made. First, one point is it seems like this bill goes far beyond the scope of the actual court decision. But my question is about, and that's a big concern, but my question is about the consultation period. There was a tremendous amount of response, and I know I had dozens and dozens of constituents that wished to get involved, but for one reason or another, they were unable to actually participate in the consultation process. So I would ask the member why the consultation process was so limited in the way that was, both in terms of time, only online, and the many challenges that I think have resulted as a part of what was, I think, an inadequate consultation period on such a serious issue.
The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. I can assure the member that thousands, and if you factor in the surveying and the questionnaires that went out, I believe it was well over 300,000 Canadians have participated in one way or another directly. But there is also, we've seen roundtables, consultations in every region of the country, taking a look, everything from provincial governments to disability groups to doctors to nurses, and of course, just the feedback that MPs are bringing back. We still also have the Standing Committee, and I can assure the member that there will be, good discussions, healthy discussions, and as I am being approached by constituents, I'm sure that we all are being approached by constituents, and I think that at the end of the day, we still have another consultation that's going to be coming up to take an overall review of everything.
Comments, the Honourable Minister for Diversity, Inclusion and Youth.
Thank you, Madam Speaker. Madam Speaker, I really appreciated the words from the member from Winnipeg North and the great work he does in this House. I appreciate him also referring to the previous debate, and I know his time often feels limited in this chamber, and I know he had one more point to make, and I would be pleased to be able to hear that point. Thank you, Madam Speaker.
Please, the Honourable Parliamentary Secretary.
And I thank the member. very much for that, Madam Speaker and Minister. The point that I wanted was in regards to just to permit the waiver of requirement to give a final consent in specific circumstances. Just very quickly, persons whose natural death is reasonably foreseeable, who has been assessed as an eligible for MAID, and who are at risk of losing capacity can make arrangement with their practitioner in which they provide their consent in advance, which allows the practitioner to administer MAID on a specified day, even if the person has lost the decision-making capacity. Now, there are some other issues related to that, Madam Speaker, but I thought it was just a very important thing to get on the record. Thank you.
Resuming debate, the honour member for Bertie Masquinongé. Thank you, Madam Speaker. To begin, I would like to say that I'm going to share my time with my honourable colleague for Shefford. The debate right now has to be held in great dignity and serenity. We need to set aside partisanship. This is a serious issue, and our decision will have a major impact on the lives of many Canadians. Perhaps one day, we all will leave this world one day, so we may need MAID. But what is sad in this whole story, as a society, given previous decisions made here in the Parliament, cause people who are suffering to suffer more. People who are facing serious disease have to appeal to the courts to have their fundamental rights respected. Worse still, some people had to go on hunger strikes to have access to MAID if they wanted to fulfill the reasonable foreseeable death criteria. Do you realize what we've asked these patients who are suffering? Given they have to deal with immense suffering every day, both physical and psychological, serious people who are seriously ill had to turn to the courts to look at reasonable foreseeable death. And there were many barriers, and there were unreasonable delays. And this is a real obstacle course these people had to go through. All of this because we decided in the place of those who were ill. We did not make informed decisions and respect these people's freedom. Sitting in this House is an enormous privilege that comes with tremendous responsibility. We have to rise to the responsibilities, and so I'd ask all members of this House to not falter. Many people who are ill had to face the system to receive an informed decision. The Superior Court of Quebec made a clear decision, and we have to respect it and implement it. And we have to look at this further in committee. The Baudouin decision in favor of Ms. Gladue and Mr. Truchon, it says that the court clearly concludes that the requirement for reasonably foreseeable death infringes the rights and the safety of Ms. Gladue under Section 7 of the Charter. We have to look at these lines, Mr. Speaker. We're talking about the freedom to choose. Who should choose in their place? So I would warn us against the temptation to think of ourselves. We shouldn't just vote in view of our own beliefs and personal beliefs. We have to give people the freedom to choose. And the basis of this judgment, which was obtained after quite some time, was very clear. We're talking about rights and freedoms. No one should be able to choose for someone else. We have to get rid of barriers so that everyone can live their last moments of their lives as they choose, free, without barriers, without, of course, protecting the most vulnerable individuals of our society. We do need free and informed consent, informed by offering them all the possible options and free from any undue pressure. This bill is a step in the right direction. It does include important provisions and other aspects that need to be studied. People who suffer from mental illness, for example, well, this is a cautious approach. It's a very complex issue and requires greater study. So we cannot decide on this right now. And that is why we need to study this issue properly. We also have to look at the whole question of advanced requests for people who are diagnosed with an illness that could hamper their ability to make a decision in the future. And these are very delicate issues that we have to study very cautiously, and that's why we can't include them right now. But this bill generally targets people who are ill with degenerative diseases to have access to MAID, whether their death is reasonably foreseeable or not, except in the case of cognitive or degenerative diseases I mentioned. So reasonably foreseeable death. So we're talking about getting rid of the 10-day waiting period. There has to be a written request for services. So getting rid of the 10-day waiting period can be allowable if the person made arrangements with their practitioner to renounce the final consent because they may lose their making ability if the disease progresses or if they take certain medications to relieve their pain. So if their pain, even with care, can be relieved, the patient can renounce their request. So this measure will allow the person to extend their period of life with some quality. People shouldn't ask for a MAID too quickly if they're afraid to lose their capacity to do so. For people who are not facing reasonably foreseeable death, a 90-day delay period is necessary between when MAID is requested and when it is delivered, unless an evaluation was done and the person is about to lose their capacity to make a decision. So we need to look at this whole reasonable delay period. Who is able to guarantee that 90 days is enough for some people? Who amongst us is able to say whether a 90-day period would be a much too long period for some people to wait, could be a living hell for them? Who can look at how this delay period should be applied? No one, Mr. Speaker. No one can say that. And that is why this provision and this entire legislation needs to be implemented in a very intelligent fashion. The practitioner is the best person to deem what is right and what is not. In cooperation, with cooperation and by listening to patients and human treatment of patients is necessary because the patient themselves should be the priority. Their well-being and their dignity must be the priorities. So, Mr. Speaker, I would remind everyone in this case, this is a question of dignity, but most importantly, about rights and freedoms. Every individual, when they arrive at the end of their lives, should be able to make a choice. And this choice, Mr. Speaker, is up to the person themselves. Let us not impose our own values, our own viewpoints, and simply let's provide a framework for the practice of MAID in a just fashion. Let us respect everyone's personal freedoms. This is fundamental, and I would ask all parliamentarians in this House to realize the great responsibility that is entrusted to us. We have the destiny of hundreds of millions of people in our hands, and we're looking at the suffering of these people at the end of their lives, but also we are responsible for the suffering and the concerns of their families. It's atrocious to see someone who we love suffering and to feel powerless to help them. Sometimes there are personal choices that some people may wonder about. But as I said earlier, the question that you have to ask yourself, that we have to ask ourselves, is what can we do to reasonably provide a framework for this legislation that is very complex? And what can we do to allow people to have free choice? Thank you very much.
Commentaires, questions and comments. The Honourable Parliamentary Secretary.
I'd like to thank my honourable colleague on the other side for his remarks. And I have a couple of questions. We've heard many speeches today. We also heard several yesterday about doctors who can provide MAID. I'd like to know if the member opposite has heard similar concerns to those of the Conservatives, and that is that there are practitioners who are too aggressive, who are putting pressure on patients to use MAID. And I'd also like to hear what he thinks about the fact that mental illness is not covered under this bill. It will be considered. But I'd like to know what he thinks about the government of Quebec that itself decided to study mental illness as an underlying condition. Thank you. The Honourable Member for Berthier-Masquinongé. I'd like to thank my honourable colleague for his questions. They're very relevant. And I'll start with the second one. In terms of mental illness, yes, in fact, the government of Quebec decided to consider this issue more in depth before including it in legislation. So here we have two separate legislative assemblies that have made the same choice. So that's probably an indication that we're on the right path. I think it's a reasonable decision because when something has this great an impact as MAID, then yes, you have to look at it in depth. That's my first answer. Now, in terms of doctors and practitioners, I've heard horror stories, in quotation marks, by some colleagues in this House. But I'd like to point out that the medical profession has a very good framework. And that's what we have to remember here. We need to have a good framework. That's what we need in this legislation. Now, some members have referred to real cases. However, I believe that these cases are often a very rare exception, the horror stories, that is. The vast majority of the medical profession, whether it be doctors, nurses, orderlies, represent people who really are concerned and care about the patient's well-being, and they do want to make sure, they will want to make sure that patients make enlightened choices. However, for a patient to be able to make an enlightened choice, they have to have the choices before them.
The Honourable Member for Cloverdale-Langley City.
Madam Speaker, the honourable member has mentioned, there's much debate has gone on regarding euthanasia back in 2016, which obviously led to the current safeguards. And unfortunately, there has been absolutely no significant enforcement against infractions, and the safeguards are regularly ignored. And I have an example from the town hall that I mentioned earlier that I held. A constituent in my riding had a personal experience. Young married father with children was diagnosed with terminal brain cancer, 12 months to live. And he suffered depression, went to a psychiatrist, and the psychiatrist offered him MAID. He immediately stopped going to that psychiatrist. What I would like to know is why would we loosen the safeguards, which are clearly not working in the first place and seem to be completely impossible to enforce?
The Honourable Member for Berthier-Masquinongé. I'd like to thank my esteemed colleague for her question. It's also a very relevant question. And in fact, this is why I said earlier that we're going to have to make sure that there is oversight in this legislation. But here we're not talking about euthanasia. We're talking about medical assistance in dying. And I think these are two distinct things. But we will need a framework. Yes, we do need one. And what I would add to that is this. That's why we also have to take an appropriate amount of time to consider this in committee. And I would invite my colleague to raise these points in committee so that they are considered fulsomely, and to invite witnesses, perhaps even the people she heard, to come and testify so that we can shed more light on this. Thank you.
Very, very brief question from the member for Victoria.
Thank you, Madam Speaker. I first want to thank the member across the way for his speech and particularly for highlighting the responsibility that we as members of parliament have in our choices, and that we have a responsibility to reduce suffering, but also to ensure that people aren't ending their lives before they want to, and that Audrey's amendment really gives people the opportunity to live longer and to make the choice. But I wanted to ask specifically about the 90-day requirement for that second track and the potential that it has to prolong people's suffering.
The Honourable Member for Berthier-Maskinongé, 10 seconds. I'd like to thank my colleague for her question. Well, that's why I spent several minutes on that point, that is, the 90 days, because given how complex this decision is, I think it's important to have in the legislation some flexibility for practitioners. Resuming debate. I'm sorry. The Honourable Member for Shefford. Thank you very much, Madam Speaker. It is with great humility that I rise today to speak about Bill C-7, an act to amend the Criminal Code, medical assistance in dying. For several members, there are very personal stories that have to do with end of life for our family members. Now, I would like to speak in my remarks about the work on the Bloc Québécois, work by the Bloc Québécois on this. I'd like to talk about medical assistance in dying in Quebec, and I'd like to talk about seniors and women who came to speak to me. Now, let's talk about the context. In 2019, the Superior Court of Quebec heard Ms. Gladu and Mr. Truchon and ruled in their favor. They said that MAID is too restrictive in both the federal and provincial legislation. The criteria had to do with the foreseeability of death. And the court concluded that requiring reasonable foreseeable death infringed on the rights and freedoms and security of Mr. Truchon and Ms. Gladu. That's guaranteed under Section 7 of the Charter. And actually, that section was quoted by Christine Baudouin in her ruling. I'd like to highlight the incredible work of the member for Montcalm in the Bloc Québécois. He said that lawmakers did not do all the work under C-14, and therefore we have to make sure that people with an irremediable and serious disease have access to medical assistance in dying and should not have to turn to the courts to have their rights upheld. We feel, however, that we have to be very cautious when we're talking about mental health, and that's why we are pleased to see that mentally ill people have been excluded from the medical assistance in dying, because this needs further consideration, study, and consultation, which will be done, among others, in the Standing Committee on Health. And now, in my second part, I would like to talk to you about the Quebec situation. In Quebec, we had the first legislation on this issue in Canada. There was a committee where all parties unanimously agreed on legislation. This legislation was adopted in Quebec. It was working in Quebec, and it has actually been seen as a model elsewhere, including in British Columbia. There was considerable research and consultation amongst patients, citizens, and doctors. 79% of Quebecers support medical assistance in dying, and 68% of people in Canada support it. And when political parties unanimously acknowledged the legislation that was being brought forward in 2015, because this is important for Quebecers. It was very important for Quebecers who participated in the debate. And they were courageous enough in 2009 to bring forward this legislation. I think Quebec really has paved the way in this area, and it has done so in the best way possible, in a nonpartisan, democratic way. Now, I'd also like to talk about a meeting I had as critic for seniors and the status of women. When I met with people, I listened to their concerns about this. And in 2018, 2019, one of these associations wrote about medical assistance in dying and said that it's a quality of life issue. Some people do not want to have to suffer right through to the end. And they listed the amount of criteria they have to meet. People want to be autonomous, and it can actually be reassuring. It can allow people to approach death more serenely. The criteria, having been so restrictive, has meant that people have lost hope. And that is not acceptable. It is not acceptable for people, for example, who have degenerative diseases, who are suffering in their minds and their bodies, and they don't have access to medical assistance in dying. Many individuals are not eligible because of the federal legislation that was imposed because of a court ruling. There are Quebecers who have degenerative diseases, and yet they have to turn to the courts to be able to end their suffering. In February 2015, the Supreme Court struck down 2 sections of the Criminal Code that prevented practitioners from providing medical assistance in dying. And in the Carter ruling, adults who were competent enough to be able to make a decision were allowed to have access to medical assistance in dying if they have a serious and irreversible disease. The criteria were fairly broad, but in the Canadian legislation that came forward, reasonably foreseeable was added, which excludes many, many individuals who are suffering physically and morally, who are in agony. Everything has been based on the degree of suffering. However, we need to take into account the decisions of the person who is sick. There are people who should have access to medical assistance in dying. There may be people who are not able at the end of their life to make that decision. This legislation only affects people who are able to provide enlightened consent right to the end, which means that there can be tragedies and cruelty for those who are suffering for years. The association that I spoke to also spoke about the Parker case. A video was provided, or that we saw, of this person in which the person said she wanted to be able to get to Christmas, and she wanted to have the choice of a peaceful death, a painless death. The Bar of Quebec believes that legislation should be modified to take into account the Parker ruling, because people should not have to shoulder such a significant burden. There have been recommendations to allow practitioners to provide medical assistance in dying to those who are not able to express their consent at the end, especially those who have various types of dementia, for example, Alzheimer's. And that is why the group I spoke to is asking that medical assistance in dying be based more on the rights of individuals and the respect of their wishes. In terms of foreseeable death, they are asking that reasonable foreseeable death be removed from the criteria. And they are asking that informed consent be able to be given earlier on. They're asking that advance directives be able to be provided and that they be able to be recorded. Today, this debate shows how important it is to act so that those who are suffering from incurable diseases be not obliged to turn to the courts to have their wishes respected and to have access to MAID. We have to provide the best continuum of care to these people so that each and every person be able to die with dignity, Let us act now.
Questions et commentaires, questions and comments. The Honourable Minister for Diversity, Inclusion and Youth.
Thank you, Madam Speaker. I support much of what the member opposite said, and I agree that this bill, should be sent to committee so that members can consider it in greater depth. I would like to know what advice she would give to people who are concerned about this bill or even against this bill. The Honourable Member for Shefford. Thank you, Madam Speaker, and I'd like to thank my colleague for her question. Well, I think these people have to be listened to. You know, if there are concerns, we have to be able to bring those concerns to committee. Next week, I will be meeting a group in my office. They are concerned, actually, about this bill. I'm going to listen to them. We have to listen. We have to reassure. I think we'd agree that there is a fairly broad consensus about this, however.
Member for Sherwood Park for Saskatchewan.
Thank you, Madam Speaker. I thank my colleague for her remarks. I want to ask specifically about one issue she didn't address, I think, in her speech, and that is the issue of the 10-day waiting period. The existing framework involves a 10-day reflection period, and the value of that is so that a person who's maybe at a particular low point doesn't decide and go all the way through the decision in a short period of time. There should be a mechanism, a time period to ensure that they've really are intent on moving forward with this. At the same time, the existing system already has a mechanism by which this could be waived. So in extreme circumstances, it could be waived, but generally speaking, the 10-day reflection period ensures that someone isn't pressured into it in a short space of time. I wonder if the member would be willing to support the idea of maintaining that 10-day reflection period in order to protect vulnerable people who might be pushed through this decision too quickly.
The Honourable Member for Shefford. I'd like to thank my colleague for his question. However, we think that 10 days is too much in many cases. That is a lot of suffering. And I think that if there's been prior consent, we can find a way of avoiding this 10-day delay that can be much too long for many individuals.
Comments, the Honourable Member for Victoria.
Madam Speaker, I want to thank the member for her speech. Many Canadians know someone who has experienced intolerable suffering, and most Canadians are in support of these changes. I'm curious about one of the pieces, which is that the people will be required to have 2 practitioners and one having expertise specifically in the medical condition that the person has. And I'm curious your thoughts on the barriers that people from rural and remote communities might face given this requirement.
The Honourable Member for Shefford. Well, death knows no borders, Madam Speaker. And we do need to avoid that there are these kinds of hurdles, especially in rural areas. We already referred to this. Any obstacles or barriers like this that get in the way of a dignified death will have to be considered.
Questions et commentaires. The Honourable Parliamentary Secretary.
I'd like to thank my colleague opposite for her remarks, and I'd like to raise a question that was raised earlier on by the member for Sherwood Park, Fort Saskatchewan. He said that there's pressure on patients, that medical practitioners can end up influencing people in their decision-making. Now, we held consultations, and they do not confirm that. So based on those consultations, we don't necessarily agree with that position. I'd like to know if, in Quebec, the member has heard anything about practices on the part of physicians in Quebec. We think that physicians act responsibly, cautiously, and professionally, especially when they're dealing with this kind of subject with patients. The Honourable Member for Shefford. Thank you very much, Madam Speaker, and I'd like to thank my colleague for the question. Personally, I heard more cases of very compassionate physicians who only wanted the best for patients, and they wanted them to be able to end their life in dignity. As a matter of fact, I'd say I've never heard of undue pressure being put on patients. And I think the Hippocrates Oath really also protects many patients from this. I never heard of those kind of cases, and if there were, well, we need to talk about them in committee. But I think we do need to let physicians do their work, do their compassionate work. Resuming debate.
Parliamentary Secretary to the Minister of Labour.
Thank you, Madam Speaker. And I will be sharing my time with the Honourable Member from Pontiac. And I want to start by saying this is a subject that is no doubt difficult for many Canadians watching. This is a subject where you're trying to reconcile your deeply held view that life is precious with the right to liberty and the right for people to make their own independent decisions. This is a place where parliamentarians need to reflect not only on our own values, but on what our courts have said. The Supreme Court in Carter determined that Section 7 of the Charter meant that our provisions in the Criminal Code on assisted suicide were invalid. They said that there was a class of people who were entitled to have assistance to have death with doctors and nurses assisting them. And so our Parliament in 2016 had to move forward with legislation. I had the pleasure of being the chairman of the Standing Committee on Justice and Human Rights at the time, and I listened to witnesses who had a myriad of opinions. I listened to professionals from all sides, doctors, nurses, psychologists, people representing disabled, people representing groups that advocated for the right to die with dignity. And what we crafted, Madam Speaker, was a law that attempted to bridge all of those gaps. We knew, Madam Speaker, that law would not be in place forever. We knew that we as a society and a country would learn from the experiences of that law, and we would move forward with changes. Indeed, Madam Speaker, I was very pleased that the Standing Committee on Justice and Human Rights made some significant changes to that legislation. We carved out a conscience protection for medical professionals, meaning that nobody was obliged to assist with medical assistance in dying if it violated their own conscience or moral values. We said that the law needed to be looked at again 5 years later to look at various classes of people that we left out of the original law: mature minors, people with mental illnesses, and the issue advanced directives where people wanted to make decisions before they declined into dementia. We also required that review to look at palliative care and the palliative care availability across Canada, because the two issues are intrinsically tied together. We don't want anyone to ever make a decision that they needed medically assisted death because they were deprived of proper palliative care. And so, Madam Speaker, that review is coming up, and I know that Canadians across the country will have the opportunity to pronounce themselves on these issues. However, our courts have made another decision. Nous avons eu la cause Truchon.
There was the Truchon decision in Quebec, and the court said clearly that there's a category of people who are entitled to medical assistance in dying under Carter, and the legislation we passed in 2016 prevented those people from having access to medical assistance in dying. And so that limitation in the current act had to be taken away, the reasonable foreseeability limitation. So the purpose of this amendment to the original act is to do away with that requirement and enable people, if they meet all the other criteria, to have access to medical assistance in dying, even if their death is not reasonably foreseeable.
Madam Speaker, because I have not only looked at the court decisions, but I have walked the experience of Canadians over the last 4 years. We have heard of people who have been in great suffering. They are entitled to medical assistance in dying because they meet every other class of the law except that nobody can say that their death will happen in the near future with reasonable certainty. And we have heard from Canadians that fall under that class, partout au Canada,
all across Canada,
that this is unfair. And the courts themselves now, in Truchon, and in a number of other cases where the issue has come up, have hinted at it, that this is unconstitutional. So the government is moving forward to respect the court's decision in Truchon and to remove the death being reasonably foreseeable from the law, but it's also adapting the law to deal with other difficulties that have arisen. We never talked about, Madam Speaker, or if we did, it was rare, the issue of people deciding to prematurely end their lives because they were worried that they would lose capacity at a future date. Nobody should shorten their life because they're worried that a month later they will no longer have the capability or capacity to make that decision under the terms of the law. If it is going to give people an extra 2 weeks, an extra 3 weeks, an extra month with their family, that is what we should do. And therefore the law is being amended to allow people to offer consent to a medically assisted death even if they lose capacity. But it also establishes safeguards. In the event we get to that date and the person indicates that they no longer wish to have medically assisted dying, even if they've lost capacity by any word, by any gesture that's not involuntary, then the pre-consent will disappear. I want to clarify this because it's been talked about a great deal today. This is not an advance directive. This is somebody who already knows exactly what their illness is. They already are suffering from this illness. They're in an advanced state of decline. They have no ability to relieve their pain by medical treatment reasonably acceptable to them. And they have, after being reviewed by 2 medical professionals and declaring before an independent witness, decided that they want to offer consent to end their life on a certain date, even if they've lost the capacity to consent. And I think this is a really, really important change, and I credit the government for doing so. I also want to look at the issue of how we've handled those class of people whose death is not reasonably foreseeable. We have established a 90-day waiting period in that case. We have not made this something that can happen in the 10 days that was previously reflected under the law. And we've done so with due seriousness because we understand the differences and the challenges that the issue poses for people when their death is not imminent. When they, for example, could have a catastrophic event that occurs, and their circumstances change suddenly, and we want them to have a proper reflection period before moving forward with medically assisted dying. But we also understand and have made the exception for those people who may lose the capacity to consent during that 90-day period. I think the amendments to the bill reflect well where Canadian society has gone. Et Madame la Présidente, je veux juste...
And Madam Speaker, I'd just like to indicate that when this act was passed in 2016, there were very few jurisdictions in the world that allowed medical assistance in dying. There was Belgium, Holland, and 5 or 6 U.S. states, and Uruguay. So we were one of the pioneers, one of the first countries in the world to accept medical assistance in dying. So there was a desire to proceed carefully, cautiously.
This new bill, or this new amendment to the original law, takes us to a place that Canadian society has moved to. I think Canadian society, much more than in 2016, today, accepts and supports medically assisted dying because they've watched the practice happen. We've seen the challenges that we have confronted with the existing law, and we have taken steps to improve the law and comply with the Truchon decision. Thank you very much, Madam Speaker.
Questions and comments? The Honourable Member for Cloverdale-Langley City.
Speaker, we hear that the current Liberal government is not aware of any infractions against the current euthanasia safeguards. Well, Madam Speaker, I've mentioned a few today, but I'd like to include also the very, very public story of Roger Foley, who became a national story after being offered repeatedly by his hospital care workers euthanasia rather than suitable home care. So, Madam Speaker, the current safeguards aren't working. So why would we even start to loosen restrictions when we clearly cannot enforce the ones that we already have?
The Honourable Parliamentary Secretary.
Madam Speaker, I believe and I have faith in healthcare professionals across Canada, nurses, doctors. I believe that the great majority of physicians in this country and nurses are dedicated professionals who are doing their job appropriately and following the law. And in those cases that anyone has knowledge of, where a physician or a nurse practitioner has violated the law, I strongly suggest that that member report them to the professional order of their province and to the police, and justice should prevail. I also want to indicate, Madam Speaker, that I clearly agree that for me, medical assistance in dying is a decision of the person, but it is a decision of last resort for me. I believe that palliative care is a priority and everyone should have access to good palliative care in this country.
Questions and comments? L'honorable député de...
The honourable member for Berthier-Masquinongé. Thank you, Madam Speaker. I'd like to congratulate my colleague on his very sensible speech. I'd like to hear more about the 90-day waiting period he referred to instead of the 10-day period. We all are aware that each situation will vary widely in terms of capacity and time frames. We all want to avoid a situation where a person decides to leave this life too soon for fear of losing the ability to consent. So I'd like my colleague to explain what type of flexibility could be built into this 90-day waiting period. The Honourable Parliamentary Secretary. I'd like to thank the member for his question and congratulate him on his speech. In my view, you have to distinguish between people whose death is reasonably foreseeable and those for whom it's not. I think 90 days could be 75 days or 120 days. I think 90 days was a good compromise, but at the end of the day, there's an exception. If the person has all the doctor's permission to get medical assistance, and if the person loses capacity, there's an exception in the law where the waiting period could be varied. I think that's a good step forward. But if there are any amendments, that will certainly be considered by the committee and the minister.
Member for Saulteaux-Kanagan, West Kootenay.
Thank you, Madam Speaker, and I'd like to thank my colleague across the way for his speech. And one of the concerns, I would start off by saying the NDP is relatively happy with this new bill. We think it should have been done this way in the first place 4 years ago. But one of the concerns we have, and this was also brought up by the Liberal member from Beaches East York, and that is that with this new track, for people who are suffering, intolerable suffering, they will have to have get an opinion from a specialist. Specialists are not easily seen in many parts of Canada, rural parts, northern, and these are people at the end of their life, intolerable suffering, and we're worried that this will restrict the ability of these Canadians to have the same medical service that other Canadians have.
The Honourable Parliamentary Secretary.
Thank you very much, and I'd like to thank my honourable colleague for his question. In 2016 at committee, this was suggested, the requirement to see a specialist was suggested by a number of the groups that actually appeared, a specialist in the condition that the person has. And concerns were expressed that two doctors or a nurse practitioner and a doctor that didn't have expertise in the condition wouldn't be able to properly assess the individual, and especially when we're talking about people whose death is not reasonably foreseeable. I don't believe that this is outside the bounds. I think this is a reasonable way to approach the situation, and I believe with video, for example, video conference and consultations, there are ways to reach remote communities and other communities. The person does not have to, I believe, be in the room with the patient.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Innovation, Science and Industry.
Thank you, Madam Speaker.
5 minutes before question period. You will have another 5 minutes after question period.
Madam Speaker, and I'm pleased to rise on the topic of Bill C7 as we embark on what I expect is going to be quite a lively and passionate discussion about issues that an issue that Canadians care deeply about. And certainly my Pontiac constituents, I heard from them for several years on this topic, regular correspondence, regular discussions at the door, and so I appreciate this opportunity to discuss certain aspects of our government's proposed changes to the federal made legislation. And I think it's timely to share some of the insights from 3 important studies on very complex and sensitive issues that were not included in the 2016 federal legislation. These are requests by people for whom mental illness is their sole underlying medical condition, advance requests, and requests by mature minors. Now, hopefully I'll get to all 3 of them. I may only get to the first 2. When Bill C-14 was debated in 2016, parliamentarians had difficulty finding common ground on how to address these types of requests within Canada's first assisted dying regime. Understandably, given the challenging nature of these issues and the limited time that was available due to the Supreme Court's timeline to deliberate on acceptable approaches for Canada, we parliamentarians collectively decided that more in-depth study and review of the evidence was needed. The legislation in 2016, therefore, included requirements for the government to undertake independent reviews. There were strict timelines set out in Bill C-14, and the studies that needed to be commissioned had to be done within 6 months of the coming into force of Canada's new legislation on assisted dying, and the government was obliged to table the final reports on the studies within a further 2 years. Both of these timelines, Madam Speaker, were met. In December 2016, the government asked the Council of Canadian Academies, the CCA, an independent organization that undertakes evidence-based expert studies, to inform our public policy development and to take on these studies that were required by legislation. And the resulting reports were tabled in December 2018, documenting an extensive review of academic and policy research, stakeholder submissions, and international experience in the 3 subject areas. They also include a broad range of perspectives from relevant healthcare professions, diverse academic disciplines, advocacy groups, Indigenous elders. Essentially, the whole of Canadian perspective was brought to bear. In accordance with the CCA practice, they do not, in fact, contain recommendations. Now, 2 of the reports, one on requests by individuals where a mental illness is the sole underlying condition, and the report on advance requests, have been particularly informative during the development of our government's response to the Quebec Superior Court decisions in Truchon. D'abord, j'aimerais...
I'd first like to address the issue of mental illness. And I would begin that discussion because under the current legislation, very few people with mental illness as their sole source of suffering are eligible for medical assistance in dying. And that is because most mental illnesses do not lead to a reasonably foreseeable natural death. And at times, I will refer to this notion as reasonable foreseeability. That criterion introduces a possibility for people who have mental illnesses being eligible if they meet the other criteria under the amendment. We have heard a number of complaints since the current legislation was passed. It was felt that not enough was done to extend eligibility to people who solely had a mental illness. Many people felt that this issue warranted more in-depth consideration. And knowing that there was very little interest in extending this among psychiatrists and psychologists, as well as organizations representing people with mental illnesses. The Council of Academics report on this point raised a number of difficulties related to providing MAID to people with mental illness. And I assume I will be able to continue later, Madam Speaker. That's right. You'll have 5 minutes after question period to continue your speech.
Statements by members. The Honourable Member for Etobicoke North.
Etobicoke North has been celebrating Black History Month. Black Canadians, their significant contributions to our community and how they have helped shape our history and our country. Today I highlight the work of Marcia Brown, the founder of Trust 15, a youth organization focused on creating a safe place where young people are welcome, valued, inspired, and supported. Marcia, thank you for your vision, tireless work in championing our amazing young people. And to our outstanding youth, know that you matter, your ideas matter, and that we see your smarts, kind hearts, and tremendous talents. Know that there will be challenges as you work to achieve your dreams. There always are. But know that you can achieve anything, and that Marcia and I are here to help you break down barriers and support you in all your efforts. Trust 15, dare to dream your greatest dream.
The Honourable Member for Peace River Westlock.
Thank you, Madam Speaker. Madam Speaker, a new beard and a new look, but we wish the Prime Minister had a new attitude. Albertans work hard and we play hard, and we're proud of overcoming the challenges. The challenges like landlocked resources, cold climate, rugged terrain, great distances from markets, and strict environmental standards. We step up and we work hard to overcome every challenge put in front of us. The Tech Frontier Mine was a project of clear example of Albertans overcoming challenges. It had support of 14 First Nations and met or exceeded every environmental and scientific requirement that the Liberals had placed on it. The only obstacle standing in the way was this Prime Minister and his government. Last week, Tech made it clear that the lack of action by this government led to its cancellation. Now, 7,000 jobs, $20 billion, gone. Mr. Speaker, Albertans are a proud people. We work hard and we contribute to Canada. It's time for the Liberals to respect us, recognize our contributions, and let us get back to work.
For Newmarket Aurora.
Madam Speaker, this past Saturday, I was proud to join my community in Newmarket Aurora in the coldest night of the year fundraising walk. This year, we doubled our goal and raised over $86,000 to help In From the Cold, a local charity that assists homeless and at-risk individuals by providing shelter, training, and transition to permanent solutions. I'd like to congratulate the walkers, the volunteers, the sponsors, and the charities of Newmarket Aurora for making this year's coldest night of the year walk a huge success, and I thank them for the continuous commitment to help the vulnerable people in our community. Madam Speaker, I also recognize that Canadians across 145 communities participated in this annual walk and raised over $6 million. Congratulations to my colleagues in the House who participated in the walk, each in their own ridings. Thank you, Madam Speaker.
The Honourable Member for Lac-Saint-Jean. Mr. Speaker, yesterday we learned that Résolu Forestry had to temporarily close the doors of its Dolbeau-Mistinani factory. Why? Because of this Prime Minister's inaction on the rail blockades. On the other side of the House, they love to lecture us about the middle class, but they really don't understand. When a railway is blocked long enough to close a paper mill that affects the middle class, just like my region, I am angry. I know what it means to be laid off. I used to work in a paper mill until last September, and I experienced this. It isn't easy. It's not just 160 people who are without jobs. We're talking about 167 families from the middle class that are now in a precarious situation. This crisis must end, and I hope that this House will listen to the cries from the Genois, and worse still, better still, it should listen to the Bloc's proposals, because things work out when they listen to us.
Davenport. Mr. Speaker, last week I was part of the Canadian delegation to the NATO Parliamentary Assembly in Brussels. NATO is a multilateral organization committed to global peace and freedom and to meeting security challenges of terrorism and cyber attacks. Canada has participated in nearly every NATO mission since its founding in 1949 and is currently leading the following key initiatives: Forward Presence Battle Group in Latvia, led by Colonel Eric Laforêt. NATO Defense College, led by Lieutenant General Christine Whitecross. Standing NATO Maritime Group 2 until recently, led by Commodore Jose Kurtz. And the NATO Training Mission in Iraq, led by Major General Jenny Carignan. We're proud of Canada's excellent leadership, and note that until the end of December 2019, 3 of our 4 operations were led by women. Mr. Speaker, I saw firsthand how vital an organization NATO is to ensuring peace and stability in the world. We can never waver in our commitment to NATO and to supporting the amazing women and men who step up every day to defend our values, our liberty, and our democracy. Thank you, Mr. Speaker.
The Honourable Member for Markham Unionville.
Thank you, Mr. Speaker. I stand today to join the Armenian community across Canada to commemorate the 32nd anniversary of Somagate pogrom and the 30th anniversary of Baku pogrom. During the waning days of Soviet Union, Artsakh Armenians demanded reunification with Armenia and later the independence of Armenia. In response, Azeri nationalists carried out gross massacres in the city of Somagate and the capital city of Baku. These massacres set a precedent for xenophobia, hatred, and discrimination towards Armenians in Azerbaijan that unfortunately continues to deteriorate and impede the Artsakh peace process. These historic events should act as a strong reminders for Canada that we must continue to defend human rights and stop crime against humanity abroad. Thank you, Mr. Speaker.
Yes. Honourable Member for Charlottetown.
The Innovative Communities Fund focuses on investments that lead to long-term employment and economic capacity building in Atlantic Canadian communities. There's an excellent example of that happening right now in the great riding of Charlottetown. Since 1981, our beloved Charlottetown Farmers Market has been the city's go-to destination on a Saturday morning.
In public life, it's important to spend time with your constituents, and on Saturday mornings, I find many of my constituents at the market. All year long, there are over 65 vendors who sell the best local products, cuisine, arts and crafts that Prince Edward Island has to offer. And in my opinion, this speaks volumes.
It is an essential driver for our economy, particularly for small business and agri-food entrepreneurs. And this new investment will ensure that the market is able not just to survive, but to thrive as a place to buy local and meet neighbours. Thank you, Mr. Speaker.
The Honourable Member for Laval-les-Îles. Mr. Speaker, Armenians from Laval-les-Îles and across Canada are commemorating the 30th anniversary of the Baku genocide and the 32nd anniversary of the Somagate one. These were heinous crimes against humanity that took the lives of many people in the cities of Uzbekistan.
It is still fresh in the memory of those who survived. Today, let us take a moment to pay homage to each and every one affected directly or indirectly by this barbarian, senseless violence, and to raise awareness so such history does not repeat itself.
By commemorating this horrible tragedy, we remember how lucky we are to live in a country like Canada where fundamental human rights are respected and where we share common values such as respect, tolerance, and justice. Thank you, Mr. Speaker.
The Honourable Member for Calgary Centre.
Mr. Speaker, I rise today and salute the volunteer organizations in Calgary Centre who have spent years promoting pride in Canada's working resource industries. For years, workers in these sectors have contributed to Canada's growth, paying taxes, while an army of foreign-funded activists mounted misinformation campaigns to discredit their work. These Canadians believed that governments would make good common-sense decisions. Well, Mr. Speaker, common sense is not always in abundance. Out of this noise arose a collection of volunteer voices, recognizing we needed better information on how our natural resource industries contribute to the essentials of life we all enjoy. Canada Action, started by Cody Battershill, has become a highly regarded source of information and a purveyor of Canadian pride. There are many more. Terry Winnetoy of Energy Now, Michael Binion of Modern Miracle Network, Aaron Foyer and Alexandria Shrake of Energy Minute.
Chris Slubicki from Modern Resources. Each of these organizations and people have undertaken their task as volunteers to make our country better.
The honourable member for Mississauga East Cooksville.
Today I'd like to talk about an organization that is leading by example in showcasing to the people of Mississauga and the country how warmth, kindness, and empathy help us build an ideal community. As a nonprofit charitable organization, Community Living Mississauga supports individuals with an intellectual disability to ensure their social life is meaningfully improved. Over 3,000 Mississaugans have received opportunities through 450-plus employers, which provide support and care to individuals that need it most. Community Living Mississauga will be hosting their annual tribute dinner. Frank Giannone will be honored for his philanthropic efforts and contributions towards the city. The goal of this event, along with honoring Frank, will be to raise funds so that young people with intellectual disabilities can attend summer programming. As a big supporter of Community Living Mississauga, I want to thank all the donors, volunteers, staff members, and management for their great work. Thank you, Mr. Speaker.
The honourable member for Elgin, Middlesex, London.
Thank you, Mr. Speaker. On March 8th, we celebrate International Women's Day. Every day, Canadian women make vital contributions to communities across our country. For years, women have stood up against sexism and inequality. Women's contributions to our farms, our businesses, and our homes make our communities vibrant and dynamite. While women have come a long way towards true gender equality, we know that issues such as gender-based violence, sex trafficking, and unequal representation to disproportionately affect women. Canada's Conservatives are hard at work to put forward constructive ideas that benefit Canadian women in every region of our country. We are committed to empowering women and girls to achieve their full potential. We know that women will succeed and all of Canada will benefit. Happy International Day.
The honourable member for Bruce Grey, Owen Sound.
Mr. Speaker, I rise today to pay tribute on the 120th anniversary of the Battle of Paardeberg. The Boer War marked the first overseas deployment of the Canadian Army and specifically the 2nd Special Service Battalion of the Royal Canadian Regiment of Infantry, who played an instrumental role in the victory of the Battle of Paardeberg Drift. During the early morning of the 27th February 1900, the battalion advanced by night towards the enemy lines, quietly digging trenches on high ground only 65 yards before the Boer lines, before the Boers attempted to repel the Canadian advance and fierce fighting began. By 6 a.m., the Boers surrendered, thus removing the enemy forces blocking the way to the Boer capital. As the colonel of the regiment, the Right Honourable David Johnson, said recently, this battle represented a turning point in the South African conflict. Historians acclaim that this battle, attributed internationally as a Canadian success, led to Canada's first true pangs of nationalism. For approximately 2 decades afterwards, Canadians would gather on 27 February around memorials to the South African War to say prayers and honor veterans until replaced by Remembrance Day following World War I. I invite all members of the House to join me in honoring our veterans and celebrating Paardeberg Day. Pro Patriot.
The honourable member for Timmins, James Bay.
The opioid crisis is causing havoc and heartbreak. Back in 2009, my office helped establish the first OxyContin task force in Timmins, and those frontline groups are doing incredible work. And then we got hit with a new generation of nightmare drugs, fentanyl, carfentanil, purple heroin. There is now an unprecedented medical emergency across North America. In Timmins, I'd like to thank the work of the Situation Table, the frontline workers and police, medical, mental health, the Living Space. In Kirkland Lake, my office is working with the opioid task force. In James Bay, we have states of emergency that have been declared, but we need the federal government at the table. We need more services for harm reduction. We need a commitment to start going after the illicit trade in fentanyl on the dark net. We need to have a gut readiness of this government to go after big pharma to make them pay for the damage that they've done. We need to declare a national medical emergency because this crisis is affecting us all.
The honourable member for Rivière-des-Mille-Îles. Mr. Speaker, on February 13th, when I was visiting Quebec's wonderful national capital, I visited the original Ma Langue au Chat Cat Cafe. There are many cats there, and this is a small business created by 2 Army veterans who were suffering from PTSD. So I'd like to underscore, Mr. Speaker, the commitment and the courage of Marie-Pierre Tremblay and Lisa Cyr, who through their work are changing mindsets and are allowing veterans to a place to go where they won't be labeled and where their suffering is alleviated, a true refuge. These two women are changing mindsets and reducing stigma related to mental health. Thank you, Mr. Speaker.
The honourable member for Brandon Souris.
One of the worst acts of vandalism in Canadian history occurred 2 nights ago in Winnipeg when someone defaced a monument honouring RCMP officers who died in the line of duty. These brave men and women, the RCMP, died in their line of duty to our nation. They died upholding the rule of law and for answering the call when we needed them the most. I can think of nothing more despicable than this cowardly act of vandalism. Instead of peaceful protests, these vandals have resorted to radical acts. They stoop to the lowest levels in their attempt to advance their cause. In Canada, when we disagree, we do it through peaceful means and not spray painting vulgarities on monuments. If these vandals thought their acts would garner support for their cause, they were wrong. These vandals have unfairly tarnished those who are engaging in peaceful dialogue. They should be ashamed of themselves and immediately apologize, and I call on all members to denounce these illegal and appalling acts of vandalism.
The honourable member for Etobicoke Lakeshore.
Mr. Speaker, Canada has lost a giant. The Honourable David P. Smith, husband, father, grandfather, former cabinet minister, senator, a genuine political legend, passed away yesterday. Brother Smith, as he was known by everyone, was honest, funny, and decent. He was called home, but far too soon. He was deeply religious. Yesterday was Ash Wednesday, fitting perhaps, and it was his time, but the rest of us weren't ready. His humor, his demeanor, and his gregarious personality transcended all political boundaries. He was respected and loved by all that knew him, regardless of their political stripe. But make no mistake, he was a Liberal. And he was a brilliant strategist. He was the man behind many successful campaigns. In 1993, he ran the Ontario campaign, and the Liberals won every seat but one. Mr. Speaker, I'm told that Prime Minister Chrétien still hasn't forgiven him. Yeah. There are many people in this chamber who would not be here but for him. He was a mentor, a role model, and an inspiration. He represented all good things about this profession. A minute isn't enough time to reflect, Mr. Speaker, so I ask that we pause and we learn from his legacy.
Before we go on, I just want to remind the honourable members, if I can have your attention. The honourable members, when it's time to speak or you have to get up, if you don't mind doing it before your name is called. Most of you know when you're going to be getting up. So if the honourable members can rise before the name is called. We've had a few incidents where people have been overlooked and we've gone somewhere else. So just to make sure, it's not usually during question period, it's during the day. But even during question period, if you know your time is coming, please don't wait until it's time to speak before you get up. Just a little reminder there to help the process go better. Now, oral questions. Question orale. The Honourable Leader of the Opposition.
Mr. Speaker, the Tech Frontier mine would have been a big benefit to Canada's economy, creating the 7,000 construction jobs and 2,500 long-term jobs. 14 Indigenous communities had signed partnership agreements, and they were looking forward to benefiting from the jobs that this project would have created. So the decision to cancel Tech Frontier should have been a massive disappointment to any government, but yet the Prime Minister has refused to tell us how he personally feels about this decision. So can the Prime Minister tell us how he feels about Tech Frontier being cancelled?
The Honourable Deputy Prime Minister.
Mr. Speaker, let me say that I know this was a very difficult decision for the company and a very difficult decision for our country. Let me tell you how I feel about our country's oil and gas sector. We secured the largest investment in Canada's history in LNG Canada. We have approved the Line 3 replacement. We approved TMX, and we will get it built. Our government understands that Canada is one of the world's leading producers of oil and gas, and that sector is the source of hundreds of thousands of great jobs across the country. We support the sector.
The Honourable Leader of the Opposition.
Well, the problem with that answer, Mr. Speaker, is that over almost $200 billion worth of investment in our energy sector has left Canada for other countries that can actually get projects approved and built by the private sector. Now, the Prime Minister is trying to blame Tech Frontier's decision on the polarized debate around it. In other words, what he is saying is that the only way big projects can get built in this country now is if nobody notices that they're happening, because he doesn't have the strength to stare down radical activists who just want to leave the oil and gas in the ground. So, can the Prime Minister tell us what he's going to do to make sure that future projects don't get hijacked by these types of tactics?
The Honourable Deputy Prime Minister.
Mr. Speaker, let me tell the Leader of the Opposition what we all need to do. We all need to recognize that reconciling ambitious climate action and getting energy projects built in Canada is complex and presents complex challenges. It is not good for our country to have this debate be dominated by extremes on either side. We need to work sincerely together to find common ground, and our government is committed to doing just that.
Leader of the Opposition.
Mr. Speaker, it was the Prime Minister who praised the protesters, who he said were out defending their community in the cold. Those were his words. But it is very complicated to get a project approved. But it's actually very simple once the independent regulator gives a recommendation. And that recommendation was sitting on the Prime Minister's desk since July. This Prime Minister could have approved this project in July, but he refused to do so. He refused to approve it in August, September, October, November, December, January. What I would like to know, Mr. Speaker, is what information was the Prime Minister waiting for that he couldn't approve this project back in July?
The Honourable Deputy Prime Minister.
Mr. Speaker, I don't agree with the members opposite about everything, but I think we can all agree that our country needs to find a path forward on getting big energy projects built and on acting ambitiously when it comes to climate change. It is simply untrue and false to suggest to Canadians that that path is simple. It's complicated. It's going to take all of us working together, and that's what we're going to do.
The Honourable Member for Richmond Athabasca. Mr. Speaker, for 5 years now, every time a difficult situation arises in Canada, our Prime Minister shows no leadership. A trip to the Aga Khan's Island, trip to India, SNC-Lavalin, coronavirus, the CN strike, Western energy projects, and now rail blockades. Mr. Speaker, governing is easy for anyone when things are going well. But it's in the face of adversity that you see who the true leaders are. When will this Prime Minister show leadership in order to resolve once and forever the rail blockades? The Honourable Deputy Prime Minister. Mr. Speaker, the Prime Minister has shown leadership and did so last week when he clearly stated that the injunctions have to be respected and the law must be upheld, the blockades removed. And I would like to congratulate our Minister of Indigenous Crown Relations, who is in British Columbia today to work with her provincial counterpart and representatives from the Wet'suwet'en community. The Honourable Member for Richmond Athabasca. Mr. Speaker, we are now into the 4th week of rail blockades, and nothing is happening. On one day, it's the Conservatives' fault. On another day, it's Harper's fault. On yet another day, it's the First Nations' fault, the province's fault. It's everyone's fault except the Prime Minister's. And yet he has been in office for 5 years. But the reality on the ground is that Canadians are fed up. We want a Prime Minister who shows leadership. When will he give us a date when all those tracks will be freed up? the Deputy Prime Minister. Mr. Speaker, I must point out the Prime Minister's leadership that he showed last Friday when he said that the blockades must be dismantled. And I also want to underscore the leadership of my colleague, our Minister of Indigenous Crown Relations, that she is showing today in British Columbia. Now, it's all very well for people to speak, but we are the ones who are doing the work.
La Prairie.
The Honourable Member for La Prairie. Mr. Speaker, it took 22 days for the government to finally meet with the Wet'suwet'en chiefs. It's the only way to get the Kahnawake blockade lifted, and I hope the PM knows this. You see, yesterday he said, and I quote, "We have enormous trust in the Quebec Police Services and in the community to resolve their own crisis." Their crisis, Mr. Speaker? It wasn't a crisis that was caused by the government of Quebec, nor by the police services in Quebec. It was caused by the lack of leadership on the part of the Canadian Prime Minister, and everyone knows that. Will the government finally tackle the crisis at its source in British Columbia? The Honourable Deputy Prime Minister. Mr. Speaker, I would like to take this opportunity on a question from the Bloc Québécois to underscore the fact that we are all working together in order to resolve a very significant issue for the economy. And I would like to thank the entire Bloc Québécois on its will to work with our government on the new NAFTA. The Bloc recommended better oversight for aluminum, and we have had very fruitful conversations with them. Thank you. The Honourable Member for La Prairie. Well, I like what the Deputy Prime Minister said. I'd like her to say that more often in front of the media, actually. But listen, what did we propose on this crisis? That the RCMP withdraw from Wet'suwet'en territory and that work cease on the project. Now, if you had listened, the Bloc Québécois, from the beginning, like you did on aluminum, perhaps we'd be better off today. But that's not what's happening. Here we are on the 22nd day, and they're saying maybe the issue will be resolved. Can you understand that the Kahnawake problem will find its solution actually in British Columbia? I would just like to remind members that the Speaker had nothing to do with aluminum, actually. And so when you put a question, you have to move through, not directly to the Speaker. The Honourable Deputy Prime Minister. Mr. Speaker, I would like to remind my colleague on the other side of the House that the responses we give in the House are also the responses we give to the media. And I think everyone knows that. Now, with respect to the blockades, I would like to point out that our Prime Minister has shown significant leadership over the course of last week, and I would also like to underscore the very important work that my colleague, the Minister for Indigenous Crown Relations, is doing now in British Columbia. Thank you, Mr. Speaker. The hereditary chiefs asked for a meeting with the Prime Minister and have been doing so since January 10th. That's more than a month ago, and the Prime Minister has refused to act. Now here we have a national crisis. It's simple. When will the Prime Minister meet with the Wet'suwet'en hereditary chiefs?
Leader is also a BC MP. So I am sure he will be glad to know that we are working on this issue in very close collaboration with Premier Horgan, with whom I spoke at length last night. No Premier has worked harder on reconciliation, and we should all acknowledge that. We should also all support the province of BC's efforts to get important natural resource projects built in Canada. And when it comes to meeting with the Wet'suwet'en leadership, that is what my colleague is doing today.
Well, Member for Burnaby South.
On January 29th, 2020, the Prime Minister met with Suncor Energy. On December 11th, 2019, Novartis Pharmaceuticals. On November 14th, Enbridge. In the past couple of months, when wealthy and powerful corporations come knocking, the Prime Minister finds a time to meet with them. But when Indigenous people ask to meet the Prime Minister, he ignores their requests. If the Prime Minister can find the time to meet with powerful corporations during a national crisis, why can't he find the time to meet with the hereditary chiefs of Wet'suwet'en?
The Honourable Deputy Prime Minister.
Let me be very clear and say something which is incontrovertible, and that is that our Prime Minister has worked harder and more sincerely towards reconciliation than any Prime Minister in Canada's history. When it comes to a meeting with the Wet'suwet'en hereditary leadership, my colleague, the Minister of Crown Indigenous Relations, is in BC with her BC counterpart doing exactly that.
Fort McMurray Cold Lake.
Mr. Speaker, as a result of the government's anti-oil and gas policies, Teck withdrew their application. Thousands of families in many Indigenous communities are devastated and very concerned for their future. Investment into the oil sands is now seen as a non-starter with this current Liberal government. When will the Prime Minister end his attack on Alberta and let us create the needed jobs?
The Honourable Minister of the Environment.
Thank you, Mr. Speaker. The decision made by Teck Resources and the letter that the Teck CEO sent to me clearly demonstrates the need for all levels of government and indeed all members in this House to be working together to deliver climate action and clean growth. We need to take action on climate change in order to move forward with business certainty. It is something that the investment community has told us is extremely important. It is something that all Canadians are telling us is extremely important. Mr. Speaker, we should be fighting climate change, not each other.
The Honourable Member for Edmonton Centre.
Mr. Speaker, yesterday I introduced my private member's bill C-229, which asks the government to repeal their West Coast shipping ban. This bill sends a clear message to investors Canada is open for business, and that my Conservative colleagues and I continue to advocate for increased access to markets for our oil and gas sector. Will the Prime Minister commit today to support Bill C-229 and show that he's finally listening to Alberta and the rest of the Western provinces?
The Honourable Minister of Transport.
Mr. Speaker, our commitment to safe shipping on the west coast of this country is a very, very strong one, because we realize to what level it is important to get our products to Asian and other international markets. That's why we're very, very proud of the Oceans Protection Plan, which contains more than 50 measures to make our marine shipping industry safer and our waters more safe. And that is why we're also involving our First Nations, and we're very proud of that, and we're going to continue to work in that direction.
Well done.
The Honourable Member for Louis Saint Laurent. Mr. Speaker, when it comes to natural resources, unfortunately, this government practices a scorched earth policy, and that's really too bad for Canada. 7 major projects have been cancelled. $150 billion investment have evaporated. 200,000 jobs have been lost in the energy sector in Canada. That's what the record is of the Liberals. In Quebec, did you know that we buy 10.6 billion litres of fuel, and 62% of that comes from the U.S.? Now, perhaps the Liberals and the Bloc are happy to help Donald Trump, but we're not. Why doesn't the Liberal government decide on having energy self-sufficiency in this country? Mr. Speaker, we have done important work on growing our economy and protecting the environment, and that rises well above any single project. Our government is committed to working with Alberta and with the resource sector in order to ensure that the right projects go ahead. Thank you.
The member for South Surrey, White Rock.
Mr. Speaker, Teck's withdrawal is a tragedy for Canada, not just Alberta. 7,000 jobs lost, billions of investment dollars gone. There's a serious disconnect between this Prime Minister and Western Canadians. Yesterday, he said Alberta continues to politically resist after Teck engaged First Nations and passed all overall standards. His contempt for hardworking Canadians hurts. When will this Prime Minister stop blaming Alberta and support industry-leading projects that are socially and environmentally responsible?
The Honourable Minister of the Environment.
Mr. Speaker, I think it'd be helpful to quote the Calgary Chamber of Commerce, which recently said, and I quote, "We need real decisive action on climate change with tangible outcomes and conviction. The success of our businesses, the well-being of our families, and our strength as a country all depend on it." Mr. Speaker, we agree, and we are working with all orders of government to ensure a sustainable resource sector and to take aggressive action on climate change.
The Honourable Member for Grand Prairie, Mackenzie.
Mr. Speaker, the Prime Minister regularly attacks elected officials from the province of Alberta, but yesterday he let his contempt for all Albertans slip out of his mouth yet again. He was justifying his paternalistic, his Laurentian elite Ottawa knows best attack on Albertans' energy sector, falsely claiming that Alberta has done nothing to address climate change. False statements attacking Albertans pour gasoline on the flames of a national unity crisis that he himself ignited. Why is the Prime Minister willfully ignorant about what is happening in Alberta, or does he just want this crisis to burn on?
The Honourable Deputy Prime Minister.
Mr. Speaker, I am very aware, and our government is very aware, of the pain and indeed, among many people, the despair in Alberta today. I want to be very clear that when it comes to the oil and gas sector, our government is clear in its support. We understand that the oil and gas sector in Canada is the source of hundreds of thousands of well-paying, often blue-collar jobs across our great country. It is not right to play with national unity.
The Honourable Member for Edmonton-Wetaskiwin.
Mr. Speaker, those are just words. And yesterday in an interview, the Natural Resources Minister was challenged regarding his government's lack of an emissions plan. Asked when one would be unveiled, he repeated the word soon 5 times in 25 seconds. He acknowledged that investors don't currently, quote, know what direction we're heading in and what the rules are. No kidding. This is something that's been glaringly obvious to everyone but this government for the past 4 years. How many more billions of dollars in investment and tens of thousands of jobs need to be lost before this Liberal government finally has a coherent plan?
The Honourable Minister of Natural Resources.
Mr. Speaker, it is very clear that one of the things we have to do is develop a net zero plan, and that has to be done with the provinces, with the territories, and it has to be done with industry. And indeed, Mr. Speaker, it has to be done very soon because the investment climate all around the world is changing. It is changing. They are going to jurisdictions that take climate change seriously. And we need to make sure that we get
Now, we started off not too bad. It was actually going well, but suddenly the noise level came up. Order. Now, you know, what's very embarrassing is being named, and I'm sure we don't want anyone to be named today. So I'll just leave it at that, and we'll let the Honourable Minister of Natural Resources continue.
Mr. Speaker, the investment community around the world is coalescing around the net zero marker, and there is no way that we can get to net zero as a country without Canadian oil and gas. In the same way, there's no way we can have a competitive, thriving oil and gas industry in this country without net zero.
The Honourable Member for Avignon-La Métis-Matane-Matapédia. Mr. Speaker, we're now in the era of climate change, not the era of drill, baby, drill. Suncor president said that the time of big projects is over. Teck Resources CEO said that before investing, provinces have to agree on their climate change policies. Even oil companies are greener than the government now. That's quite something. The government decides to buy Trans Mountain for a huge sum and doesn't even blink when that cost explodes. Will this government listen to reason and end this irresponsible spending? The Honourable Minister for the Environment. Mr. Speaker, we have taken significant action to tackle climate change. We have developed a plan with 50 initiatives to reduce greenhouse gas emissions, and we have promised to implement a plan to reach our 2030 target and to achieve net zero by 2050. Mr. Speaker, we have made a lot of progress, but we need to make even more progress. The Honourable Member for Repentigny. Mr. Speaker, you can't talk about tackling climate change and at the same time put $18 billion worth of taxpayers' money into the purchase of the Trans Mountain Pipeline. And yet that's exactly what this government is doing. It's wasting $18 billion to buy a pipeline that will transport the dirtiest oil on the planet and sell it to markets that will continue to pollute. So, Mr. Speaker, I'd like to know if the Minister of the Environment can explain once again, perhaps, how Trans Mountain will contribute to the goals that this government set. The Honourable Minister for the Environment. Mr. Speaker, we have a serious, affordable plan to tackle climate change. We have spent more than $63 billion in green infrastructure and in clean energy, more than any other government in the history of this country. Furthermore, every dollar generated by TMX will be invested in a green transition so that we can move on to a cleaner economy and make sure that our resources reach markets and that we still transition to an affordable green economy. The Honourable Member for Repentigny. So TMX is going to be invested into green energy? Sorry, that's like saying you're going to set fire to a village and that way you'll be able to justify hiring firefighters. Trans Mountain is $18 billion that could be invested into what? Well, how about health transfers? How about climate change? How about old age pensions? And how about a transition for oil workers? But no, they're going to invest it in the oil sands. Will the minister recognize that this white elephant is harming the economy as much as it's harming the planet? The Honourable Minister for the Environment. Thank you, Mr. Speaker. As I stated, we are going to implement a strong plan to tackle climate change, the strongest plan in the history of this country. We have a plan for 2030. We have said that we want to develop a plan to achieve net zero by 2050. We have made more progress on climate change with this government than with any government in the history of Canada. The Honourable Member for Charlesbourg, Haute-Saint-Charles. Mr. Speaker, Australia has announced that it is implementing an emergency plan to face the increasing spread of the coronavirus. The Australian Prime Minister, Scott Morrison, announced that decision today because he expects that a global pandemic will be announced in the coming days. Even the Chief Public Health Officer of Canada, Theresa Tam, stated on Tuesday to reporters that this virus will probably become a pandemic. But we shouldn't panic. However, Canadians need to be reassured. Will the Prime Minister confirm today that there is an emergency plan in place? The Honourable Parliamentary Secretary to the Minister of Health.
At this time, the risk within Canada remains low, but we do need to be prepared. This is a rapidly evolving situation, Mr. Speaker, and based on what is happening around the world, we are now preparing for a global spread of COVID-19. Our focus is now on limiting the impact within Canada. We already have emergency response plans in place. We also have federal, provincial, and territorial preparedness plans to respond to a pandemic situation. Mr. Speaker, only the World Health Organization can declare a pandemic.
Good job. Member for Caribou Prince George.
Mr. Speaker, the WHO Director General said this today. This virus does not respect borders. China, South Korea, Iran, Italy, Australia, Brazil. The coronavirus is spreading to all corners of the world. People are dying, and Canadians are rightfully concerned for their health and safety. This government needs to assure Canadians they are doing everything in their power to protect our country from this global health emergency. The U.S. has implemented restrictions denying foreign nationals from entering the country if they have visited China within the last 14 days. Our allies have taken unprecedented steps to protect their citizens and contain the virus. Has this government considered the same restrictions?
The Honourable Parliamentary Secretary.
I want to thank the Honourable member for the question. As we learn more about COVID-19, our public health officials are updating their advice for travelers. If someone has recently traveled to any jurisdiction with a confirmed case of COVID-19 and they are unwell or unsure, we are asking that they self-isolate for 14 days. Now, Mr. Speaker, this is out of an abundance of caution. Our public health system is well prepared to handle cases of the virus in Canada, and we are taking every necessary precaution to prevent the spread of this infection.
You're here. Good job. For Edmonton Riverbend.
The health minister is telling Canadians to prepare for a possible pandemic by stockpiling food and medication. While no one is trying to raise panic, sudden statements about needing to stockpile food and medicine are raising concerns across the country. Canadians are now wondering if they should be scared to fly, go to work, or go to school. How likely is Canada to face a pandemic at this time? Is the risk still low? Should we be stocking our shelves with supplies?
Good question. The Honourable Parliamentary Secretary.
Thank you very much, and I want to thank my friend for the question, Mr. Speaker. Again, as I said, at this time the risk does remain low, but we do, in fact, need to be prepared. This is, as I said, a very rapidly changing situation. And based on what is happening around the world, we are preparing for a global spread of COVID-19. Our focus must focus on the impact within Canada. We already have emergency response plans in place. We also have federal, provincial, and territorial preparedness plans to respond to a pandemic situation. The health and safety of Canadians is at our utmost wish.
The Honourable Member for Vancouver East.
Iran has the most COVID-19 cases in the Middle East, and Canadians are unable to fly out because all commercial flights have been cancelled. The minister said no one in Iran is requesting airlifts to get out of the country, but the facts tell a different story. Within the last 48 hours, the Iranian-Canadian Congress has received over 100 emails from Canadians who are stranded in Iran. Will the minister commit to evacuate Canadians out of Iran, just as they did for Canadians in China and Japan?
Here, here.
The Honourable Minister of Foreign Affairs.
Mr. Speaker, we remain very committed to providing consular services to Canadians travelling abroad, obviously including in Iran. We invite Canadians in Iran to take commercial flights while they remain available, Mr. Speaker. Canadians in Iran can access service to our embassy in Ankara, and they can also contact the Italian embassy in Iran, who is our protector. Mr. Speaker, we're providing consular services to everyone in the world who needs the assistance of Canada to come back home.
Member for Vancouver Kingsway.
Canada's nurses are warning federal guidelines to protect frontline workers from COVID-19 don't go far enough and may be putting patients at risk. Safety protocols in Ontario, the U.S., and the European Union all call for the use of disposable respirators, while federal guidelines provide less secure barriers. Nurses say that federal standards presume the virus can't spread through the air, but the science is unsettled. Will this government listen to frontline professionals, revise their guidelines, and ensure the best protection possible for healthcare workers and their patients?
The Honourable Parliamentary Secretary to the Minister of Health.
Mr. Speaker, I want to take a moment here to thank the frontline healthcare providers across this country. Mr. Speaker, they have been seized with this from day one, and they have been paying attention, and they've been doing incredible work, and for that, I am very thankful. Mr. Speaker, we are committed to protecting healthcare workers and patients from exposure to COVID-19. The Public Health Agency of Canada released interim guidelines for medical professionals on infection prevention and control for COVID-19, which were developed in partnership with our provincial and our territorial partners. Thank you, Mr. Speaker.
Good job.
The honourable member for Acadie Bathurst. Mr. Speaker, fish harvesters in my riding will soon head out for the opening of the snow crab season. We wish them a great season out on the water and the best of prices for their catch.
Ocean and the Canadian Coast Guard update this House on what our government is doing to ensure our harvesters have access to markets while also continuing to protect the North Atlantic right whale. Thank you, Mr. Speaker.
The Honourable Minister.
Thank you, Mr. Speaker, and I'd like to thank my colleague for his question.
Riding of Acadie Bathurst. Mr. Speaker, this morning I was happy to announce updated measures to protect the North Atlantic right whales. We're working in collaborations with industry as well as with our conservation experts. But, Mr. Speaker, I want to be clear that the measures and the progress we're making is only possible because of the support and hard work and cooperation from our fish harvesters. We're ensuring that our fisheries remain sustainable and products are getting to market while protecting for generations this animal that's so important to all of us. Thank you, Mr. Speaker.
The honourable member for Montmagny, Kamouraska, Rivière-du-Loup. Mr. Speaker, in Quebec alone, the economic impact of the railway blockades is estimated at $100 million a day. The CED's budget for Quebec is $300 million a year. The blockades have in 3 days undone what the government hoped to accomplish in an entire year. We've already heard the broken record from the Prime Minister, the Transport and Public Safety Ministers. What does the Minister of Economic Development have to say about this? The Honourable Minister of Transport. The answer, Mr. Speaker, is that we're working day and night to solve this problem as quickly as possible, and that is why we have undertaken dialogue, major dialogue, that will begin today, and at the same time we've clearly indicated that the barricades have to come down and the railway system has to be able to get back to full speed. That's what's happening now. And we're very well aware of the fact that we have to continue along these lines so that our economy can return to normal.
For Saskatoon West.
Mr. Speaker, the ongoing blockades by activists continue to hurt ordinary Canadians. Last week, the Prime Minister said, "I hope we will see positive developments." The Public Safety Minister was hopeful the police would help restore rail shipments. The Liberals repeatedly speak of their hope that the protests will be resolved peacefully, yet we see protesters starting fires in front of moving trains. Mr. Speaker, hope is a wonderful sentiment, but hope is not a management tool. When will the blockades finally come down and stay down?
The Honourable Minister for Public Safety.
Thank you, Mr. Speaker. And I understand the members opposite are hopeless, but let me assure you, Mr. Speaker, that we are working tirelessly both to re-engage.
Order. 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 We were doing so well. I just want to make sure that people understand on both sides that when we throw stuff, it comes back negative. And just try to be getting along and do the best we can. We were doing very well. I was really having hope. The Honourable Minister.
Thank you, Mr. Speaker. Let me assure the members opposite that our government remains committed to doing the hard work of going to the table and engaging in the negotiations to resolve the outstanding issues and to get that project built. And at the same time, Mr. Speaker, we have confidence. We have real confidence in law enforcement across this country to do the job of restoring order and to taking those barricades down.
Honourable Member for North Okanagan Shuswap.
300,000 chickens. Mr. Speaker, that's how many birds will go hungry on one farm in Salmon Arm in a few days. Wow. This family farm's existence is being threatened by the rail blockades. The farmers have the trucks ready to pick up the grain from the rail cars, but they can't get the rail cars moved. Wow. The livestock and the livelihoods of farmers are at risk. When will the Prime Minister remove these blockades?
The Honourable Minister of Public Safety.
Thank you again, Mr. Speaker. And let me be very clear. The Prime Minister and our government has been crystal clear. These barricades are having an unacceptable impact on Canadians across the country, and they must come down. And at the same time, Mr. Speaker, we have confidence in law enforcement's ability to do their job and to uphold the law while we engage in the important work of negotiation to reconcile the issues giving rise to these barricades. Thank you, sir.
Number 4, Lethbridge.
Right, before you open your mouth, guys.
I shouldn't be up yet. Canada is in a crisis. Roads, railways, and ports have been shut down. Thousands of Canadians are unable to get to work. Small businesses and farmers cannot get their products to market. Workers are being laid off. A few radical activists and those who break the law, who hate energy progress, are literally being allowed to hold our country hostage. When will the Prime Minister do his job, take leadership, and put an end to this lawless nonsense?
The Honourable Minister of Transportation.
Working very hard to resolve the problem, and I should point out that trains are beginning to move again, not only moving freight across this country, but also moving passengers. So the situation is improving. It's not where we want it to be, and we're going to continue to work very, very hard. And we're extremely happy of the dialogue that is going to start today with the Wet'suwet'en Hereditary Chiefs. We are working with a very sensible approach to solve this problem.
The Honourable Member for Beauport-Limoilou. Mr. Speaker, we're celebrating the 4th anniversary of Phoenix, the abyss into which 3/4 of public servants have unfortunately fallen at one time or another. Some haven't been paid. Others have to pay back tens of thousands of dollars, net, not gross. Some have lost their homes. One public servant even took her own life, and that's the cases we know of. 4 years later, there's nothing to celebrate. A demonstration is being held in Montreal. Will the President of the Treasury Board go there?
No, excuse. The Honourable Minister of Infrastructure.
Monsieur le Président.
Mr. Speaker, I express my sympathies to the family of Ms. Deschâtelet. We know the problems, the stress that they cause to public servants and their families, and we're determined to fix the problem. Over the past 2 years, we have reduced the number of transactions that were awaiting processing, and over the same period, the number of transactions with financial consequences have gone down by about 50%. We are continuing in these efforts. The Honourable Member for Beauport-Limoilou. I understand that the Minister is trying, but 4,000 RCMP employees are still at risk of getting caught up in Phoenix. They're being told the tests show that all the bugs have been worked out. Mr. Speaker, try telling that to the 100,000 public servants who've had problems over the past year. It just makes no sense to bring new workers into Phoenix this late in the disastrous game. We know the system doesn't work. We know the government's working to replace it. Why not wait for the new system? The Honourable President of the Treasury Board. Thank you, Mr. Speaker, and I'd like to thank my colleague for that very important question. RCMP employees are fundamental to Canadian security, and their working conditions are crucial under my mandate, and that is why no RCMP will migrate towards Phoenix if there's any risk involved.
Mr. Speaker, Saskatchewan grain farmers are facing serious financial hardships after a difficult harvest season. The Liberals have failed to resolve trade disputes with China. The carbon tax is making everything more expensive. And now illegal blockades are shutting down the rail system. The Liberals must act to help our struggling farmers. The deadline for loan repayment through the Advance Payments Program is fast approaching. Will the minister agree today to waive the interest on the loans and extend the repayment deadline?
Honourable Minister of Agriculture.
Mr. Speaker, we understand the pressure our farmers have faced following these tough years. This is why we have improved the advance payment program, and we are in close contact with the APP administrator to monitor the evolving needs of farmers, and I assure you that I will duly evaluate a request when it comes. Thank you.
The honourable member for Perth Wellington.
Well, Mr. Speaker, farmers are facing their challenging now, and the deadline is fast approaching for the advance payment repayments. But farmers are facing challenges. Wet harvest meant that many of the crops stayed in the ground, and those who did get their crops off are now facing delays because of a CN rail strike and now because of illegal blockades. When we asked the Prime Minister this question yesterday, he appeared as though he didn't even know what this program was. So to the Minister of Agriculture, will she extend the deadline for the advance payment program, and will she waive the interest charges, yes or no?
The Honourable Minister of Agriculture.
We have made significant modification to the advance payment program last year. I know it's an important program for our farmers, and I can assure you that we are working closely with the APP administrator, and if they come to me and ask for such a request, I will take it very seriously. Thank you, Mr. Speaker.
Honourable member for Battleford Lloydminster.
Thank you, Mr. Speaker. Canada's farmers have been hit with blow after blow with this Liberal government. Last fall's early snowfall has left so many crops buried under the snow. Rail strikes and illegal blockades are preventing crops that are in the bin from even getting to the market. The Liberal carbon tax and crumbling trade relationships only compound this crisis. Advance payment program loans are coming due, but with so many hardships beyond their control, farmers are strapped for cash, Mr. Speaker. Our farmers are in desperate need for more than just empty platitudes. When will the Prime Minister commit to extending the advance payment program deadline and waiving interest on its loans?
Honourable Minister of Agriculture.
Mr. Speaker, I will be very pleased and open to evaluate such a request when it comes to me. And I've already told you many times that I am also very committed to improve the business risk program, the business risk management programs. And should I remind my colleagues that they have cut $400 million to these programs?
The honourable member for Mississauga, Erin Mills.
Mr. Speaker, everyone has the right to a safe workplace with fair treatment for all, no matter their gender or their gender identity. Sexual harassment impacts the health and the well-being of those involved, as well as their ability to perform their jobs to the best of their ability. Will the Minister of Justice please share with this House what action our Liberal government is taking to address the issue of workplace sexual harassment?
The Honourable Minister of Justice.
Mr. Speaker, I thank the honourable member for her question. I agree with her that everyone has the right to feel safe and secure in their workplace. Our government, Mr. Speaker, has invested $50 million over 5 years in funding to address sexual harassment in the workplace. Half of this funding will increase organizations' capacity to provide legal advice to complainants, and half will enable them to provide public legal education and information to workers. Mr. Speaker, we all have important roles to play in creating and maintaining workplaces where everyone can feel safe and respected.
A member for Selkirk, Interlake, Eastman.
Mr. Speaker, the Liberals' fighter jet fiasco has turned into a complete circus. First, they manufactured a fake capability gap to justify their ridiculous plan to buy a bunch of old, rusted-out Aussie jets. Now they've delayed the competition to buy new jets for another 3 months. And to top it all off, they're only upgrading the fighting capabilities on half of our old jets. How have the Liberals managed to waste $3 billion taxpayer dollars without buying a single, not one, new fighter jet?
The Honourable Minister of Public Services.
Mr. Speaker, our government has been strong and consistent in delivering on its promise to replace the existing fighter jet. Unlike the previous Conservative government, which procured no jets, we are delivering real progress in purchasing 88
I'm sorry. I'm sorry. I'm going to have to interrupt the Honourable Minister. I'm having a hard time hearing. I'm sure everyone else is as well. I think we quiet it down. The Honourable Minister, please proceed.
At the request of industry, the deadline for preliminary proposals has been extended until June 30th, 2020. This will not affect the timeline for contract award and delivery. Our objective remains clear: getting the best plane for the RCAF at the right price with the most economic benefit for Canadians.
Member for Calgary, Midnapore.
Mr. Speaker, families in Toronto are struggling to find a home. The first-time home buyers incentive provided a glimmer of hope before the details were actually known. Mr. Speaker, you can't buy half a home in Toronto under the current incentive, leaving families with little option for home ownership under this plan. When will the Liberals put forward a real plan for families who are just trying to buy their first home in Toronto?
The Honourable Minister.
We're happy to talk about the National Housing Strategy, which reintroduced federal leadership in housing after 10 years of inaction by that party when they were in government. We have ensured that we've introduced programs to build more affordable rental stock into the market, more social housing. We've signed bilateral agreements with provinces and territories. And yes, we've introduced the first-time home buy incentive so that the dream of home ownership can be within reach for middle-class Canadians.
So much good work. Remember for Canora.
Mr. Speaker, forestry contributes over $20 billion to the Canadian economy and employs over 200,000 people. The industry also plays a role in protecting our environment, as forest products are an effective way of storing captured carbon. This is why many Canadians are concerned with the Liberal plan to restrict 25% of Canada's land from development. Reducing the amount of forest land available for harvest would negatively impact our economic and environmental prosperity. So can the Minister of Natural Resources confirm whether or not this plan will impact areas that are currently accessible for harvest? Yes or no?
Honourable Minister of the Environment.
Thank you, Mr. Speaker. We were incredibly proud of the work that was done between 2015 and 2019 to meet our protected areas targets of 10% marine and 17% terrestrial protection. That is critically important in terms of protecting biodiversity in this country, and we worked with all sectors, including the forestry sector and the provinces and territories in doing so. We have now established a 25 by 25 target. We will continue to work actively with the provinces and territories, with all sectors, very much including the forestry sector, to ensure that we are protecting spaces for years to come, but doing so in a manner that is economically sensitive.
The Honourable Member for Vimy. Mr. Speaker, all Canadians know it's often hard to strike a good balance between our personal and professional lives. In my riding of Vimy, families work hard to balance the demands of work, family, mental health, emotional and physical fitness. Canadians want this government to deal with this important issue. Can the Employment Minister tell us what steps this government is taking to address work-life balance? The Honourable Minister of Employment. Mr. Speaker, my colleague's question is very important. Our government understands the importance of work-life balance.
For Canadian workers, Mr. Speaker, we've expanded leave provisions for families. We've created new leaves. We've enshrined flexible work arrangements, restored fair and balanced labour relations, and moving forward, we will modernize health and safety standards, implementing mental health protections. Merci, Monsieur le Président.
Thank you, Mr. Speaker.
The Honourable Member for Skeena, Bulkley Valley.
Mr. Speaker, a woman I met in Fort St. James worked for 25 years at the sawmill. She told me that when she was laid off, she lost all her benefits. Now she can't afford the drugs she needs for her arthritis. Like the 1 in 5 Canadians who can't afford their medication, she's been left behind by this government. The NDP is ready with a plan to make universal, public, single-payer pharmacare a reality and save Canadians and our health system billions. Will the minister support our plan for pharmacare?
The Honourable Parliamentary Secretary to the Minister of Health.
Thank you very much, Mr. Speaker. I want to thank the Honourable Member for the question. We are open to collaborating with the members of the opposition we are open to collaboration with members of the NDP. We will look very seriously at this bill. We will work towards coming up with things that we can work together on to move forward for national pharmacare for all Canadians.
The honourable member for Fredericton.
Mr. Speaker, 1 in 5 Canadians suffer from a mental health problem or illness in any given year. Mental illness-related costs in Canada are over $50 billion annually.
The social costs are very high. People with serious mental illness are more likely to live in poverty.
France has been tasked with setting national standards for the access to mental health services. Can the minister confirm that the upcoming budget will include funding for a national framework that will allow Canadians to access a variety of mental health professionals, including counselors, and will empower provinces and territories to work together for action on this important issue?
Yes.
The Honourable Parliamentary Secretary.
Mr. Speaker, the health of Canadians is a top priority for constituents in every riding from coast to coast to coast. Of course, during the recent federal election campaign, we committed to put billions of dollars to support not just mental health, but to improve access to primary care, to implement pharmacare, and to improve in-home care for our seniors. I look forward to continuing my conversations with colleagues on both sides of this aisle to implement a plan through our fiscal framework that's going to improve the health of all Canadians. Thank you.
And that's all the questions for today. There's a point of order, but before we go to the point of order, I just want to say that today was not a great day, but it was a much better day, and I want to thank the members who did respect others while they were speaking. The honourable member for Edmonton West has a point of order.
Might be setting your standards too low, Mr. Speaker. Now, Mr. Speaker, earlier we heard the member from Rapontier wrongly label Alberta oil as dirtiest in the world when we know it's actually Nigeria. I'd like to table, please, a report from the Library of Parliament showing Quebec imported 3 million barrels of the world's dirtiest oil from
Does the honourable member have unanimous consent to the... I'm afraid we don't have unanimous consent. We have a point of order coming from the honourable member for Kings Hants.
Mr. Speaker, and again, I rise on a point of order today. Now, on Tuesday, we had a great discussion on Tech Frontier and the oil sands industry writ large in this country. And I'd like to thank the member from Lakeland for bringing that emergency debate so all members in this House could be able to bring forward their thoughts, and I appreciate having that chance. During the debate, I had an intervention from the member from Regina, Leuven, and I asked him, what about the 38 existing oil sands projects approved, representing 2.7 million barrels of oil that could start tomorrow? And he asked for the report, Mr. Speaker. He asked for the report. I have it here. I'd like to table it for the benefit of all members. Appendix C.
Yeah, sounds good.
Does the honourable member have the unanimous consent of the House to table the motion? No, I'm afraid we don't have unanimous consent. Any other points of order? The Honourable Parliamentary Secretary has a point of order. The Honourable member.
I rise today to simply point out that there are rules in this House. One of the main rules is that we have a chance to ask questions as well as respond to those questions. And unfortunately today, the Honourable member from Prince Albert did not follow those rules. After the Minister of Agriculture, actually during her response to her question, he was so loud, I had a hard time hearing her. I'm sitting literally 2 seats behind her, and following the question and the response, he decided to throw attacks at her and continue to launch insults. Now, yesterday, I don't know if the honourable member wore a pink shirt for Anti-Bullying Day. If he did, it wasn't worth the picture that it was printed on, Mr. Speaker, and I'm asking him to apologize to this House.
The honourable member for Prince Albert.
You know, Mr. Speaker, I do apologize to the House. I did act irrationally, but I would have to justify it in such a fashion that I have farmers right now, Mr. Speaker, that are looking at the weather, looking at the road bans, looking at their situation and their financial situations, and they need action. And this government does not seem to act unless it's a crisis.
I'm going to accept the honourable member's apology. I just want to remind the honourable members, when someone rises on a point of order about respect in the room and then they're shouting afterwards all around, there's an irony there, and I'm not sure I'm missing something. The Thursday question, the Honourable Opposition House Leader.
Thank you, Mr. Speaker. Very simple
simple question, a short question for the Government House Leader, if he could tell this House what the business is for the remainder of this week, and if he knows what the priorities would be when we return after our constituency week, that would also be appreciated. Thank you.
The Honourable Government House Leader.
I want to thank my colleague for a question, for a third question.
This afternoon we'll be continuing debate at second reading of Bill C7 concerning medical assistance in dying. Tomorrow is a supply day for the Conservative Party. The House will then be suspending for a week so that we can be in the ridings to do that important work with our constituents.
Upon our return, we will deal with Bill C4, the agreement between Canada, the United States, and Mexico, and C7, medical assistance in dying. Thank you, Mr. Speaker.
Okay. Orders of the day.
Government orders, government bills.
Second reading of Bill C7, an act to amend the Criminal Code, medical assistance in dying.
Okay, the Honourable Parliamentary Secretary to the Minister of Innovation has 5 minutes left in his speech. I'll let him continue.
Thank you, Mr. Speaker. And I'd like to continue talking about the Council of Canadian Academics, particularly when it comes to medical assistance in dying and people with mental health issues. As you know, Mr. Speaker, it's a very complex question, demonstrated by the fact that the CCA report reflected divergent opinions on the issue. For example, the report shows that mental health issues can hurt cognitive capacity, which can make it more difficult for a patient to understand the nature and consequences of treatment decisions. The term incurable is generally not used in clinical settings for mental illness, and so it makes it very difficult to determine whether the patient is really incurable or not.
The report points out that the autonomy rights of individuals with a mental illness must be respected. The report cites the experience of Belgium and the Netherlands, which permit assisted dying for psychiatric conditions with additional safeguards. However, the report also acknowledges that assisted dying for persons with mental illness in these jurisdictions remains controversial and the public debate is ongoing. Ultimately, the working group could not reach consensus on ways to address the complexities and mitigate risks associated with mental illness and medical assistance in dying. On a second topic, advance requests. The Council of Canadian Academies report on advance requests also documents considerable evidence and provided many instructive findings on an issue of great interest, of concern to many Canadians, and particularly in our riding, this was an issue that I heard a lot about. An advance request, as you'll understand, is a request for assisted dying made well in advance and in anticipation of the time when the person making the request may face suffering and other circumstances that may make them eligible for medically assisted assistance in death. An advance request would set out conditions under which an individual requests made to be provided at a future date. Advance requests are premised on the likelihood that when the person's health circumstances deteriorate to the point where they would want an assisted death, they would no longer have capacity to affirm their decision immediately before receiving medical assistance in dying. In other words, that critical requirement of giving final consent would not be possible. Many people express a desire to make an advance request so they have the comfort of knowing they will be able to avoid a lengthy period of grievous suffering for themselves, and not only for themselves, but also for their families. This is in the event they succumb to an illness that could leave them severely impaired and lacking cognitive capacity for a lengthy time period. The CCA report helped unpack advance requests in a way that really was helpful by outlining several scenarios of increasing complexity. The first scenario involves an individual at the end of life who's been assessed as eligible for medical assistance in dying, but fears losing capacity while waiting to receive it. And this is the situation experienced by Audrey Parker from Nova Scotia, who chose to receive MAID earlier than she had wanted in fear of losing her eligibility status. The second scenario involves an individual who's been diagnosed with a serious condition but does not yet qualify for medical assistance in dying. The third scenario involves an individual who wants to plan for various future outcomes prior to any diagnosis. The report indicated that when the request is farther in advance of the procedure, it becomes more challenging for healthcare providers to be certain that the request still reflects the wishes of the individual. And the report found that this first scenario poses the least risk and is relatively straightforward. Canadians expressed a great deal of support for the scenario in the federal consultations and is also widely supported by experts and practitioners. And our proposed amendments in Bill C7 would permit this type of advanced request. This means that an individual who has a reasonably foreseeable natural death and who's assessed and approved for medical assistance in dying can wait for their chosen date without worrying about losing decision-making capacity. If the person does lose capacity prior to that date, they would still receive medical assistance in dying on the requested date or earlier as expressed in their advanced wish. It also means that individuals no longer need to reduce required pain medications or endure additional suffering in order to maintain their capacity to consent right before the procedure. However, the other two scenarios where significantly more time passes between preparing a request and medical assistance in dying provision are far more complex and challenging. And now I know my time is running out, Mr. Speaker, but I just wanted to point out that we've definitely made movement on that first aspect. It's in those other two aspects where there's significant more debate, and those need to be taken care of by Parliament in the coming months, which is exactly what this bill provides for. Thank you, Mr. Speaker.
Questions and comments. The Honourable Member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. It's really interesting that this member actually makes very explicit the slippery slope that so many people are concerned about. Because when C-14 first came out, the ministers at the time defended it as representing a finely tuned balance between access and safeguards. And now we have legislation that removes safeguards, and this member talks about the possibility of new legislation very soon after the statutory review in June that would remove further safeguards. We've seen dramatic increases in the rate of people accessing euthanasia every one of the last 4 years. So I wonder if people should be reasonably skeptical when the government talks about the balance they're trying to establish, when every single time this comes up, they want to remove more and more of the safeguards. Just to pick on one safeguard, I mean, the idea that there could be a 10-day waiting period, one that can be waived in certain circumstances, but by and large is in place, that seems to be eminently reasonable. The idea that there should be 2 witnesses that observe the consent. These basic safeguards, a 10-day waiting period that could be waived, 2 witnesses, very reasonable things that the government wants to do away with. And it makes me wonder, the next iteration of this legislation, what safeguards at that point will the government remove? How many safeguards do they intend to take away? What's wrong with having some checks and balance in place protecting vulnerable people?
Honourable Parliament Secretary to the Minister of Industry.
Thank you, Mr. Speaker, and I thank the member opposite for his question. And I think this country has been going through an ongoing discussion on this issue, and this precedes the Carter decision. It goes even back beyond the Rodriguez case, and we've been having this conversation about what are the appropriate ways to secure the life, liberty, and security of the person while also respecting their dignity. And I think that this is not a question of removing safeguards. What this is a question of ensuring that Canada has a properly progressing discussion about issues that are very difficult. And granted, the bill brought in 2016, it was brought with significant time pressures, and there was a significant and robust discussion, but we left room for further discussion. That was the whole purpose of the reports that were prepared by the Council of Canadian Academies so that further reflection could be provided, and that was done. And those reports have really helped this legislation bring forward better proposals.
Questions and comments. The Honourable Member for Nanaimo, Ladysmith.
Equality. Thank you, Mr. Speaker. Listening to the debate today, I'd like to thank the Honourable Member for his speech. Listening to the debate today, one of the things I think we need to do as a Parliament is to make sure that we have national standards for palliative care and for a national mental health strategy that ties the provinces to the Canada Health Act and make sure that they spend money in these areas so that those aren't concerns going forward with this act. My question is about the final consent waiver, Section 3.2. It seems that it's tied directly to enter an agreement in writing with a medical practitioner or a nurse practitioner that medical practitioner or nurse practitioner would administer a substance to cause their death on a specific day. And I'm just wondering whether it is actually tied to that practitioner or whether it can be transferred to another practitioner in the case that that medical practitioner that they've made the agreement with is unable to go forward with those wishes at that time when they are in a situation where they do need medical assistance in dying.
Honourable Parliamentary Secretary, the Minister of Innovation and Science.
Thank you, Mr. Speaker, and I thank the member from British Columbia, from the island, for bringing that question. I must confess, that's an aspect of this bill that I don't know enough about. I'm going to have to go back and discuss with the Minister of Health, with the Minister of Justice, because it does raise an interesting question. Canadians do have access to different health practitioners, and so rather than say something that I don't know much about, I'd rather reserve comment, thank the member for his question, and then have a discussion with him separately. Thank you, Mr. Speaker.
Time just for a short question and response. The Honourable President of the Treasury Board.
Merci, Monsieur le Président. J'aimerais tout d'abord remercier.
Well, thank you, Mr. Speaker. I'd like to start by thanking the members for his speech when he talks about this very important issue. And I'd like to ask him a question, in fact. I'd like to ask him to talk about the double objective between protecting people who are vulnerable and the objective to work for dignity, greater dignity through greater freedom for people who are suffering. I'd like him to comment on that. The Honourable Parliamentary Secretary.
Merci, Monsieur le Président.
Well, thank you very much, Mr. Speaker, and I'd like to thank my colleague for his question. Clearly, this is a very sensitive matter. It's a complex issue and a highly, deeply personal one. From the conversations I've had with people in the Pontiac, everyone is concerned, not just about their own future, their own health, but that of their parents, their loved ones. Clearly, this is a matter of validating needs in society. The government must protect vulnerable people in society, but also ensure that there is equality. We must support the autonomy of people eligible for medical assistance in dying, but also prevent situations from occurring where families or people who don't have the capacity to make a decision are protected. So it's a very sensitive matter, and I'm very proud of the position our government has taken.
Honourable Member for Brandon Souris.
As a new member of the Justice Committee, I look forward to the issues that we will be dealing with in this new Parliament, and I'll be sharing my time today with my colleague from Saskatoon West. Mr. Speaker, while I'm not a lawyer, nor do I have any desire to become one, I hope my contributions and insight on the issues of the day will help in rebuilding trust in our judicial system. I'm fully aware that many Canadians have serious concerns. Many are looking for solutions that will keep our community safe, and they want us to begin the process of rebuilding the public's confidence in our justice system. The legislation we're dealing with today is one of those issues that almost every Canadian will have heard of, and they will undoubtedly be following in the news. And as a member of the Conservative Caucus, I can debate this legislation and vote on it as I see fit. It is my intent to improve this legislation and to do the best I can in representing the good people of Brandon Souris. Like many Canadians, discussing the implications of medical assistance in dying is challenging. There's no sugarcoating the fact that it is extremely difficult to openly discuss the issue of death for many people. In response to the Carter decision, it was left up to Parliament in 2016 to determine the appropriate legislative response in order to be compliant with Section 7 of the Charter. It must also be said the Carter decision was specifically limited to a competent adult who gave her consent in receiving medical assistance in dying. When we were seized with dealing with the legislation, many members of Parliament felt the government's response didn't go far enough. One of those Liberal MPs who voted against the legislation was none other than the current Minister of Justice. Some members were quite concerned about the lack of clarity, such as the term, quote, reasonably foreseeable, end quote, which was left undefined. Other members wanted Parliament to supersede the Carter decision. Disagreement is not new in this place, Mr. Speaker. It is to be expected in a Parliament with members from all political stripes and backgrounds. I would argue that our democracy is much better served having such divergent views as to guarantee that every position is fleshed out. When we debated C-14, our Conservative caucus studied the legislation with the rigor that Canadians demanded of us. We asked the tough questions. We put forward amendments, and we did what we were sent here to do, which is to ensure the concerns of our constituents were put front and center. It's my sincere hope that we once again invest the necessary time and be as inclusive as we can so that every Canadian has their say on Bill C-7. It goes without saying there are deep divisions on the overall issue of medical assistance in dying. I know every member of Parliament is hearing from their constituents on this issue, and in the past couple of weeks, numerous petitions have been sent to all members' offices. I'll also note that in the election, I received inquiries on the future of the legislation and in Parliament, and if Parliament would be reviewing it anytime soon. One of the elements of the original legislation was to have an automatic review, which will be undertaken this summer. Saying that, it is notable that the legislation that is now before us has preempted the automatic review on a few matters. This upcoming review will be far more comprehensive than the 2-week online survey used for Bill C-7. From what many were expecting, the legislation that was set to be introduced was to respond to the Superior Court of Quebec ruling. We now know that this is not the case. In fact, yesterday during debate, the Parliamentary Secretary of Justice acknowledged they did go above and beyond because that's what he thinks Canadians want. While that may be his opinion, Mr. Speaker, it is concerning that the larger changes found in Bill C-7 could have been dealt with in the larger review this summer. What we're debating today has numerous changes that go much further than deleting and replacing the phrase reasonably foreseeable in order to be compliant with the recent court decision. For example, the government is easing safeguards, which I might add is the actual language found within the presentation with which department officials briefed MPs. As it stands, patients must make a written request for MAID that is witnessed by 2 independent witnesses. In C-7, this has been changed to 1 independent witness. I believe it is incumbent on the government to justify this change and to outline the rationale why it needed to be amended. The government's also removing the mandatory 10-day period after the written request is signed. Once again, this is a significant change that goes above and beyond what was required to be in compliance with the Quebec Superior Court decision. It's my intent to invite as many experts, healthcare professionals, and provincial governments to committee to ask them about the proposed changes and to determine if they are in fact needed. And we must also be cognizant that MAID still has the necessary safeguards in place to protect the vulnerable. I also want to put on the record that many of the issues we raised in the last Parliament, such as enshrining conscience legislation in law for medical practitioners, has fallen on deaf ears. This was an almost universal position from my Conservative colleagues, while the Liberal government of the day didn't adopt those measures. We were also quite adamant about improving access to palliative care. While the delivery of health care falls under the purview of provincial governments, we passed a private member's bill to implement an action plan. My colleague from Sarnia-Lambton, who worked hard to get this legislation passed, is very disappointed the government's 5-year action plan failed to commit enough resources or outline a clear set of measurable outcomes. In a rural riding such as mine, there are not enough palliative care services available. My heart goes out to those families who must send a loved one to a different community in their final days of their lives. As a champion of rural Canada, I know firsthand the unique challenges that millions of people face every day due to this isolation or remoteness. I want to give the benefit of the doubt to the government that they are committed to rural Canadians, but their record says something completely otherwise. While these issues cannot be fixed in this legislation, we cannot treat them in isolation while discussing MAID. In closing, I want the government to know I am committed to working with them constructively on this legislation. I will ensure that the concerns of my constituents are heard, and we know there is nothing more precious than the gift of life. To live freely, to live safely, and to live healthy and happily. It's our collective responsibility to do what we can to improve the quality of life of all Canadians. I look forward to what my colleagues have to say on this legislation, and if it gets sent to our Justice Committee, we will do our due diligence to listen to witnesses and improve this legislation where possible. Thank you, Mr. Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Economic Development.
Thank you. I'd like to thank the member for his thoughtful speech. I enjoy working with him on the Standing Committee of Parliamentarians of the Arctic Region, and I think he gave a very positive speech. I just wanted to reply to a couple of items. Why now? Before that major review of the Act in June, it's just that we have no choice. The Supreme Court ordered it. On the 10 days, the medical practitioner suggested that the person may be incapable in those 10 days, so that wasn't necessary, and that was a bit problematic, as was the two signatures. On the palliative care, I agree 100% with him on that, and that's one of the reasons that for the first time in history in the last budget, we added $6 billion to the provinces to help palliative care, and I hope it's working towards exactly what the member would like. And my question for him is just to help me see, as I think about this bill, what his constituents did respond to him on this, on the MAID legislation.
Honourable Member for Brandon Souris.
Sorry, Mr. Speaker. I wonder if my colleague could just throw his question at me again there.
Just what did your constituents say to you?
Well, thank you, Mr. Speaker. I want to thank my colleague from across the way from the Yukon for his question as well. We have worked together on the Standing Committee of Parliamentarians of the Arctic Region for a while, and someday I'm going to have to get up there to Whitehorse to see how he operates. But anyway, I just want to say that that the people in my riding have given me very, very differing directions on this particular issue. As I said in my speech, there are many people with different ideas on how it should be done, whether it should be done at all. And so I've received the petitions from hundreds of people on both sides of this issue, and so we'll be listening intently. And as I said, if it comes to the Justice Committee that I am a member of, we will be looking for the input from the witnesses as I outlined, and making sure that we improve it wherever we possibly can.
Questions et commentaires. L'honorable député.
Questions and comments, the Honourable Member for Trois-Rivières. Mr. Speaker, I want to thank my colleague for his speech, and I'd like to know why he's opposed to the presence of a witness, a single witness, under MAID, when we know that normally family is present at the important time, and that normally there is love and affection surrounding the person.
Yeah, well, thank you. I want to thank my colleague for her question, and the only thing I can say on that is that the two signatures acted as a safeguard that was there before, and now it's one. They're shortening the time frame of the reflexive period on this as well, and so I think that we need to hear from the witnesses as to whether that should have stayed where it was or gone forward, but the government has put this in their bill to move it in that direction. I'm not saying that one witness is not enough. I'm just saying that the safeguards need to be there in place to protect those who are vulnerable.
Questions et commentaires.
questions and comments.
Guelph. Oh, sorry. Thank you, the honourable member. The honourable member for Esquimalt Saanich-Sooke.
Thank you very much, Mr. Chair, and I thank the member for Brandon Souris for his thoughtful remarks on this. Obviously, the original medical assisted dying legislation was about limiting the amount of unnecessary suffering when people are facing end-of-life issues, both for the individual and for their families. One part of this legislation that's been brought forward has been referred to as Audrey's Amendment, after Audrey Parker, a woman in Nova Scotia, who was felt forced to choose an earlier death than she would have liked and ended up missing a last Christmas with her family because she felt that she might lose competence and not be able to give consent at the end. So this bill that's come forward provides for those who have been assessed and approved to give instruction to their doctor that if they lose competence before their wishes are carried out, that they could receive that assistance and not have to make that ugly choice to go sooner than they would like to do. So does the member support that provision?
The honourable member for Brandon Souris.
I want to thank my New Democrat colleague for his thoughtful question as well, and I want to assure him that this is an area of concern. There's no doubt that that the situation that he has outlined is one of great importance in determining the situation that's before us, and it's one of the ones that will be coming back to our committee to deal with. I know I look forward to dealing with him as a member of the Justice Committee on it as well. And so at this point, I want to make sure that we hear from as many witnesses as we can. I have already heard from many in my area who are quite supportive of that, and the fact that if they have that 90-day period to be able to go forward, I think is one of the changes that they've put in this bill from the reasonably foreseeable change, and I do support the part of that particular bill that allows them to do that.
The honourable member for Saskatoon West.
Thank you, Mr. Speaker. Today I rise to speak on Bill C7, the Act to amend the Criminal Code, Medical Assistance in Dying. My office has received about 135 phone calls, emails, or letters so far on this issue, and so I recognize that this is a very touchy, personal, and nonpartisan issue. A quick bit of history. The MAID legislation came into law in June 2016. Recently, one judge in Quebec ruled that the legislation wording of foreseeable death was too restrictive, and so the Liberal government was very quick to accept this ruling. They chose not to appeal it and instead moved to rewrite the legislation taking into account the decision of the court. As I was thinking about that, it caused me to wonder, to compare this to the recent Alberta decision, court ruling where 4 judges found the carbon tax to be unconstitutional, and made me wonder if they're going to be as quick to accept the Alberta court ruling as well and not appeal it, but that's a digression. As I said, MAID is a very touchy, personal, and nonpartisan issue. Now, one can always find examples of people for whom MAID legislation is difficult but a welcome option. Unfortunately, those simple examples are usually in the minority. Far more often, it is much more complicated than that. Stories I have heard reflect these complications. A case where families are caught by surprise with a death and then forced to deal with the aftermath of that. Cases where a person is at a particularly low point in their health, but under this proposed legislation would be able to request and receive MAID with no waiting period. Cases where officials or physicians or hospital officials would apply pressure on individuals to consider MAID. And of course, there's the example of Roger Foley, who's an Ontario man suffering from an incurable neurological disease, who said the medical staff repeatedly offered him MAID despite his repeated requests to live at home. And there's also the BC case of Ms. S. Dr. Wiebe lamented Ms. S.'s profound suffering, but felt that Ms. S. was not eligible for an assisted death. And then unfortunately, Ms. S. decided to starve herself. Dr. Wiebe and another doctor then determined that Ms. S.'s severe malnutrition and dehydration made her natural death reasonably foreseeable, so Dr. Wiebe euthanized her on March of 2017. According to the Globe and Mail article, this case is the first to be made public in which a medical regulator has ruled on the contentious question of whether doctors should grant assisted deaths to patients who only satisfy all the criteria of the federal law after they stop eating and drinking. It is not difficult to imagine a situation where a hospital will, for reasons of efficiency, encourage its staff to suggest MAID to patients in chronically difficult and complex cases. It is not a simple problem. It is a very complex problem. I guess what bothers me a little bit about this is that the government is preempting the parliamentary review process that was specified in the legislation. We know that the current Justice Minister voted against the party on the original legislation because he felt it didn't go far enough. Now, as Justice Minister, he's able to make those changes that he desired. This is troubling because he is choosing to preempt the legislative review process and get his desired changes into legislation without the legislative consultation. The existing law mandates the review of legislation every 5 years, and the review will happen in just a few months. Why is the government in such a rush to make substantive changes to this legislation and preempt the legislative review process? To me, it makes far more sense to deal with the specific issue raised by the Quebec judge only, and then do a proper consultation this summer with Canadians and propose changes based on that. Instead, they have had an extensive online survey that lasted 2 weeks. And while they did receive a lot of responses, I think this just proves that there's great interest and Canadians have a lot to say about this issue. So far, the results of these responses have not been shared, and I ask for these responses to be shared. I would call on the government to do the right thing and leave any changes beyond what the Quebec judge has asked for until the completion of the review process later this year. Now, since we are talking about changes to this legislation, I want to talk about palliative care. There are calls for a pan-Canadian strategy on palliative care. And I think it's convenient to point to the provinces and say that this is their problem, but there cannot be a full end-of-life strategy without funds and laws around palliative care. The government broke a key election promise to invest $3 billion in long-term care, including palliative care. Access to palliative care is an essential part of end-of-life decision-making. I'll give you a personal example. Saskatoon has 12 beds, 12 palliative care beds, for an area with over 300,000 people. 12 beds for 300,000 people. Now, my mother-in-law had a terminal disease. In her case, MAID was not requested, nor was it desired. She was fortunate in that her death was relatively quick, and by a miracle, she was able to get one of those 12 beds in Saskatoon. Now, it shouldn't take a miracle to get good end-of-life care. And it shouldn't be that MAID is the only reasonable solution at the end of life because palliative care is not available. So I call on this government to put as much effort into palliative care as they have in MAID. Another significant area of concern is conscience protection. Physicians and health professionals must be given strong conscience rights. They must be able to be free to not participate and also be free of penalty or harassment for making that choice. They must also be free to not be required to refer to another health professional. They must have full conscience protections. Further, it must be recognized that the conscience objection of institutions must be protected. Institutions are not bricks and mortar. They are collections of people with values, and therefore institutions must also be given the right of conscience protection. Several Supreme Court cases are instructive here. The Supreme Court in 2015 in the Loyola case said that religious freedom under the Charter must therefore account for the socially embedded nature of religious belief and the deep linkages between this belief and its manifestation through communal institutions and traditions. In another 2015 decision, the Supreme Court said, a neutral public space free from coercion, pressure, and judgment on the part of public authorities in matters of spirituality is intended to protect every person's freedom and dignity, and it helps preserve and promote the multicultural nature of Canadian society. We must respect the multicultural nature of Canadian society. We must respect both medical professionals and institutions and allow them to have full conscience protections free from harassment and consequences. There are some specific changes proposed that I am concerned about. The current legislation includes a 10-day waiting period between when MAID is requested and when it can be administered. The current legislation already allows for this waiting period to be waived. It says if two medical practitioners are both of the opinion that the person's death or the loss of their capacity to provide informed consent is imminent, any shorter period that the first medical practitioner or nurse practitioner considers appropriate can be used in the circumstances. So there already is a provision to deal with this issue. There's no need to make changes. The situation has been contemplated and addressed in the current legislation. Another area of concern is the lack of safeguards for the mentally ill. Mental illness is a very complex situation. Patients diagnosed with an underlying mental health challenge are not required to undergo a psychiatric assessment by a psychiatric professional to determine whether they have the capacity to consent. There is no one-size-fits-all solution to the issues of mental health. However, it is not difficult to imagine scenarios where a person is in a particularly dark period in their life and considers MAID. It may well be that with proper professional help, that person can work through the darkness and emerge a bit better. This may not always be the case, but that is why having a general waiting period is so important. It eliminates the ability of a medical professional or a person to make a quick decision that they regret. A poll in January found that Saskatchewan and Manitoba have the lowest support in the country for MAID. In 2018, in Saskatchewan, only 67 of 172 applicants for MAID were actually received medically assisted death. Some were declined, some withdrew, and some died before their request could be completed. In summary, I would make the following observations. Most importantly, in the words of a constituent I spoke to this week, we need to slow this down, not speed it up. Yes, we need to deal with the Quebec court decision, but that only requires one change. There is a legislative review that will be happening this summer. Let's wait for a proper consultation and use that lens to view any proposed changes. Let's have a pan-Canadian strategy for palliative care. Let's put full conscience protection in place for physicians and healthcare professionals. Let's put conscience protection in place for institutions. Let's leave the 10-day waiting period and the ability to create exceptions the way it is. Let's deal with the Quebec court decision and leave the rest until after the legislative review this summer. Let's slow this down. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you very much, Mr. Speaker. I thank the member opposite for his contributions to today's debate. And I'll put to him that given that the preamble in the old Bill C-14 expressly references conscience protections, given that Section 241.2 sub 9 of the Criminal Code, which was amended by his party at his party's suggestion in the last Parliament, also has conscience protections, given that paragraph 132 of the Carter decision references conscience protections, and given that the Section 2 protection in the Charter is a bedrock foundational conscience protection, does the member, one, think that is sufficient in terms of conscience protections, and two, is there any instance of an institution of religious persuasion or otherwise being forced to provide this given those protections? Because I'm aware of none.
The Honourable Member for Saskatoon West.
There are cases that I'm aware of, to your last point, and thank you for your question, by the way. The reality is what happens on the ground, and so I've heard cases of people who are feeling pressured, people who feel harassed, people who do not want to participate. I'm speaking of medical professionals here who do not want to participate, and yet they feel harassed, they feel pressured, they feel criticized, and those types of things. So there are certain protections under the laws now, yes, but I think they need to be strengthened, and I think in practice it needs to be expanded.
Question commentaire.
Questions and comments? The Honourable Member for Shefford. Thank you, Mr. Speaker. I'd like to thank my colleague for his question, or rather for his speech. In his speech, the member spoke of rights and freedoms, so I would like to know whether he is aware of the Gladu and Truchon decision. These two people were suffering from a degenerative condition, and the judge ruled that the criterion of a reasonable foreseeable natural death infringed on their rights to liberty and freedom of choice.
Yes, I'm aware of that, and that is the part that I believe we should be pursuing now. I think the other changes that have been proposed regarding the waiting period and some of these other things should not be pursued now. I think the bulk of what's being proposed should wait until the consultation period of the summer. We need to deal with the request from the Quebec court and the ruling from the Quebec court, yes. The rest, I believe, we should wait.
Questions and comments. The Honourable Member for Esquimalt, Saanich-Sooke.
Thank you very much, Mr. Speaker, and I thank the Honourable Member for Calgary Centre for his speech on this. I would just like to talk about something that just happened just a few minutes ago, and that is someone that I know quite well who contacted me who is not currently eligible for medical assistance in dying, under the legislation and would probably qualify under the new provisions. This person is in intolerable pain and suffering and has reached out to many people asking for help. And so the reason I believe the government has decided to proceed with some of these changes is to actually meet that need to help us reduce unnecessary suffering at the end of life. This is not someone who's being pressured. This is someone whose condition is deteriorating quite rapidly and is, as I said, in enormous pain. So I ask the member to think about that motivation here for us to reach out and help those people and those families who are faced with this right now, not months from now.
Member for Saskatoon West.
Thank the member for his question, and I do enjoy Calgary, but I'm actually from Saskatoon West. There are many, many cases, specific cases that we can all think of that are, impacted by this, and people that are impacted by this. I still believe it is correct to wait for the review process to look at all these cases and make changes based on that. The other issue that I believe your question raises is the lack of palliative care. If there was more and better palliative care options, then I don't know about the specific case you mentioned, but more people would have other options than MAID. And so I believe, though, that's another solution.
We have time for just a short question and response. The honourable member for Cloverdale, Langley City.
In this debate, Mr. Speaker, we see that the safeguards we currently have are already not working. We know that quality palliative care is a necessary solution. And we all see a lack of access, even a revocation of palliative care in my province. The third thing is, unfortunately, the inability to ensure conscience rights protection. And in my province of BC, the former program director of palliative care had to resign when Fraser Health imposed MAID in hospice. And he believes that palliative care does not include euthanasia, since palliative care, by definition, neither hastens nor postpones death. So why is this government not working harder to ensure proper protections for patients and healthcare professionals?
Member for Saskatoon West.
Thank you. And yes, that raises some very good points. And it raises the issue of institutional conscience protections, and it also raises the issue of better palliative care options in our country. And so I think those are areas that we need to pursue just as vigorously as this government is pursuing the MAID legislation.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of International Development.
Thank you, Mr. Speaker. It's an honour to rise in this House to speak today about Bill C-7. This bill would amend the medical assistant in dying regime in the Criminal Code to address the Superior Court of Quebec's decision in Truchon. As members know, in September 2019, the Quebec Superior Court struck down the eligibility criteria of reasonably foreseeable natural death from the medical assistant in dying regime in the Criminal Code. Our government has made significant efforts to consult and engage with Canadians in order to inform the proposed approach to address this decision and to amend the medical assistant in dying regime in Canada. Mr. Speaker, an online consultation was launched and received over 300,000 responses from Canadians. In addition, the Minister of Justice and Attorney General of Canada, the Minister of Health and the Minister of Employment, Workplace Development and Disability Inclusion had the opportunity, along with their parliamentary secretaries, to meet with stakeholders and experts across the country during a series of roundtables all over Canada. These consultations were extremely important part of the development of Bill C-7. Medical assistant in dying is a sensitive and challenging social issue that we're currently faced with, one that is deeply personal for so many people, and for me, Mr. Speaker, personally, as I've worked as an oncology nurse at St. Joseph's Hospital in Toronto, and have seen firsthand the real individuals facing and having had experiences with end-of-life care and making difficult decisions about their end-of-life decisions for themselves or their loved ones. And I appreciate our government's decision to consult and listen carefully to Canadians on this issue. In addition to being deeply personal, the issue of medical assistant in dying is also legally and ethically complex, which is why it is so important for our government to meet with experts, stakeholders, practitioners during the roundtables. And our government listened, Mr. Speaker. It listened to the healthcare experts, doctors, nurses, legal scholars, and the regulators. But most importantly, Mr. Speaker, they listen to Canadians. The bill takes into account what was learned during these consultations and responds to the Truchon ruling by proposing amendments to the criminal code that would ensure consistency of the medical assistant in dying law across the country by broadening eligibility and adjusting the safeguards accordingly for a medical assistant in dying regime that is no longer limited to end-of-life circumstances. Bill C-7 proposes to amend the criminal code in response to the ruling in 3 ways. First, by expanding eligibility to those whose natural death is not reasonably foreseeable, but who are still experiencing intolerable suffering. This will give those who are suffering in a wider range of situations the choice of a medically assisted death. At the same time, Mr. Speaker, the amendments would exclude those suffering from only a mental illness. This is in response to very specific concerns voiced by experts and mental health professionals about eligibility on the basis of a mental illness. Many members will also recall that during the study of formal Bill C-14, the government asked the Council of Canadian Academics to look into such cases. The experts in this field could not come to a consensus on this very complicated issue in their report on the subject, which was released and tabled in this chamber in December 2018. Our government recognizes the unique considerations for the availability of medical assistance in dying for individuals experiencing suffering only from mental illness requires further discussion and public debate. I believe that the parliamentary review that will begin in June 2020 is the appropriate forum for the further consultation and deliberation that is needed before considering any changes in this regard. The second point, Mr. Speaker, and the main feature of this bill is the creation of 2 sets of safeguards to be followed before medical assistance in dying is provided, depending on whether a person's natural death is reasonably foreseeable or not. The bill will continue to use the expression reasonably foreseeable natural death as the element that determines which safeguards to use. This approach for a medical assistance in dying request is consistent with the view that medical assistance in dying for people whose natural death is not reasonably foreseeable presents more complexity. Many experts believe that the assessment of a request should be tailored to these different types of cases. New safeguards for those whose natural death is not reasonably foreseeable will focus on ensuring that assessments take adequate time and involve the relevant expertise to detect and address the sources of the person's suffering. They will also ensure that the person receives information about the appropriate and available services and options to improve their quality of life. They will need to give serious consideration to those options before concluding that medical assistance in dying is the choice for them. And finally, Mr. Speaker, the bill would relax some of the existing safeguards, in particular for those whose natural death is reasonably foreseeable. Those whose deaths are reasonably foreseeable will not need to undergo the 10-day reflection period. These individuals have already given a lot of thought to their request before they make it, and requiring them to wait another 10 days after they are approved for medical assistance in dying may prolong their suffering unnecessarily. Just as importantly, Mr. Speaker, the bill proposes to permit the requirement of final consent to be waived in the case of people whose natural death is reasonable foreseeable where certain conditions are met, such as the person's death must be reasonably foreseeable, they must have been assessed and approved for medical assistance in dying in accordance with all safeguards, that they're at risk of losing decision-making capacity before their preferred date to receive medical assistance in dying, and that they have written arrangement with their practitioner in which they give consent in advance to medical assistance in dying being administered if they lose capacity, and the practitioner agrees to provide medical assistance in dying on their preferred date or earlier if they can no longer provide the final consent. These proposed amendments would also clarified that practitioners would not be allowed in this situation to provide medical assistance in dying in cases where the patient demonstrates by words, sounds, or gestures refusal or resistance. Mr. Speaker, for individuals whose natural death is not reasonably foreseeable, the remaining criteria defining a grievous and irremediable medical condition in the Criminal Code would expand medical assistance in dying eligibility to people with a wide range of conditions. A grievous and irremediable medical condition is defined in the Code as one that includes a serious and incurable illness, disease, or disability, an advanced state of irreversible decline in capacity, and enduring and an intolerable suffering that cannot be alleviated under the conditions that the person considers acceptable. This means that a grievous and irremediable medical condition, could include conditions producing chronic pain or other symptoms. Canada's medical assistance in dying regime would move away from being an end-of-life regime and would become a regime where medical assistance in dying can be chosen to relieve unbearable suffering that occurs outside of the dying process. Now, to conclude, Mr. Speaker, the bill before us today proposes the amendments required by the Truchon decision. It also reflects what we heard in 300,000 responses to the online consultation. This is what we heard from stakeholders, with the ministers and parliamentary secretaries who held these consultations from coast to coast to coast. It takes into account of the opinions and input of healthcare professionals, doctors, nurses, legal scholars, provincial regulators, civil society, non-governmental advocacy organizations, and those with lived experiences. The bill strives to achieve a balance between respecting personal autonomy and protecting vulnerable individuals. But perhaps most importantly, Mr. Speaker, it respects the equality of rights of all Canadians. And for those reasons, Mr. Speaker, I call on the members of this House to support this bill, send it to committee where it can be looked at even more thoroughly, and make this a reality in Canada. Thank you so much, Mr. Speaker.
Questions and comments. The honourable member for Sherwood Park, Port Saskatchewan.
Well, thank you, Mr. Speaker. And I want to comment and pose a question to the member around, I think, one of the strands in today's debate. Members on our side have raised the need for safeguards because of the risk of abuse. And government members have said, I think responding to an argument that was not made, they have said, well, we trust healthcare professionals to make good decisions in the vast majority of cases. Of course, we also trust healthcare providers to make good decisions, to have good intentions, and to do all they can to stay within the bounds of a patient's well-being in the vast majority of cases. But the reason we have safeguards is to deal with that small minority of cases where someone could actually lose their life as a result of pressure, as a result of not proper review, as a result of being rushed into decision in less than ideal circumstances. Would the member accept that because of this need to have safeguards dealing with those small minority of cases where human lives are still very much in the balance, and we've talked about examples of that, that something like a 10-day reflection period, which can be waived in extreme circumstances already, but a default to a 10-day reflection period provides some degree of insulation against the possible risk that somebody in a dark moment in a sort of short-term thinking process will opt for something that on balance most of the time they would actually not opt for, and they wouldn't opt for with the sort of proper engagement and support of their full support structure. What's wrong with the 10-day reflection period?
The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. I want to thank my honourable colleague for his question. Mr. Speaker, I know this is a very complex and a very personal issue, but Mr. Speaker, for those whose death is reasonably foreseeable, the bill proposes to eliminate the 10-day reflection period, which many practitioners say can prolong unbearable suffering. It is about patient. It's about the individuals and their rights, Mr. Speaker. The requirement for 2 independent witnesses, which many experts indicated create difficulties for certain types of patients, Mr. Speaker. It would also be eased for eligible persons. Healthcare workers may act as independent witnesses, provided that they're not the provider of or the accessor. Thank you, Mr. Speaker.
Question and commentaire, questions and comments. The honourable member for Guelph.
Thank you, Mr. Speaker, and thank you to the honourable member from Brampton West, both for her speech today and also her work as a health professional. I'm sitting listening to her, thinking of what her patients must be thinking of her in the House now, speaking on their behalf. I've had many conversations with constituents that are facing the need to have this legislation improved. Particularly back in December, I spoke to a person who had a best friend that was trying to access medical assistance in dying. He also had a brother that was trying to access medical assistance in death. And the reasons that led them both to that was around ultimately their pain they were feeling, their loss of independence and dignity, and not foreseeable deaths. And those are the voices that really resonate at the end of the day, is the people that are trying to access services or their family members that know the situation they're in, and how important it is that we give priority to the voices of the people whose rights are being denied under this legislation. Could the honourable member maybe comment on how important it is that we protect the freedoms of the people that we're serving that are trying to access this type of service?
The Honourable Parliamentary Secretary to the Minister of International Development.
Thank you, Mr. Speaker, and I could thank my colleague for his very important question and for his ongoing advocacy on this issue, and we've had many conversations about this. It is, Mr. Speaker, very personal for me to speak on this issue, as I have in the past when the debate on medical assistance in dying first came to this chamber back in 2015. Because just before the election in 2015, I was a registered nurse. I'm still a registered nurse, working on oncology, working with patients, providing them palliative care, and helping them during their end of life. And those rights are what we're protecting today. So I think the member actually, in his question, answered his own question. So I'd like to thank him for that, and I think this bill does just that. And I hope that all members of this House, we pass this bill, take it back to committee, where there may be some discussions on how to make it better. So thank you, Mr. Speaker.
Question and commentaire. La députée.
Questions and comments, the honourable member for Trois-Rivières. Mr. Speaker, I want to thank my distinguished colleague. Yesterday, I spoke in this House about the need to clarify certain points in this bill. So in the same vein, I've noticed that it says that the legislation concerning eligibility for mature minors should be reviewed. And we've spoken very little about that issue here in this House. So I would like to know how my colleague would define mature minors.
Secretary.
The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. I'd like to thank my honourable colleague for the question, and she raises a very important one. And as I've said before, I think this is a very complex and a personal issue. It raises many difficult conversations, not just in this place, but I believe throughout the country, whether it is around mature minors, whether it is around mental health, whether it is around making sure that we're working with provinces and territories to continue to invest in palliative care, to make sure that people have the end-of-life care that they need and that they deserve. And Mr. Speaker, I think it's important to also make sure that we're protecting the people when it comes to with mental health issues or mature minors. And I think there's a broader discussion that we need to have, and that's why I hope that we can take this bill to the committee to have those conversations. And I know in June 2020 that there will be a broader discussion on this very topic. So thank you, Mr. Speaker.
Questions and comments. Question and commentaire. The honourable member for Cloverdale Langley City.
Mr. Speaker, my Liberal colleagues continue to push the myth that there's only 2 choices here. Option 1, horrific suffering. Option 2, euthanasia. Well, Mr. Speaker, there is a third option. And that option is the love in the form of palliative care that meets the true needs of the patients. Why do the Liberals insist on only offering a binary solution when our amazing health professionals want instead to offer a truly compassionate option of palliative care? Why are they pushing euthanasia ahead of palliative care?
Honourable Parliament Secretary.
Thank you, Mr. Speaker. I'd like to thank the honourable colleague for her question. And I want to correct the record, Mr. Speaker. There isn't two choices. There are many choices, but it's about the choice of the person that is going through the suffering at the end of their life, Mr. Speaker. That's what it's truly about. Someone that has worked with patients during their end of life, have provided palliative care to patients, Mr. Speaker, I can tell you, I am your biggest advocate to making sure that we're working and providing more palliative care, and not just in our hospitals, in our long-term care, Mr. Speaker, but also people want to be in their homes, Mr. Speaker. And that's why our government has worked collaboratively with our partners, such as the provinces and territories, to develop a framework on palliative care. To support this framework, our government is implementing a targeted action plan, which will help improve access to palliative care to underserved populations, families, supports, healthcare communities, and communities, Mr. Speaker. And in addition, Mr. Speaker, it's important to talk about the fact that we provided $6 billion in federal funding directly to provinces and territories to support better home care, palliative care in our own communities, Mr. Speaker. This is a conversation that we have been having, and I agree with the member opposite that we need to do more when it comes to palliative care and to ensure that we work with our provinces and territories to make it a reality for every Canadian. But to say that there's only two choices, Mr. Speaker, I think that's misleading this House, Mr. Speaker. I think it's about the choices of the patients, about the choice that they want, and respecting those choices. Thank you, Mr. Speaker.
Before resuming debate, I want to inform honourable members that we have passed 5 hours of debate since the first round on this motion. And so all of the following speeches will have to be limited to 10-minute speeches and 5 minutes for questions and comments. So resuming debate.
The Honourable Member for North Island, Powell River.
Well, thank you, Mr. Speaker. You know, I'm here today to talk on Bill C-7, which is an act to amend the Criminal Code talking about medical assistance in dying. And it's very interesting for me to be here in a new parliament discussing something that we spoke on in the last parliament. And I remember as a fairly new member of parliament when we had Bill C-14 in the last parliament before us, having a lot of constituents calling my office, sending letters, emailing us to talk to us about this very important issue. And I spent a lot of hours responding to people on the phone, talking to them and hearing their stories. And what I really respected was the thoughtfulness that was there. There was concerns, of course, I think that's legitimate. And there was a lot of hope for some people as well. And so here we are back at it again. And it reminds me of somebody very important to me who used MAID in his journey. Joey, who was a dear friend and loved one of mine. And when I think about the core issue and value that we're discussing today, which for me is unnecessary suffering, I can't help but think of Joey. So Joey had an illness that was slowly killing him. And in fact, it was so painful for him that he made this decision. And I was very sad to say that he actually rearranged his time of death so that I could be there with him, which was a huge honor for him, for me, I should say. I was so grateful for that. And when I think about the process that we went through that day together, it was a beautiful process, but it was also a hard process. And part of the reason that it was hard was because he couldn't take any of his pain medication that day, because he had to be totally able to answer that question. After a lot of thoughtful discussion, he had to stay in pain all day. So we spent the day with him. But it was hard to see him suffering in that way. So when we look at the bill before us today, I think that that is what I hope all Canadians and all of us as parliamentarians remember, is what we are here to do is to make sure that nobody goes through unnecessary suffering like that. You know, one of the things that really struck me about that day when Joey passed was that his doctor came to be part of the process. His doctor is a doctor who made a decision. He did not want to be in a role to administer MAID, but he came. There was a lot of tears and a lot of sort of remembrance of the long-term relationship, and I think we have to also talk about that in this House, how long some of our doctors have known us. They've known us for years in some cases, and in this particular case, that was the reality. And then the other doctor came and helped administer, and his doctor was with him, his loved ones were around him, and it was a peaceful process when he left us. So today we're here to do this important work. I hope that this goes to committee. I think there's a few things. I've had some discussions with doctors in my riding who administer this process, and they have a lot of good things to say about this bill and some concerns that they're hoped that will be addressed, and I hope that that will happen. But I have to say that, you know, as this process came, a lot of people started writing my office again, and we did some outreach. We wanted to let people know that this was going to be coming up in the riding. We wanted them to know that there was a process that they could connect and give their feedback to the government on this issue. And so a lot of my constituents participated in the process online, and not only did they participate in that process, they were very thoughtful and made sure that the information that they had submitted was also given to my office. So in front of me, I have just a small portion of the people who sent us information and shared their stories. And I want to say one of the things that resonated for me through this reading, because I want to be clear, and I think this is something we have to also remember as we go through this legislation. I represent a rural and remote community. The doctors that provide this service sometimes spend the whole day just traveling to the community where they're going to be providing this very important service. So there are some specific barriers, and we want to make sure in all of our legislation that we don't let those people in rural and remote communities down. So I hope people know that. And that the doctors, there's 3 of them in my region, and my riding is just under 60,000 square kilometers. There's several ferries, many small islands. The doctors in that area provide the total service for that area plus a portion of my neighbor's riding. So they deliver this service to a huge amount of people over a vast distance. And in the messages that I heard again and again was thank you to those doctors. In fact, Dr. Dawes is a doctor in my riding. Her name was mentioned repeatedly of being compassionate, of helping people go through this process in a very respectful way. People wrote to me before they were actually going to participate in MAID and said, I just want to say that this doctor has helped me through this process. So I just want to recognize the amazing healthcare providers in this country that provide this service, who do it in this sensitive and beautiful way, and are with people at one of the most precious moments for their families. So I want to talk about Margaret, who got a hold of us, and she told us about her nephew. And her nephew had participated in MAID, and that was what the decision he made was. But the biggest issue for her was the lack of the advance consent clause. So he was given a choice of either doing this process 2 months earlier or not at all, because due to the medication that he would have to take for his illness, it would automatically disqualify him from having the capacity to provide the consent. So, you know, this is the biggest issue in this bill for me, is how many people talk to me about people having to leave sooner than they wanted to because they were afraid they were going to lose the capacity to give their consent. I think of Megan, who wrote here about the experience that her family went through. They were present for a friend's death. And she said, I fully support the idea of giving prior consent for MAID in case one is unable to give that consent immediately prior to the procedure, or in case one is in considerable pain and discomfort and would go through the process more calmly with adequate pain control at the end. You know, for me, this really resonated with my experience with Joey, watching him suffer physically, waiting for the relief. It was really hard, and I think that this is so important as we go through this process. And I think about Dolores, who sent us a beautiful message about making sure that the process was clear for people, wanting to have the accessibility to this be really clear and easy and an information packet. And her biggest concern is that her family physician did not believe in this process and didn't give her the information that she needed to make the decision she had to. And so she said it would be good to have just an information package that's a little bit more effective, so that when a doctor is struggling with that personal choice, that it doesn't impact the patient. You know, again, I can't tell you how moving. And I think as a parliamentarian, these are the moments where you really respect the role that you have in a whole new level. When people are telling you about experiences they've had in their life that are so precious. You know, this family talked about their father-in-law who spent 7 years with dementia and was very well cared for, but in his last year rapidly deteriorated and his dignity plummeted. And he, as you know, a loving son, said, "I'm convinced that if he could have projected how his final years of deterioration would have happened, he would have chosen MAID as an option if it was available to him." Or Milt, whose wife is in a care home, and because of her Alzheimer's will not be able to express herself, and he's so concerned that she's going to suffer way too long, and he does not want to see her suffer. Or this family that talked about a friend who had cancer of the brain, and she had a stroke, and after she had her stroke, she was concerned that if she had a second stroke, she would be unable to say what her wishes were. And so because of that, she actually participated in MAID sooner than she perhaps would have wanted to. You know, for me, when we talk about this is a precious decision that people make. It's a decision that they make with their loved ones and they make with their health professionals. For me, I will be supporting this bill because I don't believe in having people suffer unnecessarily. And there are some challenges in this bill that I hope are clarified, especially looking at the realities for rural and remote communities. But when people are telling these personal stories, what we hear again and again is we don't want to see them suffer, we don't want to see them lose their dignity, and we want to make sure that their wishes are honored. So I'm happy to be here to talk on this bill. I want to thank all of my constituents who have reached out to us in the riding. I always appreciate these beautiful stories that people share and some of the hard ones. Thank you, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Economic Development.
Thank you. And I'd like to thank the member for a very heartfelt speech. I think it's one of the best ones we've heard, and because of her personal opinions. And she mentioned that the important thing for her was people that so they don't have to end their life earlier than they should need to because of they wouldn't be capacity. And the other great thing, I think, or positive item, major positive item, is people that don't have access to MAID at all right now. And that makes it for them. I just wonder, the member mentioned near the beginning of her speech that she had some suggestions from healthcare professionals. I wonder if she could outline any of those to us.
Honourable Member for North Island, Powell River.
Thank you, Mr. Speaker, and I thank the member for his question. Some of the things that I've heard from the professionals in my riding is just language around who will get to decide what a specialist is. So there's some of those languages, especially for rural and remote communities. Who are they identifying? If somebody's had a long condition, obviously they've met with the specialist. So what time is that process? So it's a little bit of just clarifying what that language actually means. Some of the other issues are the 90 days, concern about how long that's going to take. Again, if we're coming back to people suffering in profound ways and wanting to make a decision, we have to look at some of those numbers. So I think language language is the biggest part, and we need to make sure, as always, that legislation is as clear as possible, that we understand where we're legislating so that the language matches the practice. So hopefully some of those things can be fixed up. I believe they can. I hope that everyone in this place sort of has that awareness that what we're here to do is to obey the law, and that's why we're here today, is because of the court decision in Quebec, but also to make sure that we're supporting people in access and that we prevent suffering at all costs. Thank you.
Questions and comments. The Honourable Member for Yorkton Melville.
Thank you very much, Speaker. And I've listened very intently and appreciate the heart of the member in what she is saying. And we work together on Veterans Committee. And so I would like to talk to her a little bit about that dynamic. Specifically here, it talks about the need that the patient's death no longer must be reasonably foreseeable, but requires patients to still have a grievous and irremediable medical condition. I think she and I appreciate and deeply are concerned about our veterans and the number of them that are choosing to end their lives because of the circumstances that they find themselves in, coming back not feeling well. And I'm so concerned that it's antithetical to trying to prevent them taking their own lives, and yet saying to them, here is an opportunity for you to do this. And as well, my father has Alzheimer's and passed away 2.5 weeks ago. And as he was barely able to still control his thoughts, looked at my mom, and his words were, will you take care of me? And that was 9 years ago. So I can tell you that the care he's had, the palliative care he's had, the love that he's had in that circumstance, I can't imagine, even though he was down to nothing, not honoring the fact of life and death in that circumstance the way it was.
For North Island, Powell River.
Well, thank you, Mr. Speaker, and I thank the member for her question, and I thank her also for the work that she does with me in Veterans Committee. I, too, share a deep concern and admiration for the people who have served this country. And, you know, when I look at some of the things that I would like to see done to support our veterans, she knows them well. She hears me in committee talk about the supports that need to be in place. When I look at this legislation, though, what I keep coming back to is that people have a fundamental right to make the decision that works for them. And I appreciate deeply the story she shared about her father and her loved one. But I have also sat with people who were ready to go. And I remember the years that I spent as a hospice volunteer, and I would be in the hospital with families and with people as they were in that process. And there were some beautiful moments that I feel so honored that I got to be a part of, and just bringing people food and reminding them to eat when they were going through that incredibly sad time was something that I will never forget. But I also remember the people who were starving themselves and refusing all help that they could have gotten because they so just wanted to be out of their body. They wanted to be out of their pain and their suffering. And I think that when we look at that process, we have to honor all people's decisions, and that's what I'm hoping to see through this legislation.
Resuming debate, the Honourable Member for Richmond Hill.
Thank you, Mr. Speaker. It gives me great pleasure to once again rise in this House and intervene at Bill C-7, an act to amend the Criminal Code, medical assistance in dying. Mr. Speaker, this bill proposes amendments to the Criminal Code provisions on medical assistance in dying or made in response to the Superior Court of Quebec Turgeon decision, which struck down the eligibility criterion requiring the natural death be reasonably foreseeable. I would like to highlight five major components as I reviewed the bill that stood out for me. First, it repeals the condition that a person's natural death be reasonably foreseeable, with the exception of patients whose sole underlying condition is mental health issues. Two, it introduces new safeguards in addition to existing ones for patients whose natural death is not reasonably foreseeable. Third, it also permits the waiver of the requirement for final consent, allowing patients to provide consent to healthcare practitioners in advance in the event that their death is naturally foreseeable and they're at risk of losing capacity to consent. Fourth, it permits the waiver of the requirement for final consent if a patient chooses made by self-administration in case complication arises following self-administration, such as a loss of capacity. And finally, fifth, it modifies the MAID monitoring regime to require that healthcare providers and pharmacy technicians provide regulated information when assessing a patient's eligibility or when dispensing a substance for MAID. Mr. Speaker, over the last 2 days, many of my colleagues from both sides of this House intervened on the amendments at fair level of details. And it gives me great pleasure to see that there is broad agreement that this legislation, with these amendments, get voted in and move to the committee for further study. I rose in this House on the 42nd Parliament back in 2016 and shared my experience, which dealt with tragic loss of my father as a result of stage 4 cancer back in 2014. Such assistance were not available to us, and we saw the loss of dignity, the loss of what I call my hero, losing their capacity to be able to function and lead the community and lead our family, as well as the fact that his desire would have been met given the fact that we had these type of assistance available. Also, as the chair of the All-Parliamentary Mental Health Caucus, I have been advocating, and our caucus has been advocating for consideration of mental health and exclusion of that. So I'm pleased to see that that remains. As I was listening attentively to the interventions over the last 2 days, I realized at times there was question raised vis-a-vis why did it take so long. So considering that and considering that we are almost halfway through this debate, I decided to focus my intervention mainly on the journey that our government has gone through the last 4 years. And the key concept of within that journey is the challenges that we're faced with, the stakeholders that we through this process engage with, the consultations won, the studies were done, and the implementation and the successes and the challenges we've had. So having said that, Mr. Speaker, since the introduction of the legislation for medical assistance in dying 2016, we have witnessed a steady increase in the number of Canadians and healthcare providers who have adopted this new regime. We've seen a relatively smooth integration of MAID assessment and delivery in end-of-life care service available across the country. The enactment of this historic legislation was just the beginning of our efforts. Our government has since been very active in supporting the implementation of MAID across Canada. The 2016 legislation included clear directives for actions, including the need for government to initiate independent reviews on 3 complex issues not addressed in the bill back in 2016. Some of my colleagues before me touched on those complex issues. Rather than proceed too hastily, the Parliament felt that they require more study and the review of available evidence. The government tasked the Council of Canadian Academics with undertaking these studies, and that's where the journey starts. The resulting report tabled in Parliament in 2018 reflected an extensive review of academic and policy research, stakeholder submissions, and international expertise in all 3 areas. They documented a range of perspectives from healthcare professionals, academic disciplines, advocacy groups, and Indigenous leaders, hence the stakeholders that we have engaged with. We expect dialogue on these issues to continue during the parliamentary review, and as I indicated, I hope this everyone in the House votes and we can move this to the committee so we can further continue this dialogue. Taking into account our federated system and division of responsibility for healthcare and criminal law, the federal government developed a monitoring and reporting regime to collect valuable information about requests for and the provision of MAID. In all other jurisdictions permitting assisted dying, there is an oversight and monitoring mechanism in place. The roles and responsibility of these monitoring regimes varies. In the wake of this monumental shift toward legalized assisted dying, Canadians wanted to know what kind of uptake there would be. Some were keen to know how accessible MAID would be across this vast country. Others wanted to know how safeguards would be applied and if there were protections in place for the vulnerable. Our government worked quickly with the provinces and territories to establish an interim reporting system, collecting and reporting on the best data available. Mr. Speaker, I want to acknowledge our provincial and territorial partners who had the challenging task of arranging safe access to MAID services from scratch in a short period of time and in collaboration with multiple partners such as healthcare providers, professional association, and healthcare delivery institutions. This tremendous task involves setting standards of practices for physicians, nurse practitioners, and pharmacists to support consistent and safe delivery of MAID within legally sound framework. It also helped minimize the disparity to access in rural and urban areas. Our government produced 4 interim reports using data voluntarily transferred by providers and their jurisdiction from 2016 until creation of the permanent regime in late 2018. These reports covered 6 months period and provided information on the number of MAID deaths, patient demographic information, and underlying medical condition and predicted MAID requests. In reviewing these reports, we know that the awareness of MAID as legal option is growing. There appears to be a growing comfort among healthcare providers. In the interim period, our government worked to establish a permanent national monitoring and reporting system as considered in Bill C-14. Through stakeholder consultation and collaboration with provinces and territories, the government enacted federal monitoring regulation in late 2018. These regulations set out the reporting requirement for all physician, nurse practitioners, and pharmacists who participate in MAID. We were mindful of balancing the need for information while limiting the reporting burden on healthcare providers and avoid duplication of effort. The system has been operating for just over a year, and late this spring, our government plans to release the first annual report using data from this new monitoring system. Mr. Speaker, the budget 2017 announced $11 billion over 10 years to support home and community care services, including palliative care, mental health, and addiction services. $6 billion of those were specifically allocated to those services that I talked about. 2019, our government worked with all the provinces, territories to develop the framework for palliative care in Canada, which I consider a cornerstone of this bill. Mr. Speaker, over the last 3.5 years since MAID has been available, our government has worked to support its smooth integration into the healthcare system based on the foundation I have just laid out for you. And the evidence we have gathered, we have put together a bill that represents the Trojan decision and addresses the other issues where there are clear consensus and reasonable path forward. It is my hope that after due consideration and the debate, we move this bill to the committee, and I close by indicating that I support this bill, and I thank all the members for intervening on this great topic. Thank you, Mr. Speaker.
Questions and comments. Question commentaire, the honourable member for Calgary, Rocky Ridge.
Thank you, Mr. Speaker, and thank the member for his speech. I did support Bill C-14 and voted for it at the last Parliament. I thought that it did strike the right balance. It was a very limited application, and I was troubled at the time, though, about the reasonable foreseeability words. I thought that was likely to be litigated, and indeed it was. I would ask the member, why not now simply deal with the narrow issue of the court only? There was a reason at the time to have a full 5-year period before revisiting a significant expansion. The reason was to collect a broad volume of data to examine how this how Bill C-14 would be implemented. So why the expansion beyond the narrow issue of the court decision?
Honourable member for Richmond Hill.
Thank you, Mr. Speaker, and through you to the honourable colleague. Thank you for the great question. As the honourable member mentioned, we had an opportunity to only deal with the narrow changes that or amendment that was required to respond to the Supreme Court of Quebec on the Georgian court. But what we had heard through the consultation, and I believe I went through this list of stakeholders who have engaged and what we've heard and the journey that we've been to. And through that journey, we had heard other areas that we needed to be able to address. And we found this opportunity. This is an opportune time to be able to not only address the area that were mandated by the Supreme Court, but also table other potential amendments to be not only to let our stakeholders know that we've listened, but also send it to the committee where we have the opportunity to be able to study it further. Thank you, Mr. Speaker.
Question et commentaire.
Questions and comments? The honourable member for Rosemont-la-Petite-Patrie. Thank you, Mr. Speaker, and I'd like to thank my colleague for his speech. We at the NDP will support this bill so it can be referred to committee and possibly improved. However, I'm personally concerned with the fact that some people who have a cognitive degenerative disease like Alzheimer's, why can a bill like this not include an advanced request where the patient can work with a healthcare professional and perhaps make an advanced request that can be renewed every 6 months?
Thank you, Mr. Chair, to the honourable member across. First of all, let me thank you for supporting the bill and giving an opportunity to be studied in the committee. And I'm sure this is going to be one of the areas that we will spend a fair amount of time to this point. Having said that, it is best that we actually look at it from a holistic point of view and consider all the options that are available. And this is one of the options that I think it would be worthwhile considering and looking into. Looking forward to your input during the intervention at the committee.
Yeah, we actually have time for one other short question. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you very much, Mr. Speaker. And I want to ask the member just very quickly about the 10-day waiting period. Now, right now, there is a 10-day reflection period. However, that reflection period can already be waived in certain circumstances. But it is a good default that some time is spent in consideration, that it's not a person decides in the morning that they want to have euthanasia and then it's taken care of more or less right away. There should be some period of reflection. Would the member not agree that in most cases that is sensible?
The honourable member for Richmond Hill.
Once again, through you, Mr. Chair, to the honourable member, I'd like to thank him for his intervention. He has raised this point to other intervention. And I personally agree that there needs to be that 10-day period. And the beauty of this bill going to the committee, this gives us an opportunity to be able to discuss that in further detail. But personally, from my position, I think we need to consider that as part of the safeguard. Thank you, Mr. Speaker.
Before we get back to resuming debate, it's my duty, pursuant to Standing Order 38, to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The honourable member for Sherwood Park, Fort Saskatchewan, in respect to public safety, and the honourable member for Leeds, Grenville, Thousand Islands, and Rideau Lakes, with respect to ethics. And I see the Honourable Parliamentary Secretary to the Government House Leader rising, perhaps on a point of order. He'll clarify.
Thank you, Mr. Speaker. Indeed, you're correct. I rise on a question of privilege respecting the premature disclosure of the contents of a bill between the notice and introduction period. The member for Markham-Univille gave notice of a bill entitled An Act to Amend the Criminal Code, bracket, unlawfully imported firearms, and a bracket, on Friday, February the 21st. On February the 24th, the member for Markham-Univille, in an article published on iPolitics, disclosed the contents of the bill. The article in question revealed the following, and I would quote, "The member for Markham-Univille is introducing legislation that would amend the criminal code to increase mandatory sentence to 3 years for someone in the possession of a gun illegally brought into Canada. If an offender is found guilty of owning a smuggled gun a second time, their prison sentence would be a minimum of 5 years. And a quote. The article continues to disclose the content of the bill, and again, I would quote, Mr. Speaker, the proposed law changes would also see a maximum amount of prison time that could be awarded to somebody who owns a smuggled gun increased to 14 years, both the first time they break the law and in every offense that follows. End of quote. On Tuesday, February the 25th, the member from Markham-Unionville gave notice of a new bill entitled An Act to Amend the Criminal Code, brackets, possession of unlawfully imported firearms. And today, Mr. Speaker, February 27, the member introduced the bill as C-238. While I would note that there was a slight change to the long title, the bill C-238 accords directly with the details of the bill which were published in the article by iPolitics on February the 24th. Clause 2.1 of C-238 provides, and I would quote, every person who commits an offense under subsection bracket 1 when the object in question was obtained by a commission of an offense under section 103 bracket 1 is, if prosecuted by the indictment, liable to imprisonment for a term not exceeding 14 years and to a minimum punishment of imprisonment for a term of A in, or bracket A in the case of a first offense, 3 years, and bracket B in case of a second or subsequent offense, 5 years, end of quote. The provisions of Bill C-238 just quoted accord directly with the characterization in iPolitics article on February the 24th, which was provided earlier in my intervention. While I do not want to impute unworthy motives of the member for Markham-Unionville with respect to his bill, it does raise certain questions. I submit that the member for Markham-Unionville is attempting to do indirectly what he knows he cannot do directly, Mr. Speaker. I submit that the practice of placing a bill on notice, then making public the content of the bill, then placing another bill with a slightly different title to avoid a charge of the premature disclosure of the content of a bill would set a dangerous precedent. In short, using this approach would subvert the principle that members should be the first to see the contents of a bill. I would also like to draw the attention of the members Speaker's ruling earlier this day concerning two bills that were substantially similar despite a different long title. The Speaker stated, and I would quote, Mr. Speaker, I would like to take a few minutes to inform members about an error on the order paper. Two private members' bills, which are substantially the same, are currently listed under private members' business, items outside the order of precedence. Specifically, Bill C-212 on the Employment Insurance Act, standing in the name of the member from Elmwood Transcona, was introduced and read a first time on Thursday, February the 20th, 2020. And Bill C-217, standing in the name of the member for Selberry-Surroot, was introduced and read a first time on Monday, February 24, 2020. Pursuant to Standing Order 86 Bracket 4, the Speaker can refuse notice if he determines the two items as to be substantially the same. As a result, Bill C-217 is currently before the House in error. I therefore direct that the order for the second reading of Bill C-217 be discharged and the bill be dropped from the order paper. End of quote. Mr. Speaker, it would be interesting to see if the first bill that the member for Markham-Unionville had placed on notice, if introduced, would be determined to be substantially similar to C-238. While I cannot confirm this to be the case, but it certainly gives rise to the assumption that the bills would be substantially similar. I further submit that if this practice was determined to be an acceptable practice, I can only assume that this approach could become common practice. Could you imagine the government placing a bill on notice, then making public statements with comprehensively disclose the contents of a bill, then make a slight change to the long title and place this new bill on the notice, followed by its introduction? This would be seen by members, and perhaps by even you, Mr. Speaker, as a clear departure from the long-standing principle that members should be the first to see the contents of a bill. Mr. Speaker, I will not waste the precious time of the House reciting the numerous precedents that support the conclusion that a premature disclosure of the contents of a bill between a notice and introduction period has been determined to be a bona fide question of privilege. I do not begrudge the member from Markham Univille for his attempt to get out his message about what his bill would accomplish and to provide the details of his bill to solicit public support for the bill. The fact remains that it is an affront to the privileges of the House to disclose a bill's content before members of this House have had the opportunity to see the bill once introduced. I understand that there was a very similar issue that was raised on February the 25th with respect to the unfortunate premature disclosure of the medical assistance in dying legislation. As a result, if you determine this matter as prima facie question of privilege, I would suggest that both matters be referred together to the Procedure and House Affairs Committee. Mr. Speaker, I await your decision, and if you agree, I will be prepared to move the appropriate motion at the said time.
I thank the Honourable Parliament Secretary. I see the Honourable Member for Barrie Innisfil rising as well. This would be on the same question of privilege. The Honourable Member for Barrie Innisfil.
Thank you, Mr. Speaker, and that's correct. And while I respectfully disagree with my honourable member, I would like to reserve the right of the official opposition to respond at some point to the point of privilege, Mr. Speaker. Thank you.
Thank the Honourable Member. I see the Honourable Member for Fundy Royal. Is it on the same point? The Honourable Member.
On the same point, Mr. Speaker, the Honourable Member mentioned they did not want to waste the time of the House, yet he went on when we're debating medical assistance in dying on a point of privilege about a private member's bill. And I just point him back to earlier this week when the entire contents of Bill C-7, Medical Assistance in Dying, was in a CP story the morning before the bill was introduced, just for his reference.
I think we, the intention, order, the intention was not to sort of get into debating the various aspects of the question of privilege at this point in time, and be assured, the Honourable Parliament Secretary, that we'll get back to the House in due course, and to the Honourable Member for Barrie Innisfil that noted the intention to come back to this at a later time as well. Resuming debate, the Honourable Member for Sturgeon River Parkland.
Thank you, Mr. Speaker. I'm rising today to address Bill C-7, an act to amend the criminal code in regards to medical assistance in dying. Assisted dying is the leading moral and ethical issue of our time. Previously respected traditions supporting the sanctity of all human life until natural death have been tossed aside, most recently with the Supreme Court's decision in the landmark Carter case. As parliamentarians, it is incumbent upon us to draft responsible legislation that protects the sanctity of life, protects those contemplating suicide, and protects vulnerable peoples. These are principles outlined in the preamble to C-14, the landmark legislation that governs assisted dying in these countries. These are principles that, although restated largely in Bill C-7, are being watered down and undermined by this legislation. As recently as the early 1990s, the Supreme Court ruled in the Rodriguez case that there was no constitutional right to assisted dying in this country. The Carter decision overruled that previous decision, and now Parliament has been tasked to take on the difficult task of balancing the autonomy of Canadians with protecting vulnerable people.
Excusez-moi, it's a rappel au règlement.
The Honourable Member for Shepherd, we need to respect parliamentary tradition. I'm sorry, I did not quite get that. Could you please repeat the point? I rose because I could not hear the interpretation, Mr. Speaker.
We'll have if there is still, is it operating now? Functioning well? Okay. All right, we're going to go back to, thank you for bringing this to the attention. Merci pour l'attention concernant l'interprétation.
Thank you for the reminder that we need the interpretation.
River Parkland.
Thank you. Would I be able to restart, Mr. Speaker, for the benefit of my colleagues?
Here, here. Perhaps if you could go back about 30 seconds or so and pick it up from there, that would be great. Thank you.
So as parliamentarians, it is incumbent upon us to draft responsible legislation that protects the sanctity of life, protects those contemplating suicide, and protects vulnerable peoples. These are principles that were outlined in the preamble to Bill C-14, the landmark legislation that governs assisted dying in this country. And these are principles that, although largely restated in Bill C-7, are being watered down and undermined by this legislation. As recently as the early 1990s, in the landmark Rodriguez case, they ruled that there was no constitutional right to assisted dying in this country. The Carter decision overruled that previous decision, and now Parliament has the difficult task of balancing the autonomy of Canadians with our responsibility to create safeguards for vulnerable Canadians. And it is one of our most sacred responsibilities, Mr. Speaker, to protect the lives of our citizens, and we need to get laws on assisted dying right. The adoption of medical assistance in dying after the 2015 election is an event that I'm very familiar with. I had the honour of serving under the member for St. Albert Edmonton as he took the lead as the Conservative Vice Chair of the Joint Senate House of Commons Committee on Physician-Assisted Dying. And during this time, I was involved in all aspects of the committee that was making recommendations on a new law. I heard from all the witnesses, and I listened to all deliberations regarding what direction our country should go. That committee recommended a radical departure with very few safeguards, and these recommendations did not reflect the testimony of experts, but instead the political agenda of special interests. The Conservative Minority Report provided at the Joint Committee was entrenched firmly in the principles of the Supreme Court's decision in Carter, and included recommendations that were laid out by key witnesses, such as the former president of the Canadian Psychiatric Association, Dr. Kay Sonyu Gain. It outlined key principles for us on the issue of physician-assisted dying. These include not accepting the provision that assistance in dying be provided to those under the age of 18, in line with the Carter decision that only competent adults should be allowed access to assisted dying. We also did not accept the extension of medical assistance in dying for those suffering exclusively from mental illnesses, and we do not believe that any mental illness is irremediable, as the Canadian Psychiatric Association stated. We also do not believe in the validity of advance directives to allow Canadians to consent to an assisted death far in advance of its administration, a change that would stand opposed to the express will of the Supreme Court, which ruled that consent must be contemporaneous at the time of death. We also recognized the lessons of the Quebec experience as the first jurisdiction in this country to legalize euthanasia. In their regime, medical assistance in dying could only be rendered on adults with a severe, incurable physical illness characterized by an advanced state of irreversible decline. Many Canadians, I believe, can sympathize with this limited exception for assistance in dying. However, even these safeguards have proven short-lived. Barely 5 years later, the courts and the government have decided that these safeguards are far too restrictive. How did we get here today? Barely had the ink dried on C-14 before proponents of expanded assisted dying launched their campaign to eliminate necessary safeguards. As a conservative who strongly believes in the sanctity of human life, Bill C-14 was a difficult pill to swallow, but it was one that I believed upheld many of the values that I hold and the values that many of my constituents hold. The previous legislation recognized that we must tread carefully with this new reality of assisted dying. It introduced safeguards that limited mature minors, those exclusively with mental illnesses, and those whose deaths were not reasonably foreseeable. And I believe that this is where the majority of Canadians are at. And I believe that the government largely got the balance right under C-14. Unfortunately, there are a radical, vocal few who want to undermine even these protections and push this country headlong into a permissive regime for assisted dying. A regime which we know from international experience has resulted in the deaths of vulnerable people. If we continue to go down this road and liberalize all safeguards, we will continue to see mistakes and deliberate actions that end the lives of vulnerable people. This new legislation outlined in C7, although not taking these large radicalist steps that I outlined, is opening the door to a wider radical departure from principles like the protection of the vulnerable and the sanctity of human life. And I am particularly concerned about the inclusion of the term and policy of advanced consent. The Supreme Court of Canada was very clear, crystal clear, that an assisted death should only be administered with the consent of a person at the time of their death. We know that there are some cases where people fear losing their capacity to end their lives. However, we cannot allow the precedent of advanced consent to gain legitimacy in our system. Advanced consent in this legislation, I believe, is a Trojan horse designed to build the legal case to accept the adoption of advanced directives. Now, advanced directives are a concept where people can direct the action of medical professionals after they have ceased to have the capacity to consent to an assisted death. Many Canadians are familiar with the practices of DNRs, do not resuscitate orders. DNRs are a completely ethical and morally acceptable practice, whereby a patient can designate that no action should be taken to attempt resuscitation. By respecting the will of the patient and not acting, medical professionals are allowing the patient to die a natural death. Medical professionals can also hasten the natural death of their patient through pain remediation. I believe this is also an acceptable practice. I support do not resuscitate orders, and I think many Canadians are being deliberately misled into believing that an advanced directive is the moral and ethical equivalency of a DNR. It is not. An advanced directive does not ask medical professionals to withhold action allowing a natural death. It requires medical professionals to take direct action to immediately end the life of a patient. This is a leap in practice that goes far beyond what I believe is ethical. It undermines one of the greatest medical principles: first, do no harm. I can imagine in a not so distant future, someone with dementia or Alzheimer's who had previously written an advanced directive, believing that their lives would not be worth living with these diseases. Imagine in the future that we had the medical expertise and the breakthrough pharmaceuticals that could make life better for those suffering. How can someone consent to have their life ended without contemporaneous consent at the time of death when they cannot know what their quality of life will be? It introduces a high level of subjectivity to the question about what kind of life is a life worth living. This is a dangerous question that will lead us down a lethal road, a road that I don't think anyone wants to go down today. And I believe it is unethical and dangerous to allow someone's life to be ended by an advanced directive or consent, even with the meager protections offered in C7, which include a provision that no resistance be shown. There is still a threat of abuse. If someone is unable to understand and consent to a death, how are they supposed to know to resist when someone comes to administer to death? Parliament is being rushed into liberalizing a practice that is not even half a decade old. We lack the experience, the data, and the moral understanding to press forward with such a life and death issue. I am disappointed that the government abdicated its responsibility to stand up for vulnerable people when it chose not even to appeal the Quebec court's decision to the Supreme Court of Canada. What better court to clarify what safeguards are acceptable than the very court that originally dealt with these significant matters? Instead, the government has given Parliament little time to contemplate such an important issue. Canadians are still catching up to the reality of assisted dying being legal in this country, and now we are foolishly pressing forward before we can fully understand the impacts of this legalization.
Questions and comments. The Honourable Member for Scarborough-Guildwood.
that one.
Thank you, Mr. Speaker, and I thank the honourable member for his thoughtful speech and well-informed speech. And I wanted to ask him, since he has obviously informed himself over the last number of years about the various forms of medically assisted dying, whether there has been any statistical pattern developed over the time that it's been a legal concept. You know, do we know what the numbers are? Do we know where the weaknesses and strengths are? Is there material that he could share with the House that gives us some pattern of who's asking and what's being asked for and when it's being asked?
Member for Sturgeon River Parkland.
I thank the member for his question. I believe that many of the cases that we've seen where people have requested a medical assistance in dying are cases that the majority of Canadians can sympathize with and can even support. And what I'm not saying here today is that we should be repealing all the laws on medical assistance in dying, but I am saying we must be very cautious going forward. I have read some statistical information regarding the socioeconomic status of those seeking an assisted death. They tend to be in the wealthier range, and I believe the numbers are in the 6,000 people, slightly higher than the 6,000 people range on the number of people who have sought out an assisted death.
Questions and comments. Question commentaire. L'honorable député de...
The honourable member for Shefford. Thank you, Mr. Speaker. I want to thank my colleague for his speech, but I'd like to hear him talk about the fact that he used the word euthanasia when, in fact, there's a difference between euthanasia and medical aid in dying, and, of course, euthanasia is not actually dealt with in this bill. I'm also convinced that we can improve palliative care and have that as part of a series of options available, which would include medical aid in dying, of course.
I thank the member for their question, and I must say, you know, when the Conservatives were coming up with their minority report in the previous Parliament, the experience of Quebec weighed heavily on where we came in this. And the Quebec experience, it took 6 years in multiple legislatures in Quebec to come up with a law on this matter. And when they came up with this law, it was stringent. There were strong protections for the vulnerable peoples. And when we're talking about cases where somebody is unable to consent to a death, I believe that does meet the definition of euthanasia. An assisted death is a case where somebody is participating with it up until the point that they actually, their life is ended. But in the case when we're talking about somebody who can't consent to an assisted death, I believe that meets the definition of euthanasia, Mr. Speaker.
Questions and comments. The honourable member for Saanich Gulf Islands.
Mr. Speaker, and I'm afraid I disagree with the general tone of the approach taken by the honourable member in that these changes are much needed to respond to not only court decisions but analysis of what we have as charter rights to ensure that we don't have Canadians taking their own lives or finding the opportunity for medical assistance in dying prematurely out of fear that they will be unable to give consent under the strictures of our current legislation. And I'd ask the honourable member, for those in the Conservative benches who think this is being rushed, how they would suggest we deal with the fact that the courts in Quebec have ruled in Truchon that the law as it currently exists will be suspended March 11th.
For Sturgeon River Parkland.
I thank the member for their question. And the thing about the timing that I was very disappointed about is that this decision came out on September 11th, the day that the last election was called. And the government was given 1 month to appeal this decision in the middle of an election campaign. And I don't believe that it gave Parliament an ample opportunity to review the bill outside of a very politically charged period to say maybe that this decision should have been appealed to the Supreme Court, which was the court that created legalized assisted dying in this country. I believe that the Supreme Court has something to say on this matter, and that we failed by not getting the Supreme Court to weigh in on it.
Resuming debate, the honourable member for Don Valley East.
Thank you, Mr. Speaker. Mr. Speaker, I am pleased to rise today in support of Bill C7,
which proposes amendments to the Criminal Code's medical assistance in dying regime in response to the Superior Court of Quebec's Trochon decision. The context for the change. As we know, in September 2019, the Superior Court of Quebec struck down the federal and Quebec criteria which limits the access to MAID based on circumstances where death is reasonably foreseeable. The court, whose ruling only applies in Quebec, suspended its declaration of invalidity for 6 months until March 11, 2020. On February 17th, the Attorney General of Canada filed a motion to request a 4-month extension to give Parliament the time needed to implement a response and to ensure the law across the country is consistent as it relates to the federal MAID regime. So a brief overview to the amendments to the Criminal Code that is being proposed under Bill C-7. Firstly, on the eligibility criteria, the bill would repeal the reasonably foreseeable natural death criteria and exclude persons whose sole underlying medical condition is a mental illness. Secondly, with regards to safeguards, the bill would create 2 sets of safeguards depending on whether a person's death is reasonably foreseeable, while easing some existing safeguards and adding new ones for persons whose death is not reasonably foreseeable. Finally, the bill proposes to allow for waiver of final consent on the day of the procedure in specific circumstances. So how did these changes materialize? The development of this legislation was informed by 1, the Trochon decision, 2, available Canadian and international reports, such as the December 2018 report of the Council of Canadian Academies, and 3, the experience of existing international regimes, and 4, our government's recent consultation on MAID held in January and early February. The Minister of Justice, the Minister of Health, and the Minister of Employment, Workforce Development and Disability Inclusion, along with their parliamentary secretaries, hosted several federal MAID roundtables across the country. These events were attended by experts and stakeholders, including doctors, nurse practitioners, representatives from health regulatory bodies, legal experts, representatives of the disability community, Indigenous representatives, and other key stakeholders. They shared their experience and insight into MAID and its implementation in Canada over the last 4 years. In parallel to these efforts, our government heard from over 300,000 Canadians who participated in the online public survey on MAID between January 23rd and 27, 2020. An unprecedented number of respondents reflecting the significance of this issue for Canadians. This kind of input is invaluable to government, and I'm certain was seriously considered by the ministers in the development of this bill. I would like to provide a personal perspective on the issue of MAID in its previous iteration. In 2015, when the Liberal government came to power, it was tasked by the Supreme Court to amend MAID. A special joint committee was established involving both houses and all parties. The special joint committee conducted an enormous amount of consultation and came up with a proposal. The then Ministers of Justice and Health were presented with this proposal. Through intense discussions and consultations, the proposal was amended. In my riding of Don Valley East, I did a consultation in the sanctuary of the Don Way United Church. Various constituents, as well as other members from across Toronto, participated in the town hall. Members of CARP, the Canadian Association of Retired Persons, were also on the panel. Mr. Speaker, it was an emotional meeting. I clearly remember one of my constituents who was nonverbal and had to use her communication board, telling me that she wanted advance directives while she was lucid, but could not predict whether she would be lucid in the foreseeable future. In 2019, I had to do another presentation at a church in another riding. Here, overwhelmingly, the audience was against the phrase foreseeable future. and as well wanted advance directives. I'm glad to see that some of the changes requested through consultations have now been incorporated. I look forward to the 5-year review that is scheduled for June 2020 to see the discussions around advance directives. Coming to the bill itself and some of the changes it proposes to the eligibility criteria. With regards to the proposed criminal code amendments in relation to eligibility, the bill proposes to make 2 changes to the current set of eligibility criteria for MAID. First, it would repeal the reasonably foreseeability of natural death criteria from the list of eligibility criteria in response to the Turcon ruling. And that is good news for some of my constituents in Don Valley East. The legal effects of this amendment would be that those whose natural death is reasonably foreseeable and those whose natural death is not reasonably foreseeable would be eligible for MAID if they met all other eligible criteria. Second, the bill proposes to exclude people whose sole underlying medical condition is mental illness. Many practitioners, stakeholders, and experts have identified increased complexities regarding individuals whose sole underlying condition is mental illness seeking MAID. And I would suggest that this could be an item for Parliament to look at in its upcoming mandatory 5-year review of MAID regime. The Council of Canadian Academies Experts Group issued a report in 2018 on the same issue and could not come to a consensus on this question. The government of Quebec has also announced that access to MAID for cases where mental illness is the sole underlying condition would be suspended and that a broad consultation process would be conducted on this issue. With regards to safeguards, the public needs to know what are some of the safeguards that will protect the vulnerable. With respect to the applicable safeguards the proposed criminal code amendment would create 2 different sets of safeguards depending on whether the person's natural death is expected in the near term or not. The first set of safeguards would continue to be tailored to persons who have a reasonably foreseeable death where risks are reduced. The second set of safeguards would be tailored to persons whose death is not reasonably foreseeable and would address the elevated risks associated with the diverse source of suffering and vulnerability that could lead a person who is not nearing death to seek access to MAID, such as loneliness, isolation, lack of adequate supports, and hopelessness. Bill C-7 proposes to use the reasonably foreseeable of natural death standard to determine which set of safeguards apply to a particular case. This standard would also determine whether a person who is assessed and approved for MAID but who risks dying before the day of the procedure can give consent in advance. I'll be discussing that proposal shortly. So how will these safeguards be applied? Specifically, it would require that a MAID request be witnessed by 1 independent witness instead of 2, and it would allow individuals who are paid to provide either health or personal care to act as an independent witness. Madam Speaker, in essence of time, on the advance consent or directives, the bill proposes to amendments that would allow people who have reasonably foreseeable natural death and who have been assessed and approved for MAID to retain their ability to receive MAID if they lose the capacity to consent. Madam Speaker, this bill represents a significant paradigm shift in Canada's legal landscape with regards to medical assistance in dying, and I call on these members to support this important piece of legislation and send it to committee for further review. Thank you, Madam Speaker.
Questions and comments? The honourable member for Cloverdale and Langley City.
Yes, Madam Speaker. The honourable member from the opposite side there has gone on in length in regards to safeguards. And I would put to you that There are currently safeguard infractions going on across Canada without corresponding professional discipline being in place. So we can go on and on about safeguards, but if the current ones we have don't work, why would we put in more or less? I mean, they're not working. Let me point you out to a case of Mr. Roger Foley, who he has had to open a GoFundMe in order to pay for his legal bills so that he can get actual home care. And he says, I'm the young man who died of cerebral ataxia, and he's suffering, and the government is keeping him away from proper care. He's been dehumanized, threatened, attacked, and abused, and my life is completely devalued just because I'm a person with disabilities. Greater value is placed on access to MAID than access to alternatives that could alleviate a patient's intolerable suffering. MAID is being presented to patients as a preferred treatment option rather than the very last resort once all other avenues have been exhausted. Could the member opposite tell me how that's happening?
The member for Don Valley East.
Madam Chair, I sympathize with the situation that the member opposite has brought to light. But I also need to advise her that the provincial jurisdiction controls the health care budget. And we are doing things that are legally available because of certain issues that have been raised by the previous iteration of MAID. And we have, as parliamentarians, respond to it from a legal perspective. There are checks and balances in place, and people break the law like they break many laws. And I think there is a judiciary process, or there is a process within the healthcare practitioners that should be addressed.
Questions and comments? Questions et commentaires? The member for Saanich Gulf Islands.
Speaker, and I thank my honourable colleague. In studying this bill, and I certainly plan to support it and consider amendments when it gets to committee. But one of the things I'm wondering is if when you make that consent, and it's an advanced consent and there are safeguards, whether the personal practitioner who has accepted that consent must be the person who administers the procedure later. What if something happens to that particular individual and they're not available, or they themselves have died? How would we handle the loss of those who are present at the advanced consent at the moment when the medical assistance in dying procedure is determined to be appropriate?
The member for Don Valley East.
Madam Speaker, it's a very good question that the honourable member raises, and I think that is why this bill must go to committee for thorough discussion so that we ask the right questions, we get the right answers, and would put checks and balances in place to address the situation that she has brought to light.
Questions and comments? The honourable member for Calgary Rocky Ridge. Sorry.
Thank you, Madam Speaker, and to the member for Don Valley East. The present bill goes significantly beyond the immediate task of addressing the Quebec Superior Court's decision, and there was a scheduled review, broader review of the bill that was built into Bill C-14. The 5-year period was deliberate. It was made to. It was thought that would be at the time by the government to be an appropriate length of time to study the implementation of C-14. Why not just deal with the business of the problematic foreseeability of death, the words from C-14, which I had thought problematic from the start, but why taking this time to add the other portions rather than as part of an otherwise review that would have otherwise taken place next year?
Answer from the member from Don Valley East.
As I look at the bill, the foreseeable future, the foreseeable death was a very problematic issue for all my constituents. The advanced directives is something that they wanted, but that was not there. When the Supreme Court gave its decision, it actually created a base. When the Special Joint Committee created a report, that was the ceiling. And I think we have to find a midway balance to ensure that we protect the vulnerable, but also allow those that are seeking assistance to get the assistance they need.
Resuming debate, the honourable member for Lethbridge.
Madam Speaker, during this debate time, we have an opportunity as legislators to ensure that we carefully and thoughtfully examine Bill C-7, which is the piece of legislation before this House. And as we do, we must have the best interest of Canadians in mind. On September 11th, 2019, the Superior Court of Quebec found that it was unconstitutional to limit access to medical assistance in dying to people nearing the end of life. Although the current bill before the House, C-7, is responding to this court's ruling, it goes far beyond the scope of Quebec's decision, and it weakens the important safeguards that have been put in place under Bill C-14. Since the Liberals put this legislation forward, I have heard from hundreds of my constituents who have written to me in just a matter of days, and they've shared with me that they are very concerned about this bill. So I will use my time today to share a number of the concerns they are raising and to issue a thoughtful word of caution to this place. First, there is a parliamentary review of the original legislation scheduled for June. So the question has to be asked, why are we rushing? Why are we rushing to expand the scope of the current legislation? We are literally discussing life and death issues. Life and death. Death, something so final, deserves just a little bit of our time and our attention, and I dare say, due diligence. The government's original legislation went through a very lengthy consultation process. This time, however, the consultation only lasted a couple of weeks. But that's not the sole concern that I have. In addition to that, when I look at this survey, the questions that were asked were quite vague, and the multiple choice answers that were provided were drafted in such a way that the party in power could interpret those answers to secure findings that they desired. So it was unclear. And therefore unhelpful if we really are going to respect the voices of Canadians. But Madam Speaker, I think the fact that the survey was so unhelpful actually goes to show that the current government wasn't interested in hearing from Canadians. The current government was interested in pushing through their agenda and therefore being able to twist and manipulate the survey data to their end, which is wrong. It's wrong. It's absolutely wrong. It is wrong because it goes against the very essence of this place, which is 338 common people representing common people. This place exists for us to deliberate the issues that matter most in our country and to speak up on behalf of Canadians. Unfortunately, what we have before us is a bill that represents the Liberal agenda rather than the voices of the Canadian people, and this is wrong. With legislation of this magnitude, I would urge the members of this House to slow the process down, to consult extensively, and for us to come back to the table. I can't think of another responsibility that we carry as legislators that is more crucial, more obligatory than our duty to protect the most vulnerable in Canadian society. Therefore, we have to take every effort to alleviate any possibility for abuse or misuse based on what is in this bill or based on what is left out of this legislation. My Conservative colleagues have raised many concerns and have given multiple examples where extreme liberties have been taken with physician-assisted suicide, where there are looser restrictions in place. I don't wish to rehash all of those examples here today, but I certainly will draw the House's attention to a few. Sadly, members across the floor have disregarded many of those examples that have been provided by my Conservative colleagues. They've suggested that the differing jurisdictions and rules should deem these cases irrelevant in this place. But I would suggest that we actually have the opportunity and even the duty to learn from other countries and the way that they have legislated, to learn from cases right here within our own country, and to make changes that are necessary to properly protect the Canadian people. It is undeniable that one's medical condition progresses and they inevitably become more vulnerable. And it is our responsibility to stand up for the vulnerable. Individuals could lose their ability to speak, to move autonomously, or they could lack the coherence and cognitive ability to be able to interact correctly. When an individual reaches this state, this is precisely when the safeguards around MAID, medical assistance in dying, should be strong enough to keep them safe rather than weak enough to make them vulnerable. The proposed change in this bill allows for advance directive, which takes away the need for the patient to consent immediately before having medical assistance in dying administered. Now, this proposed change is alarming and I believe dangerous as well to the Canadian public. As we know, when we are faced with difficult physical ailments, they often fluctuate in intensity. And as they do, our decision-making ability shifts. Think, for example, about someone who is suffering from terminal cancer. They have been advised by medical professionals that their quality of life is likely to deteriorate to a certain degree by a specific date. But let's say that doesn't happen. So that cancer patient, wanting to avoid unnecessary pain, has already given the date on which their life will be terminated, but changes take place. What if the diagnosis the doctor gave wasn't right? What if that patient actually has fared much better? The healthcare professional could in fact euthanize this individual at any point without needing to obtain consent immediately before death is administered. Madam Speaker, this should concern all of us because of the vulnerability that is in place here. There should be a requirement for contemporaneous consent because we cannot allow one's former self to dictate the will of their future self. Minds change, circumstances change, and so final consent is an absolute necessity. This example has been raised in this House, I believe at least once before, but I believe it's worth raising again because it's close to home. Taylor Hyatt was a staffer here on the Hill. I had the opportunity to interact with her personally. She has a linguistics degree from Carleton University and she lives on her own. She loves her life. She has cerebral palsy and she is restricted to a wheelchair. She lives an incredible life and contributes to Canadian society in a multitude of ways. 2 years ago, she went to the hospital because she was feeling quite ill, and the doctors did some tests and they said that whatever it was, it really was affecting her breathing. And they wondered if it came to it, if they should administer oxygen. Now, in saying this, Taylor was quite surprised at the question. Of course she would want oxygen. That seems like a very basic thing. It's not that it was life support or something that, people often take those sorts of decisions at that level or that magnitude quite seriously. But it was a simple administration of oxygen. And so Taylor was surprised by this question. A few seconds later, the doctor asked her, well, are you sure? Are you sure? And in such a way that he was actually applying pressure to her to reconsider her decision, as if to say that her life lacked the value that she felt it had. Madam Speaker, that is atrocious. If we are sending that message to the most vulnerable in our society, then what have we become? But Madam Speaker, in closing, I would like to also address one other thing, and that is the need for palliative care. If we're going to talk about administering death to Canadians, then why are we not having the conversation around long-term care? If we are going to talk about the dignity of a human life, then what about those who want to live a dignified life right up until the moment of their last breath? Why is this government not moving forward with the plan that they promised to put in place with regards to palliative care? Why are they not spending the money that needs to be spent on preserving the dignity of those who wish to choose this type of death? Madam Speaker, these are essential questions that this House must wrestle with. And I would caution those within this place to take a step back, because we want a country to be one that supports all people.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Thank you, Madam Speaker, and I thank the member opposite for her contributions. And I clarify on a couple of points, and then I will ask her a question. First point she raised was looking at other jurisdictions. We've done exactly that and evaluated this regime against every jurisdiction that permits medical assistance in dying. And with respect to the point she made in her comments that changes have been made that were not needed by Truchon, this is both a less restrictive regime and also a more restrictive regime, depending on whether a person's prospect of death is reasonably foreseeable or not. So in the context of where there are increased procedural safeguards, it is when someone is not nearing their death imminently. There is a 90-day assessment period and also a period in which an expert doctor must be involved. But what I would put to the member opposite in terms of my question is that she takes considerable concern with respect to the advanced consent regime and the Audrey Parker Amendment, as it is colloquially known. I put it to her, is she willing to address the fact that failing to amend this legislation and address the circumstances of Audrey Parker actually leads to premature deaths, such as Audrey Parker's herself, which is a violation of Section 7, according to the jurisprudence?
The member for Lethbridge.
Madam Speaker, I once again would caution this House. If we're going to talk about advanced consent, that is one thing. But if we're going to remove the need to give final consent upon the issuance of death, that is another thing. We are talking about an individual who is going to have their life ended. That is very final, very final. It might be good for the medical practitioner to ask the question as to whether or not that patient is sure that that is indeed what they want in that moment. Madam Speaker, this is common sense. I actually take offense at the member opposite's question, because it is an incredible degradation of human life.
Questions and comments. The honourable member for l'honorable député de Shefford.
I'd like to thank my colleague for her question. And end of life is difficult, despite assistance. But for a minority of people, palliative care simply doesn't help to deal with their situation. So there is an additional option under this legislation for whom palliative care is unsatisfactory and who would prepare to die. And I'd like to hear my colleagues' comments on that.
Bridge.
Before this House is a piece of legislation having to do with medical assistance in dying. This has been discussed for the last 4.5 years. Of course, there was legislation put in place, C-14, in 2016, and that legislation allowed for medical assistance in dying in Canada. That's covered. My question is, where are the millions of dollars that were promised for palliative care? Because this country, to the honourable member's point, exists on this precedence that there is choice. So if they have the choice for euthanasia, then where is their choice to live until their last breath in a place where they are cared for and where they are pain-free? That is called palliative care. And this government has failed to deliver on that. And in doing so, has actually forced a number of people to choose euthanasia when they would not normally choose that. But because their pain levels are so high, and because palliative care is not offered, they choose death. That's wrong.
We have time for a brief question. The honourable member for Esquimalt-Saanich-Sooke.
Thank you very much, Madam Speaker. I listened to the member from Lethbridge's speech with great interest, and I respect her very strong feelings on this. But when she talks about the government making changes that weren't demanded by the courts, I'd like to point out that there are lots of Canadian families who are dealing with issues of intolerable suffering at the end of life who are asking for changes like Audrey's amendment. They're asking for them right now. As I mentioned earlier, because this debate is going on today, I've had someone I know quite well contact me and say they wish this bill would move quickly because it would assist them in making a choice and maintaining their control of the end of their life because they are facing intolerable suffering, which cannot be alleviated. So while I agree with the member that we need more palliative care and better palliative care, we're really dealing with a demand from individuals and families to make sure we avoid unnecessary suffering at the end of life.
A brief answer from the member for Lethbridge.
Madam Speaker, sorry, that was more of a statement than a question. I think the honourable member and I would agree in the sense that, yes, absolutely, palliative care is necessary. It should be an option for all Canadians, and that would be the most respectful thing to do for the Canadian population.
Resuming debate, the honourable member for Saanich Gulf Islands.
Thank you, Madam Speaker. It's an honor for me to speak today on a bill on medical assistance in dying. It is the second time in a second parliament that I have the opportunity to debate such a bill, and I also debated amendments. It's a very difficult bill, but it's an essential one.
A major improvement and reflects some of the amendments that I did make, but which failed in the House in the 42nd Parliament. Some of those amendments, in fact, were picked up and approved by the Senate. I want to stop and go back and reflect on the trajectory of this issue in Canada. As identified when I rose in my place, I am the Member of Parliament for Saanich Gulf Islands. And I believe that Saanich Gulf Islands may have more constituents concerned with and calling for medical assistance in dying than perhaps any other riding in Canada. There are two active death with dignity groups within my community, one on Salt Spring Island, one on the Saanich Peninsula. And I think it's for a very simple reason, that feelings run high, and my constituents, honestly, Madam Speaker, my constituents persuaded me in 2011 and 2012 that I had to stand up for ensuring that there was access to medical assistance in dying and removing the criminal code punishments for people who assisted, motivated by compassion and basic human dignity, to assist someone who is dealing with unbearable suffering in their last days and weeks. The reason that my community is so very, very implicated in this issue is that Sue Rodriguez was a resident of North Saanich and she was unable to take her own life due to the effects of ALS. She was able to find a doctor who remains anonymous to this day, who assisted her to end her own life. C'est clair que dans ma circonscription.
It's clear that in my riding there is a lot of support for the measures contained in the former bill, C-14, and now in this one, in C-7, because people are dealing with huge suffering, and we want to alleviate the suffering by providing medical assistance in dying. It is unfair if people must suffer. It's a human issue. It's very difficult, but so important.
Yes, she went to court, so it's also a trajectory of court cases. The Supreme Court of Canada ruled in 1993 against Sue Rodriguez. She was suffering from ALS. ALS runs a thread through what I want to talk about today. And she was losing ability and had lost ability to speak, to swallow, to walk. And we know the trajectory of ALS. And she asked the court to change the law, and she was unsuccessful. That was in 1993. She died. By the way, it was a very close decision. It was 5-4, very close decision. But she died a year later on February 12th, 1994. So then we take it to 22 years later. That's how slowly the laws evolve. It takes a while. The Supreme Court of Canada, the laws of Canada evolve to meet the changing circumstances. I think part of the reason is we also realize now, unlike 20, 30, 40, 50 years ago, that we can prolong lives and prolong sufferings through miracle advancements in medical science. But we have been denying people, before we passed this law in the 42nd Parliament, we were denying people death with dignity and the ability to control their own decision-making about the timing of their own death. So along came the Carter decision, finally, in 2015. 22 years after the Supreme Court of Canada decision in Rodriguez, we had the decision in Carter. And I felt very strongly when we debated the bill for medical assistance in dying in this place in the last Parliament, the 42nd Parliament, that our legislative efforts fell far short of what the Supreme Court of Canada ruled in Carter. I felt quite sure, and said many times in this place, that the legislation we were passing, while an improvement, would not stand up to legal scrutiny and would be ruled unconstitutional by the courts. So now we have the decision that came out last September in Truchon, and again, a court has given us a deadline to come up with an improvement. It's being called Audrey's Amendment, and certainly a lot of people have identified with that situation, and their hearts have been broken by knowing that medical assistance in dying was out of the reach of people who were suffering gravely, but feared that they would not be able to form the required consent on the day of the procedure. I think this bill is a substantial improvement, and it really reflects on how courts grapple with this, how society grapples with this. And I have to say, in the 42nd Parliament, I found the debate remarkably respectful. Across all parties, we recognize that these are serious matters of life and death, not to be trifled with and not to be turned into partisan debate. But the reality is, in this legislation, we do make amends for some mistakes in the previous bill. I find it always rather odd that the term, we have to find that a person's natural death is reasonably foreseeable. I don't think any of us in this place fancy ourselves immortal. All of our deaths are entirely foreseeable. We just don't know exactly the time and place in which it will occur. But someone who's suffering from terminal illness, their doctors weren't even able to say, well, if it's reasonably foreseeable, to what date? What does it mean to be reasonably foreseeable? We put people in a stricture where even if they knew they had a terminal illness, such as ALS, they couldn't necessarily get aid from this legislation, and they couldn't necessarily give advance consent to a doctor to be able to say, I don't want to be going through what I know lies ahead of me. One of my best friends emailed earlier today to ask me to stand up and fight this bill because she's dying with ALS and she did not think the bill would cover her. And I spoke to the Minister of Justice to confirm that I was reading this bill correctly and that, yes, they were thinking specifically of people with ALS. You know, a friend who used to sit in that chair, Mauriel Belanger, was lost to us so quickly through ALS. My friend, who's losing the ability of speech, is in a chair. She's got tubes in her stomach that cause enormous pain, and she knows her lungs will give out. So she's emailing me while we're having this debate. I was really relieved to talk to the Minister of Justice and realize that I am reading this bill correctly. My friend can get the help that's needed to be assessed and be able to say, I want consent in advance. I do think there are some areas for amendments that should be made here, and I wish we had more time. I hope the court will give us the additional 4 months, but we don't know that. Some of the boogeymen that have been raised here today, I think are considered in this bill. I think we do have the requisite safeguards to keep people who are vulnerable safe. No one can give permission to medical assistance in dying other than the patient themselves. They still have to meet very tight criteria. They have to have a sworn witness. They have to have a doctor. And the bill also does provide that on the day of the procedure, if they want to indicate that they've changed their minds, They are completely allowed and, of course, have the right to indicate they've changed their minds through all sorts of gestures and words, but not through any involuntary gestures. I think it's drafted as well as it can be, but we'll continue to consider it in the amendments of clause by clause. The bill does continue to ensure that the death is reasonably foreseeable, and there may be some complications there in the language. I note concerns from Dr. Jocelyn Downey at Dalhousie University, who's one of Canada's leading experts in this field, and I want to hear her evidence. I hope she'll be a witness. I'm sure she will be. And Dr. Stephanie Green, from the president of the Canadian Association for MAID. We want to make sure we get the language right. But I just want to close with a thank you to the Minister of Justice, for the government, for following through and hearing the cries of Audrey from Halifax, that her death be not in vain. Thank you, Madam Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
I want to thank the honourable member from Sandwich Gulf Islands for her contributions today and every day in this chamber for so many years. She led us through a very eloquent sort of chronological history of the status of the jurisprudence from Sue Rodriguez through the Carter decision and now through the Truchon decision, and about this idea about Parliament sort of keeping up with the law and responding to the law. There's been some debate, and it's fair debate in this chamber over the last 2 days about, in some respects, we're attempting to exceed the Truchon decision by wading into this area of advanced directives and addressing what is now becoming known as the Audrey Parker Amendment. And I want to have her sense of the thoughts of trying to get in front of the courts, at least on this occasion, and whether that's a prudent step in this regard in terms of empowering and respecting the dignity of people who are in such precarious positions that they want to maintain some control over their final days.
The member for Sandwich Gulf Islands.
Thank you. I actually don't think we're getting ahead of the law. I think the advanced consent, the Audrey Parker Amendment within this legislation is exactly within the four corners of the decision in Carter. The question of when your rights as a human being under the Charter of Rights and Freedoms are impinged was directly in Carter related to having to foreshorten your own life because you knew you might not be able to consent later. So I would say we may be slightly ahead of a court decision striking this law, the current law down, but we're not getting ahead of the law. We're finally meeting it.
Questions and comments? The honourable member for Cloverdale Langley City.
Madam Speaker, the honourable member asked what is the trajectory of the issue of euthanasia in this country, and I thank her for asking. It's really important that we make a concise assessment. Where are we going with this legislation? It's clear that this bill is ensuring that our country prioritizes euthanasia access while allowing palliative care to take a back seat. As we know, a request for physician-assisted death cannot be truly voluntary if the option of proper palliative care is not available. Is the honourable member willing to admit that palliative care in this country is abysmal and dwindling more and more every day due to this government's desire to push euthanasia as a preferred treatment option?
The member for Sandwich Gulf Islands.
Well, to the honourable member for Cloverdale Langley City, not only am I not willing to admit it, I think the assertion is absurd. I think the assertion is offensive. Nobody in this place, regardless of party, would place euthanasia as a desired outcome over a full range of choices. Now, it doesn't require admitting anything. I asked the Minister of Health earlier in this place whether she would agree with me that our provisions of counseling, mental health services, and, of course, assistance in having access to the facilities that make palliative care so much desired and so much preferred for patients and families across Canada. The services are not adequate, but one cannot, and I would urge the honourable member to rethink this, one cannot allege that the lack of services in palliative care is due to anyone's desire to push death over adequate care. I think the very notion is outrageous.
Questions et commentaires. L'honorable.
Questions and comments. The honourable member. Rosemont La Petite Patrie, a brief question, please. Thank you, Madam Speaker. I find it fairly unbelievable that the official opposition is suggesting that the government wants to put euthanasia above palliative care. That's shocking. I have a concern with regard to the bill. For people who've been diagnosed with Alzheimer's versus physical degenerative diseases, Alzheimer's can can evolve over years. How does the member see that? Well, I hope my answer is brief, but I will try to respond in French. Thank you to my colleague for Rosemont Lapetite-Patrie for his question. I think these questions are so difficult. Therefore, I would like to wait for the review to address them. And that review will happen this legislation will be reviewed after 5 years. But I'm not sure how to answer the question. My own father is living with Alzheimer's. I don't know what he will choose to do if the option is there. So I'll think about it and get back to him.
Member for Carleton Trail Eagle Creek.
Thank you very much, Madam Speaker. Thank you so much for the opportunity to speak on Bill C-7, an act to amend the Criminal Code, Medical Assistance in Dying, which was introduced earlier this week and dramatically expands the existing euthanasia regime in Canada. This bill was introduced in response to a ruling made on September 11th, 2019, where the Superior Court of Quebec found, in Truchon versus Attorney General of Canada, that it was unconstitutional to limit access to medical assistance in dying to people nearing the end of life. I believe it is completely unacceptable that this government did not appeal the Truchon decision to the Supreme Court. Truchon struck down vital protections for vulnerable Canadians, protections that this Liberal government put in place less than 5 years ago. Appealing this decision would have allowed us to get certainty on the framework within which Parliament can legislate. The summary of the bill states the following. This bill amends the Criminal Code to, and I quote, among other things, repeal the provision that requires a person's natural death to be reasonably foreseeable in order for them to be eligible for medical assistance in dying. It excludes mental health as an eligible reason to receive assisted suicide, creates 2 sets of safeguards that must be respected before medical assistance in dying may be provided, which differ in application depending on whether death is reasonably foreseeable, and create an advance directive wherein a medical practitioner can proceed with assisted suicide without consent immediately before administering it, assuming all other criteria are met, and the patient enters into an arrangement in writing with a medical practitioner or nurse practitioner to cause their death on a specified day. And while these changes are significant, Madam Speaker, it's the other things where I will focus most of my attention. In responding to Bill C-14 in the last Parliament, and now to this bill, it has always been our priority on this side of the House to ensure that legislation permitting euthanasia and assisted suicide includes safeguards for the most vulnerable in our society, as well as for the conscience rights of physicians and allied health professionals. Of all the proposed changes, I am most concerned about the removal of the 10-day waiting period. This was not a change mandated by Truchon. Rather, it is a deliberate choice by this government to strike down one of the most important safeguards for vulnerable people facing uncertain medical prognosis. Nearly every one of us can think of someone in their lives, perhaps a friend, a grandparent, or even a spouse, who has received a serious diagnosis. The emotional impact of hearing that news can be overwhelming for both the patient and their families. It can cause depression, anxiety, and a great fear of the unknown. I'm sure many of us can also think of people we know who have received terminal diagnoses and went on to beat their illness and live for years afterwards. But with the safeguard of a 10-day waiting period gone, such stories may be fewer and farther between. without having to take the time to come to terms with their situation, to speak to their families, and to learn about treatment options from their doctors. Many people will make emotional decisions based out of fear. And as another amendment removes the need for 2 independent witnesses and allows healthcare workers to act as witnesses, they may not even hear another voice offering a different solution. By making these changes, Madam Chair, we diminish the extremely important role legislators play in contemplating all of the unintended outcomes and consequences and then protect against them. We know very well that the current euthanasia regime has serious problems, that it has been abused, and that it has been used as a tool of desperation after the failures of government. Sean Taggart suffered from an advanced case of ALS, which left him completely paralyzed, unable to speak, and reliant on a ventilator. Despite these challenges, Taggart fought to stay alive so he could watch his son, whom he spoke of in lengthy Facebook posts, grow up. Sean required 24-hour in-home medical assistance to stay alive. Initially, the healthcare system provided him only 15 hours, leaving Sean to somehow pay hundreds of dollars each day. Eventually, even that was too much for the health authority. Healthcare authorities told Sean that he would no longer receive funding for home care, leaving institutional care his only option. Institutionalization at a facility, hours away, separated from family, removed from the son he called his reason for living. Sean appealed, but to no avail. He was going to lose his home care. Mr. Taggart fought long and hard for the rights of persons with disabilities and their families. But in the end, he was driven by his desperate circumstances to believe that assisted suicide was his only option. He was, and I quote, worn out, in his own words. And so on August 6, 2019, he ended his life. I'm going to read from the statement his family posted at that time, and I quote, "We would ask on Sean's behalf that the government recognize the serious problems in its treatment of ALS patients and their families and find real solutions for those already suffering unimaginably. Real solutions, Madam Speaker, does not mean removing the safeguards for those who are the most vulnerable. It means providing true alternatives, be that palliative care, in-home care, or the unique care needed. It is not simply enough to put in legislation, as we find here in Section 241.2, 3.1g under safeguards, to ensure, and I'm quoting, that the person has been informed of the means available to relieve their suffering, including, where appropriate, counseling services, mental health and disability support services, community services, and palliative care, and has been offered consultations with relevant professionals who provide those services or care. Madam Speaker, if we have no intention of ensuring that those services are being funded or are even available, we have failed. I note that the current federal government broke a key election commitment to invest $3 billion in long-term care, including palliative care. Access to palliative care is an essential part of end-of-life decision-making. That point has been made over and over during this debate. No one should ever be put in a position where they believe death is the only solution available to them. We are and we must be better than that. Madam Speaker, we must protect every human life with a jealousy born of the knowledge that each person is unique and has an innate dignity that nothing, not time, not illness, not disability can ever take away. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
So one point of clarification and then one question for the honourable member. I thank her for her comments today. The point of clarification is that the contribution actually 2 budgets ago by this government into palliative care and long-term care was $6 billion, not $3 billion. The question is that there are safeguards. The member opposite mentioned a catastrophic event or a diagnosis that can be shocking to an individual. That's exactly what we've contemplated by creating a second track for people whose deaths are not imminent, people whose deaths are not reasonably foreseeable. What the legislation entrenches is a 90-day assessment period, a period of time when they must be informed of counseling, mental health supports, disability supports, community services, and palliative care, and then an agreement from the medical practitioner that the person has appropriately considered those options. Is that exactly the type of response that the member opposite feels is required to ensure people are not making this decision, which is a permanent decision, with undue haste?
The honourable member for Carlton Trail, Eagle Creek.
Well, Madam Speaker, I thank you and I thank my honourable colleague for the question. I would suggest that one of the safeguards that I feel should have been left in the legislation was the 10-day period of reflection. I think that was very important to leave in this legislation. As I mentioned in my remarks, it's been, I guess the observations have already been made that that could be waived, and I recognize that. But I think that any time that we can keep a safeguard in place that allows individuals that sober second thought, we should do that.
And comments, questions et commentaires. Honorable député.
The Honourable Member for Shefford. Thank you, Madam Speaker. I want to thank my colleague for her speech. I would remind her that medical assistance in dying is really an exceptional measure that has very restrictive terms, and it's very stringently managed by the law. So it's certainly, I don't think there's been an undue increase in cases of MAID. In Quebec, between 2015 and 2018, there were a total of 830 requests for MAID. And in fact, MAID wasn't even administered in that many cases because there may have been various administrative reasons that it wasn't approved. So certainly I don't think that anything is going to substantially increase the number of cases of MAID under C7.
For Carlton Trail, Eagle Creek.
Well, I thank you, Madam Speaker, and I thank my honourable colleague for her observations. I don't think that there was a question in there. She's made some observations about whether or not access to MAID has increased in her province. But I would say again, something that I stated in the remarks that I made, I really do believe that it is incumbent upon legislators who have been given the very important role of putting legislation in place to always take a look at the legislation, to understand, to try and address any unintended outcomes or consequences, and then to protect against them. So leaving safeguards in place that don't unduly create duress should be the route that we would choose to go. Thank you.
Question, the honourable member for Esquimalt-Saanich-Sooke.
Thank you very much, Madam Speaker. I want to ask the member about an unintended consequence, I think, of C14, and that's the situation where people are forced to choose to go early because they're afraid of losing competence at the last minute, something that this new bill addresses. So we have many examples across the country, and I have one very close example to me of a friend who wanted to see family and relatives, wanted to spend some time doing last things because she had a very serious brain tumor, but chose to go earlier because she feared losing competence. And I think that that's an unintended consequence of the current legislation, that people should be able to make that choice, then get an orderly end to their lives that's dignified. So doesn't she not see that as an unintended consequence?
The honourable member for Carlton Trail, Eagle Creek, a brief answer, please.
Thank you very much, Madam Speaker. I think what I would just speak to in response to that question is that, when Bill C-14 was introduced, in the previous Parliament, the decision was made not to include advance directives. I think that was purposeful, and I think had we been allowed to deal with the issues that Truchon identified and keep all of these other issues in mind for when the statutory review that is being contemplated, if we could have done that, I think that would have allowed us far more time to take a look at the legislation, see what was working, see what wasn't, and really have a timely and comprehensive study of C14. Thank you.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Health.
Thank you very much, Madam Speaker. Madam Speaker, medical assistance in dying or MAID is complex. It's a deeply personal and difficult topic. Yet this past January alone, more than 300,000 Canadians took part in the online public consultation to have their say. And many others, including experts and family members of loved ones who received MAID, took part in roundtable discussions. We also heard how the legislation is working from many of the conscientious healthcare providers involved in delivering this service. Canadians are engaged and aware of the importance of bringing the compassionate, sensible measures contained within Bill C-7, an act to amend the Criminal Code, medical assistance in dying. This bill builds on the foundation laid by the current legislation on MAID, passed by Parliament in June of 2016, and extends eligibility for MAID to persons who, while suffering intolerably, may not be at the end of life. This bill respects the Truchon decision and supports the autonomy of Canadians wanting to make an informed choice to end the suffering they face as a result of serious illness, regardless of whether their condition is life-threatening in the near term. Respecting the autonomy of Canadians while protecting the safety of vulnerable people remains our central objective. That's why Bill C-7 proposes a two-track approach to safeguards, based on whether or not a person's death is reasonably foreseeable. We've proposed to ease certain safeguards that had the unintended consequence of creating a barrier for some when accessing MAID, for those whose death is deemed reasonably foreseeable, and we will introduce new and modified safeguards for eligible persons whose death is not reasonably foreseeable. Bill C-7 would permit the waiving of final consent for persons at the end of life who have been already assessed and approved to receive MAID, but who are at risk of losing decision-making capacity before it can be provided. There was very strong support for this type of amendment from Canadians, experts, healthcare providers, and their professional regulating bodies. Our government recognizes the importance of data and science-based evidence in the decision-making process. That's why this bill proposes that we expand data collection through the federal monitoring regime to provide a more complete picture of MAID in Canada. I'd like to note following the Truchon decision, there has been widespread speculation about the potential for persons solely with mental illness to be eligible for MAID. However, many stakeholders in the mental health community have expressed deep concern about this possibility. They feel this option directly conflicts with an important treatment principle that there is always hope for recovery and that people can live fulfilling lives with a mental illness. From the perspective of many healthcare providers and many healthcare specialists, assessing eligibility for such individuals poses numerous challenges. Mental illnesses are not generally considered to be incurable, which is a requirement under the current law. In addition, the trajectory of such conditions can be more difficult to predict. In light of the multiple challenges we heard and the lack of support by the practitioner community who would bear the responsibility for conducting eligibility assessments, this bill does not permit MAID for persons whose sole medical condition is a mental illness. Now, Madam Speaker, this decision was not taken lightly and in no way implies that suffering associated with mental illness is any less severe or more tolerable than that associated with another medical condition, such as those arising from a physical condition. Rather, this decision reflects the many uncertainties underlying this question and a concern that allowing MAID in these circumstances could place Canadians at risk. We recognize that there are proponents who support MAID eligibility for persons solely with the mental illness. However, in light of the Quebec court decision and the compressed time frame for legislative amendments, there is insufficient time to fully address this topic and determine whether a regime that allows access to MAID for persons whose sole underlying condition is a mental illness is viable. For these reasons, we are adopting an incremental and cautious approach. It is our view that this issue should be explored as part of the parliamentary review process expected to begin later this year. Now, it's easy as parliamentarians and as legislators to lose the human element of what we do, to focus on talking points and politics. But these compassionate and sensible measures have come from extensive consultation with Canadians, experts, and from folks who have lived with the unintended consequences of the original legislation. Folks like the late Audrey Parker, a Nova Scotian who wanted to spend just one last Christmas with her family, but ended her life through MAID 2 months prior while she still could give consent. Madam Speaker, in conclusion, I want to take this time to read some of Audrey Parker's final post into the record so that it will be preserved in Hansard, because this legislation includes her amendment. And as my colleagues in this House debate, discuss, and study this bill, I want them to remember that there are many folks like Audrey across Canada who deserve this autonomy and this compassion. Madam Speaker, I quote, "This is my last note to you. I can tell you that I loved my life so much and I have no regrets. I feel like I'm leaving as my best self and I'm ready to see what happens when I die today. I'm hoping for something exciting to happen, but I guess I won't know until the time is here. The one thing I'm happiest about is that I finally found my people during my lifetime. I've even met new people that I already adore near the end of my journey, so it's never too late for anything in life. In the spirit of teaching and sharing, I'd like to leave you with some words that explain my position with MAID. When MPs debated MAID federally, someone decided to add late-stage consent as a fail-safe to ensure that no one dies at the hands of another. There are 4 categories of MAID candidates. Of the 4 categories, the only one that is cut and dried is my category of assessed and approved. We are terminal, suffering outrageous pain, and there is no time frame with using MAID. The kicker that makes it difficult is the late-stage consent. As I near my death today, it is even more evident that than ever before that late-stage consent has got to be amended and removed from MAID in Canada for my category of end users. Dying is a messy business. I can't predict when cancer will move into my brain or when something else big happens to make me more unwell. I and only I can make that decision for myself. It's about living out every extra day I can. No one, including my doctor, knows when the right day to die will be. Only I can know as I wake each day. I'm not going to wait until I lose myself. I wanted to make it to Christmas and New Year's Eve, my favorite time of the year, but I lost that opportunity. Because of a poorly thought out federal law Had late-stage consent been abolished, I simply would have taken my life one day at a time. If I noticed I was losing capacity, I would have taken control myself, called my doctor to come and assist me with my death. All I have to do is give 24 hours notice so she can pick up the drugs from the drugstore in my neighborhood. We were totally organized, but the law tied our hands. This decision has to come from the patient, no one else. That's why we, the dying, should be living day to day until we have to leave by invoking MAID. Be happy, everyone, and be kind to others. Audrey. Madam Speaker, I ask that all members in the House support Bill C-7. Thank you.
Hear, hear.
L'honorable député de
The honourable member for Louis Saint Laurent.
Very touched by the testimony of our colleague. I just want to raise because the member talked a lot about we shall support that. I do support that, that's fine. But I have some concern with the timeline. I've been part of the National Assembly for the first time a legislator in Canada adopt a bill about this issue. It took us 6 full years. I was part of the committee 4 years ago who worked to adopt the bill that the House of Commons adopted 4 years ago. It took us 6 full months. So I would like to know what is the thinking of the member about the fact that in that case, as far as I'm concerned, obviously, yes, there is some rush for some people, but does it think that we should take all the time necessary and make all the consultation necessary to achieve the best bill possible?
the Honourable Parliamentary Secretary.
Thank you, Madam Chair. I want to thank the member who has spoken passionately about this. I've heard you in the House 2014 and now, and I thank you for that. Someone in the House said that we should proceed with caution. And someone else said, a very smart man in this room said, we did that in 2015. Mm-hmm. And people suffered. Thank you.
Questions et commentaires? Questions and comments? The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. Thank my colleague for participating in this debate. Obviously, this debate engages all of our emotions and often from both sides. We've heard the testimony that the member has shared. I shared in my speech a story of a woman who had her life taken in very, frankly, sketchy circumstances. It was at a hospice in Vancouver where somebody came in and took that person's life and said it was based on a demand for euthanasia, and the testimony was based on her own notes, but there had been no consultation or awareness of the local staff. So we struggle with, I think, cases that evoke major concern that exist on all sides of this. And I hope that through the amending process, we may actually be able to find some common ground. One of the issues, the member spoke specifically about the issue of advanced consent. And I think we should have some mechanism in that advanced consent section to ensure that there is contemporaneous consultation with the patient. So we don't have a case, because there are other cases we know of where someone gave an advance directive and then had their life taken while they didn't want that to happen. So how can is there a way to meet in the middle and have a requirement for some kind of contemporaneous consent, even in the context of an advance directive?
The Honourable Parliamentary Secretary.
Thank you, Madam Speaker, and thank you to the Honourable Member for the question, and thank you for your speech earlier today as well. This is one of those things that's hugely complex and affects everybody differently. We all have different approaches and different beliefs in this room about how we should approach this. I don't know whether we can find common ground. I think we found common ground, or at least met in the mushy middle in 2015 and let people down. I salute the medical practitioners in this country who are assisting Canadians with end of life, whether it be palliative care or MAID. It's important that we see everyone's side to this and respect everyone's thoughts and beliefs. I have constituents who are on both sides of this. And I had a very bad joke that I used to use in 2015. We were talking about this. There's no yes or no. I said there's 50 shades of gray. And only a couple people chuckled at that joke, so nobody got it clearly in this room either. But it is one of those very complex issues that you don't fall on one side or the other. You could ask 100 people and have 100 different perspectives. Thank you.
Resuming debate, the honourable member for Northumberland, Peterborough South.
Thank you very much, and I'd like to thank the honourable member who preceded me for his very passionate remarks. And
Sorry, I forgot to remind the member that unfortunately I'll have to interrupt him at some point, and he'll be able to continue his speech at a later date. The honourable member.
I'm aware. I won't keep people here late. Thank you. And I think everyone in the speeches in the House, they all come from a great place, right? So on our side of the House, we value life, and I think that's meritorious. We've heard others' perspectives that talk about suffering and ending suffering, and truly that has merit, and so I appreciate all of the speeches that happen on such an important topic. I just want to go back, and I know this has been sort of gone over, but just for clarity, to go over the background to medical assisted suicide in Canada. The 2015 case of Carter was a landmark decision for the Supreme Court of Canada. The previous prohibition for assisted suicide was challenged as contrary to the Charter of Rights and Freedoms. In a unanimous decision, the court abolished the provision in the Criminal Code, thereby giving mentally competent Canadians who are suffering intolerably the right to medical assistance in dying where they have provided clear consent. In the June 2016, the first legislation of medical assistance dying was passed in Canada's Parliament. In the recent 2019 Truchon decision, the Superior Court of Quebec considered the constitutionality and Quebec's requirements in accessing MAID. The plaintiffs in the Truchon case were suffering from grave and incurable medical conditions, which was causing tremendous suffering and a total loss of autonomy. However, they had each been refused MAID underneath the legislation of Quebec and federally. Because they were not at the end of life for Quebec legislation and for federally, death was not reasonably foreseeable. Madam Justice Bourdon held that reasonably foreseeable natural death of the federal provisions infringed the plaintiff's fundamental rights, Section 7 and 15 of the Charter. The court declared the impugned provisions unconstitutional. In a surprising and, in my mind, an incorrect decision, the government chose not to challenge this decision, thereby getting guidance from the higher courts, such as the Supreme Court. The government, by not challenging this legislation, was admitting that the legislation that they passed, that this House passed, was deeply flawed. The court's decision in Truchon left the government until March of 2020, which of course is now in the process of being extended, to amend the legislation to remove reasonable foreseeability of death criteria from the MAID legislation. Prior to the introduction of this bill, the government conducted a narrow consultation process, limiting its consultations to urban centres and to online surveys. The minister noted several times in his address to the House that the provisions of Bill C-7 were the result of this process. However, he will not share that consultation with Parliament. This lack of respect is disheartening and counterproductive to open and meaningful dialogue. I wish the government would stop playing games with such important topics and share the information they have with this minority Parliament. Given the limited timeline that we are in a minority Parliament and the fact that MAID legislation will be subject to complete review this summer, I would have expected the government to take a limited approach. Rather, the government has chosen to take a very different approach. The legislation makes substantial changes to the eligibility MAID far and beyond what is required to the Truchon decision. Right there.
Interrupt the member as debate is over for today. The honourable member will have 6 minutes the next time that this matter is before the House. Alors, à ce moment.
Pursuant to Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn.
Park Fort, Saskatchewan.
Madam Speaker, this is a bit frustrating because I have asked the same question of the government so many times. And I hope that I will be clear enough as to give them no excuse this time hopefully that we will actually get some degree of an answer. The question I am going to ask is why the government did not list the IRGC, the Islamic Revolutionary Guard Corps in Iran, as a terrorist entity, and is it still the policy of the government to do so? Quick historical background on this. It was approaching 2 years ago that we passed in this House a motion to list the IRGC as a terrorist entity. That motion passed with the support of all members of the Conservative caucus and all members of the Liberal caucus, at least all of those who were present. That's right. And the Prime Minister and other leading ministers of public safety, of foreign affairs, etc., were part of that vote and voted in favor of listing the IRGC as a terrorist entity under the Criminal Code. In fact, the motion didn't just say to list the IRGC, it said to do so immediately. Immediately. And then we followed up. We followed up immediately, asking the government, okay, you voted for a motion, the House of Commons expressed its desire to list the IRGC as a terrorist entity under the Criminal Code. You said immediately, we said immediately, you agreed. So what are you going to do about it? And they said, okay, we're going to think about it, we're going to study it, the process is underway. And we understand that there's a process that might have been understandable a month, 2 months, 3 months after the fact. Sure. It's not really plausible approaching 2 years after the fact. 2 years. Surely, Madam Speaker, the listing process doesn't take that long. In fact, there have been cases where terrorist entities that have existed for less time have been managed to be listed in a much shorter period of time. Now, the typical response, and maybe the responses you'll hear from the government tonight, is they usually say, well, here's some other things that have been done on human rights related to Iran. They don't say this. All of those things are continuations of things that were done under the Harper government, but nonetheless, they'll point to those things. They'll say the IRGC Quds Force, which is part of the IRGC, is listed. Again, that was an action actually taken by the Harper government, not by this government. The IRGC is, the Quds Force is still listed as a terrorist entity. But the motion that passed 2 years ago, approaching, was not to list the Quds Force. At the time, the Quds Force was already listed. The motion was to list the IRGC in its entirety, and to do so immediately. That's right. So maybe tonight will be the night. Maybe we won't hear this smoke and mirrors, oh, it's still in process, it's still in process. It's going to be in process for another 50 years, it's still in process. Hopefully we won't hear this still in process nonsense. Hopefully they won't just remind us about the Quds Force, which is already listed and has been for a long time and is not the topic here. Hopefully they will answer the question. Is it still the policy of the government to list the IRGC? Is there a reason why the government didn't list the IRGC earlier? And why? What is their intention with regards to the listing of the IRGC? It should be a simple question. It has been asked over and over again in question period, in late shows. Hopefully now is the time. Is it still the policy of the government to list the IRGC? Why haven't they done it yet? Do they plan on doing it in the future? Thank you.
The Honourable Parliamentary Secretary to the House Leader.
Madam Speaker, our thoughts continue to be with the families of those who perished in the crash of the Ukrainian International Airlines Flight 752. The plane was carrying 176 people when it crashed, and all of those aboard were killed, including 57 Canadians. After initially denying its responsibility, Iran has since admitted that it unintentionally shot down the plane. As the Prime Minister has said, there will be much thought given to the potential consequences in the course of the coming weeks. For now, we are seeking full clarity on the circumstances that led to such a horrific tragedy. The downing of the Flight 752 has brought renewed focus on the Islamic Revolutionary Guard Corps, or IRGC. Canada continues to have in place a series of strong measures to hold both Iran and the IRGC accountable. In June 2019, Canada added 3 new Iran-backed groups to the list of Al-Ashtar Brigades, Harakat al-Sabriyan, and the Fatimiyan Division. Apologies for the mispronunciation, I must say, Madam Speaker. Iran provides these three groups with substantially resources, including training and weapons to carry out terrorist acts that advance its goals in the region. The Al-Ashar Brigades, or the AAB, aims to overthrow Bahrain's monarchy and targets Bahraini security forces primarily through the use of impoverished explosive devices. Canada is not alone in the designating AAB. In 2017, AAB was listed by the UK, and the US designated it as a foreign terrorist organization in 2018. Harakat al-Sabrinian, or HAS, is an Iranian-backed Shiite group that supports the destruction of Israel. HAS was founded and is led by former leader of the Palestinian Islamic Jihad, which is itself a listed entity in Canada. Members of the HAS fight against Israel alongside Hamas and Palestinian Islamic Jihad. The U.S. designated HAS in 2018. Finally, the Phatamonian Division of, or FD, is supported and trained by the Quds Force and Hezbollah. It serves as part of the Iran-backed forces fighting in Syria and has a presence in Afghanistan. FD is also known to have used Afghan children as child soldiers. In January 2019, the U.S. Treasury Department designated the FD for providing material support to Iran's Quds Force. Canada continues to list the IRGC-Quds Force and a number of terrorist entities who have benefited from the force patronage, including arms funding and parliamentary training, and who helped advance Iran's interest in and foreign policy. These include Hezbollah, Hamas, and the Palestinian Islamic Jihad and the Taliban. We have imposed sanctions on Iran and the IRGC, as well as senior members of its leadership under the Special Economic Measure Act. The regulations explicitly target the IRGC and several sub-organizations, including the IRGC, Air Force, and Air Force Missile Command. Iran also continues to be designated as state supporter of terrorism under Canada's State Immunity Act. You can be assured that Canada is looking at all possible options to constrain the activities of Iran that threaten national security. Thank you, Madam Speaker.
The honourable member for Sherwood Park, Fort Saskatchewan.
Well, Madam Speaker, that response clearly demonstrates how uninterested the government is in actually engaging in a serious response to a serious and important question about foreign affairs and national security. Rather than giving the opportunity for the Minister or the Parliamentary Secretary for Foreign Affairs or Public Safety to respond to the question, we have sort of the great fog readout of policy detail, which in no way engages with a very simple and clear question. And it's not as if the government didn't have advance notice of this, Madam Speaker. Members know that the way these late shows work is that the government knows a long time in advance that the question is going to be asked and exactly what the question is going to be. And again we ask the same question, Madam Speaker, and not only have they not bothered to answer, the Foreign Affairs and Public Safety team couldn't even be bothered to show up. Again, simple question. Why didn't the government list the IRGC as a terrorist entity? Do they still intend to list the IRGC? If the answer is no, just tell us no, but I think the House deserves an answer.
Hear, hear. The Honourable Parliamentary Secretary of the Government House Leader.
Speaker, this listing of regime is an important tool for countering terrorism in Canada and globally, and it is part of the government's commitment to keeping Canadians safe. Listing is just one component of the international and domestic response to terrorism. With that in mind, I would reiterate that Canada has already taken action against Iran and the IRGC, specifically including listing the IRGC Quds Force. These actions are broadly consistent with our international partners who have designated components of the IRGC under their own sanctioned regimes. This past June, we listed 3 militant groups that are aligned with and controlled by the Quds Force and the operating in Bahrain and the Gaza Strip, Syria, and Afghanistan. A listing imposes severe penalties for the people and organizations that deal with property or finances of a listed entity. Another important point is, of course, that once listed, an entity falls within the definition of a terrorist group in the criminal code. This helps facilitate the laying of terrorism-related charges against perpetrators and supporters of terrorism. Thank you, Madam Speaker.
The honourable member for Leeds, Grenville, Thousand Islands, Rideau Lakes.
Well, thank you very much, Madam Speaker. It's a pleasure to rise in this House. And I've said it before, and I'll say it again, that when I was appointed by the Leader of the official opposition as the Shadow Minister for Ethics, I told the Leader, and I've told folks who've asked, that I hope to be the most bored in the Shadow Cabinet, that I don't have any work to do. Regrettably, the government has demonstrated through their top-down model of disregard for the rules, not only of this place, but the rules writ large, that we seem to find ourselves constantly following up on the ethical violations of the Prime Minister, his cabinet members, and his backbenchers. Now, I had the opportunity to ask a question in the House a few weeks ago about former member Joe Pescasolido, who was found guilty of having broken the Conflict of Interest Code. Now, the code is laid out in such a way that it is very easy for us to follow. And the purpose of the code, as you know, Madam Speaker, is so that Canadians can continue to have confidence in their elected officials, have confidence in public institutions. And when we, as the finance minister did, forget to disclose that we have a French villa, for example, Canadians find that a bit incredible to believe. Now, Madam Speaker, I don't think that you and I, when we filled out our disclosures, that we paused too long on the French villa box there. You and I both know how many French villas we have, and as I'm sure did the Minister of Finance. Now, Mr. Pescasolido, in his case, he failed to disclose a host of things, a wide range of things, and I encourage interested Canadians to take a look at that, and I also encourage the government to do the same. The response I got from the government when I asked from the government House Leader was that that member's no longer a member of our caucus, and so we don't know how it has anything to do with us. Well, that speaks to the culture that exists in the government benches, Madam Speaker. That speaks to what we've seen with the Prime Minister twice found guilty of breaking the Conflict of Interest Act. Now, also in place to ensure that Canadians can have confidence in their executive, have confidence in the Prime Minister and his or her ministers. Now, whether it's the SNC Lavalin scandal, clam scam, forgotten French villas, we've seen this litany of ethical breaches with this government. And most recently, Madam Speaker, again on the subject of disclosures, these disclosures that we make to the Commissioner with regards to members' personal dealings, so that we can make sure that members aren't being unduly influenced financially in a pecuniary manner. The Prime Minister just didn't answer the questionnaire. He is required to do so. He didn't do it, and in response, when he was called out on that, it was an administrative oversight. Well, a week later, the Ethics Commissioner publishes who has failed to file their disclosures. Whose name appears again? The First Minister, Canada's Prime Minister. So my question is, when will this government start taking the confidence that Canadians have put in them seriously, and do they need any help on following those rules?
The Honourable Parliamentary Secretary of the Government House Leader.
Madam Speaker, here, let me allow me to provide an actual quote in terms of what it is that the Commissioner has stated. And I quote, "Where I conclude that the member has contravened the code and I find no mitigating circumstances, as was the case in this particular inquiry that the member actually referenced, I may recommend a sanction for the House to impose on the contravening member. However, in the present case, given that Mr. Pescasolido is no longer a member and therefore not subject to the rules governing members of the House of Commons, issuing such a recommendation would serve no purpose. Madam Speaker, I think that the government, at least the party, has been very, very consistent with our approach in regards to the conflict of interest and the Ethics Commissioner, where we recognize when mistakes are made. In fact, we follow and respect the advice and the recommendations that are provided, and we thank the Commissioner for the fine work that he does. But, you know, the problem that I had with the question that was posed by the member across the way is that he tries to come across as if, well, you know what, very sensitive here, I really didn't want to be kept busy and all this kind of stuff. I say balderdash, Madam Speaker. You know, so many days in which I've seen the official opposition, one of their primary objectives is character assassination, and they will go all out in terms of trying to identify an issue and then try to nail it and call it an ethical breach, and constantly, as if the Conservatives, the New Democrats, or any other political party has never ever done anything wrong, Madam Speaker. You know how careful members need to be when they throw stones in glass houses. In fact, you know, he cited the Minister of Finance. Oh my goodness, how he broke the code of ethics, and we respect in terms of what the Commissioner actually ruled on. But does the member know that the Minister of Finance did not intentionally do what it is that he's proposing that he did? Because in fact, that so-called French villa that he makes reference to was actually published shortly thereafter in a major newspaper here in Canada that the Minister of Finance had a house out in France. There was no trying to intentionally hide. Yes, sometimes mistakes happen. Members of Parliament on all sides of the House make mistakes. And the Commissioner does, in fact, investigate, Madam Speaker, and come up with recommendations. To try to give the illusion that there is only one political entity that makes mistakes inside this House, Madam Speaker, is a false impression. That in fact, there are mistakes that are made on all homes, on all sides of the House. And when a mistake is made, we need to recognize it. I think that we should take the corrective action, and that is in fact what we have seen with this particular government, Madam Speaker. So, you know, if you want to talk about proactive measures, I would remind the member of the proactive disclosure that we had taken back when we were in third party in this House, in terms of all members on their members' allowances, and we had to literally drag the Conservatives into supporting proactive disclosure. This Prime Minister and this government has actually taken the responsibility of being open, transparent, and accountable very seriously. And that's, I would ultimately argue, is something in which this government has been very good at, especially if you compare it to the Stephen Harper era, Madam Speaker, where you have seen that much more open government, that much more transparency and accountability, which was lacking when Stephen Harper was the Prime Minister.
I do want to remind members that I think that it's still pretty disrespectful to be heckling someone when they're speaking, even if it's during the late shows. All of the contributions that members make need to be heard, and everyone needs to have that respect to be heard and to be responded to. The honourable member for Leeds, Grenville, Thousand Islands, Rideau Lakes.
Well, thank you, Madam Speaker. Balderdash to that, hear, hear. Madam Speaker. I don't believe that character assassination is a correct term that can be used here, because that would imply that what I said was malicious and unjustified. It is fact. It is fact that the Prime Minister was twice found guilty of breaking the law. And when he did not apologize. I will never apologize for ... I mean, he said standing up for jobs, but we know that he didn't know what he was standing up for other than his own seat. So my offer, in good faith, through you, Madam Speaker, to the Parliamentary Secretary, is that I am happy to work with him to develop a curriculum for the Prime Minister, the ministers, and members of the government backbenches on how to properly follow the ethical guidelines that are in place. And is he interested in taking me up on that offer? Thank you, Madam Speaker.
Good idea. The Honourable Parliamentary Secretary.
Madam Speaker, I would welcome a participation or a nice sit-down discussion with the member in terms of just how important it is that we listen to and follow and look at ways in which we can even improve a system, not only for the commissioner, ethics commissioner. We can talk about our election officers. We can talk about our ombudsman's officers. You know, there's independent offices of Parliament that serve our Parliament exceptionally well, and I think that we should listen so that when they come out with reports that we respond and try to make our system work that much better. But I would acknowledge, Madam Speaker, that we need to take it in such a way in which we recognize that it's not just one member or one political entity that needs to learn things from reports. I would suggest to you that there are all political entities inside this chamber that would benefit, and maybe we can start having that dialogue over a cup of coffee, perhaps. Thank you, Madam Speaker.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, the House, this House stands adjourned until tomorrow at 10 a.m. pursuant to Standing Order 24-1.